Senators, I declare open this hearing of the Senate Legal and Constitutional Affairs Legislation Committee for the budget estimates. The Senate has referred to the committee the particulars of proposed expenditure of the 2022-23 for the portfolios of Home Affairs and the Attorney General and other related documents. These are budget estimates proceedings, and the outcomes to be heard during today's estimates are from the Attorney General's and Home Affairs portfolios. The committee has set Friday the 16th of December 2022 as the date by which answers to questions on notice are to be returned. The committee has also decided that written questions on notice should be provided to the Secretariat by 5 p.m. Friday the 18th of November 2022. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to the committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. Officers and senators are familiar with the rules of the Senate governing estimates hearings. If you need assistance, the Secretariat has copies of the rules. The Senate, by resolution in 1999, endorsed the following test of relevance of questions at estimates hearings. Any questions going to the operations or financial positions of the departments and agencies which are seeking funds in the estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees, unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked for the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I particularly draw the attention of witnesses to an order of the Senate of the 13th of May 2009 specifying the process by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement that meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to public interest that could result from the disclosure of the information or the document. Mobile phones should be switched off or turned to silent mode. Senators, departments and agencies have been provided with advice on the arrangement in place to ensure budget estimates 2022-23 hearings are conducted in a safe environment. This guidance is also available to the Secretariat. The committee appreciates the cooperation of all attendees in adhering to these arrangements. In order to comply with COVID-safe requirements, senators and Secretariat may use electronic devices to communicate with one another during the hearing. We ask witnesses forbearance to do so and apologise in advance for any discourtesy. Officers called upon for the first time to answer a question should state their full name and position for the Hansard record, and witnesses should speak clearly into the microphones. I welcome Senator the Honourable Murray Watt, representing the Attorney General. Minister, would you like to make an opening statement?
Good morning, Senator, and good morning, Committee. I'm looking forward to having as much fun on this side of the table as we all used to have when the roles were reversed. I actually did have a short opening statement, but it relates to my role as Minister for Emergency Management, and I wondered whether I should do that when NEMA appear.
I'm happy to do that.
Thanks.
I call officers from the Office of the Inspector General of Intelligence and Security. Would you like to make an opening statement before we go to questions?
Yes, thank you, Senator. My name is Chris Jessup. I am the Inspector General. And I have a brief opening statement, if the committee would find that helpful.
Thank you.
As there has been a period of time since my office last appeared before this committee at an estimates hearing, I thought a very brief snapshot of what my office does may be of assistance to the committee. The role of the Inspector General of Intelligence and Security is to assist ministers in overseeing and reviewing the activities of the agencies within IGES jurisdiction for legality, propriety and consistency with human rights. It also has a role to assist the government and the Parliament and the public that intelligence and security matters of these agencies are open to scrutiny. We are a statutory agency which is governed by the Inspector General of Intelligence and Security Act 1986. We have oversight responsibilities in relation to 6 intelligence agencies, namely the Office of National Intelligence, the Australian Security Intelligence Organisation, the Australian Secret Intelligence Service, the Australian Signals Directorate, the Australian Geospatial Intelligence Organisation and the Defence Intelligence Organisation. The Office also has limited jurisdiction for the use and management of network activity warrants executed by the AFP and the ACIC. In undertaking our oversight assurance work, our key activities are inquiries and preliminary inquiries, risk-based proactive inspections, and complaints and public interest disclosures. We are a very small agency with a current forecast ASL of 57 and a non-capital appropriation of approximately $12.56 million with a capital appropriation of approximately $3.76 million. We have a talented workforce with a diverse range of backgrounds and skill sets, and a key focus for our agency over the course of this year is recruitment and retention of staff. I'm assisted in leading the office by members of my executive team who are with me today. On my immediate left, Bronwyn Notson-Glenn, the Deputy Inspector General, and on her left, Chris Brooks, Assistant Inspector General, Oversight of Agencies, and just behind me, Catherine Cook, Assistant Inspector General, Legal and Assurance. We would be pleased to answer any questions that the committee may have for us.
Thank you. I should have mentioned, I'm sorry, before you started your opening statement and check whether any senators had an objection to media being in the room today. No, thank you.
I have an objection if they're not here.
Senator Scarr, you have the call.
Thank you, Chair. And thank you, Mr Jessup, for attending today with your team. It's greatly appreciated. I reviewed your 2021 to 2022 annual report, and one of the comments you made in your opening statement resonated me, given what you said in that annual report with respect to human resources in particular. So on page 3 of the annual report, it's stated, and I'll quote for you, "More generally, although the office had many new staff join it over the year, the planned expansion to the office's full complement of staff has not yet been reached for a number of reasons, including those related to the necessary but lengthy security clearance process. The office, like many public sector agencies, continues to feel the challenges of recruiting and retaining subject matter experts across a range of skill sets." End quote. I'm wondering if you could give us an update with respect to progress in meeting those human resource challenges, and what are perhaps some of the reasons for those challenges in the context of your agency in particular.
Well, perhaps I could provide the reasons first, Senator, because that would provide, if you like, the baseline from which we have moved a further 12 months beyond when that statement was made. A lot has to do with the size of our agency. As I have said, we are forecasting over the next 12 months to reach an ASL of 57, but it will. We're nowhere near that at the moment. We're still in the 40s.
High 40s, low 40s?
We're in the high 40s.
Okay.
Yeah. The specific point to which you referred, though, relates to staff with specialist capabilities. So however big or small you are, under the requirements to run a Commonwealth executive agency, you need to have certain people with specialised skills, accountancy skills, IT skills, HR skills, and that sort of thing. When we, as we did shortly after I took office about 18 months ago, when we lose someone with one of those areas of skill, it doesn't mean we've got another one already in the organisation to step up and take his or her place. We might be able to, using either means of transfer or secondment under the public service mechanisms, we might be able to find someone on a short or long-term basis from one of the other agencies within the intelligence community, because they are the places where staff of this kind would already have a positive vetting security clearance.
Yep.
But failing that, we have to go through the process of recruiting someone.
Yep.
And the security clearance process these days, 12 months is a good outcome, from what I understand. A more average outcome is getting on towards 18 months. And the issues that we find with all staff, particularly those with specialist skills, is that during the period of their positive vetting, they get an interest in doing something else with somebody else, or they get offered another job and they just disappear out of the pipeline.
So it's hard to imagine someone waiting 18 months for a security clearance to be cleared if they've got other opportunities.
Well, the great thing is, Senator, that many do.
Right.
Many people, and we're very, very pleased to be able to say this, but there are a lot of people who have their heart set on doing the kind of work that we do.
Okay. Good.
And they're quite content to work in another department or agency somewhere and just wait until the clearance comes through.
Yep.
However, we're at a much greater risk of losing people when they happen to be, for example, a specialist in IT or someone with accountancy skills, because they are in high demand and we are not the only people looking for them. So that was the observation I made then. Now, in terms of the second part of your question, or what was the first part of your question, yes, we're in a considerably better position now than we were then. At the moment, we have all the, if you like, specialist positions in our organisation chart occupied by people on either a substantive or an acting basis. The only qualification I would make to that is something which touches another area which has been the subject of comment in relation to our office in recent years, and that is the extent of our inbuilt technological expertise. Like just about every other area of public and private activity, life is becoming much more technological, and intelligence work and intelligence oversight is no exception. So in an ideal world, we would have our inspectors fully capable of interrogating the technological operations of all the agencies and understanding it. But especially when the agencies themselves are really working at the very high end of technology, and they themselves have an insatiable appetite for people with these kind of skills. That is an area in which we are still, we still, I would have to say, have some ground to make up. However, there are irons in that particular fire. I don't want to say more about that on the open record than to use that metaphor, and we would hope that when we meet again, I will have some better news for you on that score. But broadly, that's where we are now.
So how do you deal with that issue then in terms of technological capacity? Because you have a key oversight role,
yes,
and you've explained very helpfully the role of technology in terms of these fields in particular. how do you fill that gap, or partial gap, if you like, in terms of capability and meet your oversight role? So if you don't have that capacity to delve into the technology, how do you discharge that oversight role?
Yes. Well, Senator, at one level, I think gap is probably not the right metaphor. There's a merging of our understanding of what's done in these agencies at the technological level with the cooperation we get from the agencies themselves. So it depends a bit on what kind of oversight paradigm you start from. If you start with a paradigm of enmity, then we might be in some difficulty. But if you start with a paradigm of cooperation, and we get a very high level of cooperation from the agencies, as I've pointed out in that forward to last year's annual report and this year's report also, then as a general rule, the feedback that I get from our inspection teams is that 98% of the time they have no difficulty interrogating the details of agency operations with such a level of understanding of the technological aspects of it as they are able to gather from the assistance they get from the agencies themselves. That may sound a little bit the reverse of the way it should be, but the agencies are very keen to make sure that nothing that would be of interest to our inspectors is withheld.
I just have one other question other area of questions to ask before the call is shared.
Senator, before you go on to another matter, Ms Notson-Glenn has indicated that she has something useful to add on the subject we've just been discussing.
Sure.
Good morning, Bronwyn Notson-Glenn, Deputy Inspector General. Senator, I wondered if I might just gently drop in. I think there's two threads going in your question, and I thought it might be useful if I just quickly unravelled those. The paragraph in our annual report is referring to our corporate ICT, and I think the Inspector General and you then moved to discussions about ICT in the oversight space, to which Mr Brooks would be able to add anything further on that aspect. So there are two aspects with ICT. There's our corporate, and then there is IT in relation to the oversight. The paragraph there, though, refers to the difficulties that we and many other colleagues in the public and parliamentary services are having with finding technical experts. We have a number of recruitment and retention activities that we are doing, and we are in constant dialogue with other integrity agencies, small and larger, about initiatives on the recruitment front. But on the oversight aspect and the IT issues there, which was the second part of your question, there are other aspects that Mr Brooks could untangle if you wish.
Right. Well, look, I've only got limited time, so I'm interested to see how you pursue this issue or how progress is made, but I thank you for the answers. That's given me quite a deal of comfort, so I do appreciate that. The only other question I wanted to ask was in relation to the expanded role of your agency following amendments, and Senator Shoebridge and I have been attending a number of Senate hearings and other parliamentary hearings in relation to the National Anti-Corruption Commission, which is going to be implemented in the very near future. And I've also been with the Chair attending hearings in relation to the Anti-Discrimination and Human Rights Legislation Amendment Respect at Work Bill. Now, both of those bills will provide for additional functions for your agency with respect to an oversight role in terms of enforcing the positive duty of employers to take reasonable and proportionate measures to eliminate as far as possible unlawful sex discrimination. So your agency will have that role with respect to the intelligence agencies, and then with respect to corruption and corrupt conduct, you'll have an oversight role with respect to, again, the intelligence agencies. So my question is, do you have a plan? Do you either A, have the adequate resources to discharge that role today, or B, what is the plan to acquire those additional resources so that you can discharge those functions?
Well, as far as the National Anti-Corruption Commission is concerned, the answer is we have an additional appropriation in the budget just handed down for an extra staff member, which will enable us to undertake that extra component of work. So that's covered.
One staff member.
Yes, yes. Well, that's what we asked for and that's what we got.
Okay.
That's right. Yeah, I'm assured that's correct. Now, with respect to the other one, the respect at work bill, you say something about that?
Senator, pardon me. We've been in discussions with colleagues in the Attorney-General's Department about the role that the bill proposes to provide to the office. At this stage, we are awaiting to see the bill and how it moves forward through Parliament, and then would look at whether or not there are further resource implications. The way that, sorry, I'll start my sentence again. Implications of different bills, as you pointed out, do have a downstream impacts for oversight, and we are constantly examining the outcomes of those bills on our resource allocation.
Okay, thank you. Thank you, Chair.
Thank you. Senator Polley.
Yes, thank you. I'm new to this committee, so bear with me. I want to have a better understanding of your roles. So my understanding is that the key role is to reassure the public that intelligence agencies are open and transparent and that they have scrutiny, and public accountability is critical for the trust and public licence that the intelligence agencies rely upon when undertaking significant operations. So in the annual report, it outlines a range of findings and comments on compliance incidences reported by your agency. Could you describe to the committee the rate of compliance that exists within the agencies?
Yes. Do you want to deal with that? I might ask Mr Brooks to respond because he's responsible directly for the branch within our office which deals with oversight.
Yeah, that would be really good. Thank you.
Good morning, Senator. Chris Brooks, Assistant Inspector General, Agency Oversight. So I think in terms of the rate of compliance, there's two parts of our business that we do. We do proactive inspections of the agency activities to identify areas of compliance risk that they haven't yet identified, but they also report to us where they have identified compliance risks. And I guess to your question, what we find is that we have a very good relationship with the agencies and they are very proactive in what they advise to us. They may report a compliance incident and our role is to undertake an independent review of how they manage that compliance incident and provide any advice or recommendations back to the agency on how they might better address the issue to ensure that they've gotten to the root cause of the issue, that the changes that they've made are effective in addressing that root cause, and that they've thought about broader systemic issues that may or may not be in place and implemented changes to address those.
Do you have any particular focus on your oversight activities with the agencies?
Yeah, so what we do is for each agency we undertake a yearly inspection planning activity in terms of our proactive inspection. So at the start of each year we look at what our legislation or what their legislation says that we should have oversight of or must have oversight of in terms of legislation. We have a look at the types of areas based on our previous work with the agencies where we've identified compliance risk or they've reported to us compliance risk. And then we have a look at areas of new activity, increased focus by the agencies. And between those three areas, we develop what we term a risk-based inspection plan for the coming year. So that might be, quite often we'll look at things like the ministerial authorisations that an agency puts forward to their ministers or the submissions to the minister for a ministerial authorisation, warrant requests and paperwork. And then we'll actually identify areas of particularly sensitive activities that we think pose the most significant risks in terms of the agency's legality, propriety and consistency with human rights. And for each agency we do a dedicated inspection plan that is tailored for that agency and addresses the key risks that we see in that agency.
So how do you assess the risk?
So our risk-based assessment comes down to usually about the impact that the activity may have on the Australian public in particular, the likelihood that issues may arise or may not arise, and the impact that will arise that does occur if an issue does happen. So it's a qualitative risk assessment based on our understanding of the agency's activities and based on our previous work that helps us aid and develop that understanding.
Thank you very much. When it comes to complaints, according to the annual report, there was 80 complaints. 10 of those were of public interest. Can you outline to us what the nature of the complaints were? Was there any common theme for those?
There are a number of themes, Senator. Some of the complaints are from staff. So because of the classified nature of the environment in which staff in these agencies are working, we have a role, not in all of them, but in a number of them, for receiving complaints about what might in other industrial contexts be described as staff grievances. So that's one category. Another category is from members of the public who find themselves affected by the operations of the agencies in one way or another.
Sorry,
Then there are the public interest disclosures. I just haven't got it in front of me. I don't know whether that's within the 80, but it's a part of our function. No, the 80 is the complaints, and there are 10 public interest disclosure matters we had over that period. So those are two main categories. We also get quite a number of complaints which seem to be driven by some kind of what might be described, I suppose, as a resentment against a particular agency or a particular operation, often rooted in events of the past which have been fully investigated or whatever.
would you be able to break down how many complaints per agency for us, please?
I think we certainly got that data. Whether it's in the annual report, I'm not sure. Yes, we can provide you with that information, Senator, but not off the cuff.
Great, thank you. I'm going to defer to my colleague when we have some more time.
Okay.
Thank you, Chair, and good morning, Inspector General. Good to see you again.
Yes.
I just wanted to quickly ask, in the annual report, you talk about targets, and there are many targets that you have to adhere to, but particularly there was a reference to the baseline has to be established, and this is on pages 19 and 24
Yeah.
for the benefit of
Yes, I think we explained that in later sections of the report, Senator.
Yeah. So and then it goes on to talk about achieving the intent of that measure. Now, what I want to understand is what do you mean by the intent achieved, and also what is the actual baseline that you are referring to?
Well, we didn't ever have a baseline. We tried to get a baseline, so this was something which we did in the previous annual report for the first time, and the truth of the matter is it didn't really work out the way we expected it to work, because the kind of work we do is inherently unquantifiable. I'm reminded, I suppose, is a little bit off theme. I'm reminded when I was in the federal court, but there was a standard that judgments had to be produced within 3 months for the judges to comply with. And you had a starting date and an ending date for that. So I think that what we did...
And you say that with a smile on your face.
It was close to a grimace. It was more of a grimace.
Yes, well, anyone who's had anything to do with litigation would have a smile on their face anyway.
So what does the intent achieved mean, that phrase?
But the difficulty with doing that in our kind of environment is that a lot of our work isn't a simple sort of pipeline type of operation. That is to say, when something comes in through the front door, it needs to be dealt with, and then it goes out through the back door when it's been done. There was a time, as I say in the previous report, when we were hopeful that we might be able to do this, even if and what we thought we would do with the baseline was to see what our figure was in that first year, but it simply didn't work out because the operations of our oversight teams
Okay.
are so kind of they don't operate at the kind of time quantifiable level, if I could put it that way.
Yeah, I just, sorry, we're just in the interest of providing everyone an opportunity to ask questions. I do have to hand the call over to Senator Shoebridge, but we will be coming back to government questions. Thank you.
Oh, thanks, Chair. And Inspector General, thanks for the opening statement and the work your office does. I was reviewing the budget, and I see that there's about a $340,000 increase in your budget.
$340,000.
Increase in the budget, in the departmental appropriations, and then a significant capital budget increase. But there's the entry of some $30 million in prior year appropriations available.
So where are we?
We're
on the same document?
Portfolio budget statements, page 383.
Yes, I have that.
And I was just going to ask you about the 30 million in prior year appropriations available. What does that represent?
This figure here.
And I'm more than happy for the Deputy
Maybe someone
Inspector
could
General
answer
to
that
answer
question,
yeah.
Senator.
Senator, in very general layman's terms, from my perspective,
Historical underspend?
no, not at all. What I would say is that we've, as you may be aware, this office has carried a surplus, which in past years, which represents the fact that we've not been able to recruit to the ASL for the reasons that have been previously discussed. That has been there. It's not. Excuse me. It is. I'm so sorry. I beg your pardon.
Take some water.
Thank you. I will. I'm so sorry. We walked up to Parliament House in the middle of a windstorm, and I think I'm still stuck in my throat.
Yeah, it seemed like a good idea at the time.
It did, Senator.
Yeah.
What I would say is that represents the surpluses that the office has previously carried. We are able to provide you a breakdown on notice, but that is the general answer that I would give.
But that reflects, well, years and years and years of under-resourcing in terms of staff. And is that all explained by the recruitment difficulties?
I think it's largely explained by that. I think it's also explained by the impact that COVID has had on the operations of public service agencies, and it's represented by a couple of other different factors as well. But yes, that is a key factor.
And given that historical under-resourcing, and given that the ASIO budget, for example, has increased by about $80 million, Inspector General, do you have adequate resourcing in place to do your job?
I suppose that's like a Dorothy Dixer, Senator, but I'll probably... we're not making any complaints about the level of resourcing that we have. Our difficulty is with getting the resources for which we have an appropriation.
And I suppose my focus then is, what are the strategies that you've got? And, you have a modest increase up to 57, but what are the strategies you've got and who's assisting you in doing that?
Senator, I'd say we have a number of strategies. The first thing is our internal HR recruitment and retention policies, which we alluded to earlier.
Yep.
The second thing I'd say is that we are taking advantage of some terrific initiatives, such as the temporary employment register that the APSC has set up on APS jobs. We also are in a number of different groups with, as I mentioned earlier, different integrity agencies, talking about challenges of recruitment and retention and sharing best practice. We also talk quite a bit with colleagues within our portfolio department, the Attorney General's department, and there are a number of small discussion groups within there that have been really beneficial for that.
And one of the problems seems to be the inordinate amount of time in getting a security clearance, which is 12 to 18 months. Where's the delay in that? Who are you waiting on for some 18 months to get an employment security clearance?
Well, it's a sort of a black box, actually,
Yep.
or sometimes referred to as a pipeline. But we put people in at the front end of a pipeline and we wait for them to come out the other end. I really can't give you a definite answer to that, and I'd prefer not to.
Well, perhaps if you can do it on notice, some consideration of that. And I've got to say, if the Inspector General of Intelligence and Security can't work out where that process goes, there's probably broader problems with it.
well,
and I'm not being flippant.
I went through the process myself less than 2 years ago, or probably about this time 2 years ago, and it involves a number of steps. The applicant needs to generate from his or her own resources an enormous amount of personal information. Mercifully, most of the people we take on are quite young, but someone of my age, I had to go back and look through about half a dozen passports and find out every country I'd ever been to and various things like that. So security vetting at the positive security level is very, very involved, and the security vetting agency presumably has a lot of work to do with a lot of people on its plate. But we can provide you with further information to that, Senator.
And yeah, that would be helpful. Could I ask you, you said there's about 10 PID matters that have been in your bailiwick for the last, are they current or are they past, in the past?
Yes, the 10, those are the ones that we received during the year in question. So they had either been received by us or allocated to us.
The Attorney General in the last week brought a public interest immunity claim to prevent critical evidence being admitted in David McBride's case. Did you have any role or did you have any part in assessing the public interest immunity claim being made by the Attorney General in relation to David McBride's case?
No.
Did you have a role in the Witness K case? Did your office have a role in the Witness K case in assessing whether or not information could be presented to the court in the Witness K case?
Well, that's going back a while. Whether I'm at liberty to give you an answer to that and what the answer would be if I could, I'm not sure.
I understand perhaps the Deputy Inspector General has some knowledge of that.
I'm sorry, Senator, the Inspector General was just speaking. Would you mind repeating the question?
Did your office have any role in assessing whether or not information which might be the subject of a public interest immunity claim could be presented to the court in the Witness K case?
No, not that I'm aware of, Senator.
But you'll take it on notice otherwise in relation to any role that your office has in assessing public interest immunity claims that might cut across public interest disclosure matters?
Yes, we'll take that on notice, but I think the answer would be it isn't part of our function.
Indeed. Moving to another matter, in the last fortnight, I think you indicated concern about the lack of formal procedures in ASIO when doing security assessments for temporary exclusion orders. And if I recall, it's also included in your most recent annual report. concerns about the need for formal written procedures within ASIO to capture its role in temporary exclusion order process. Do you maintain those concerns?
The concerns which actually I expressed before another committee within, I think you're right to say, the last fortnight, were not so much concerned that there was not procedural fairness at the ASIO level, but rather a concern that the legislation didn't make clear whether there should be procedural fairness at the ASIO level. Normally, with a role like that, the requirement to comply with procedural fairness would be implicit. However, the particular procedures under the TEO Act involve the minister making the decision.
On the advice of?
He or she gets the assessment from ASIO as an artefact, as a done thing, and then the minister makes a decision, and it is provided that the minister doesn't have to give procedural fairness. So we inspect ASIO, and in a lot of things that ASIO does, if there's a statutory implication that procedural fairness should be part of it, that is something that we would regard as either legality or propriety and subject to inspection and subject to report and comment. But when we inspect this particular aspect of ASIO's work, we look at the legislation and we say, well, it doesn't exclude procedural fairness at the ASIO level, but all they do is to provide an assessment, yes or no, and that goes to the minister, and the minister doesn't have to provide procedural fairness. So the concern which I had was that it could be clearer in the legislation.
Well, did your
This will
inspections
be
show
your
that?
last set of questions, and we'll have to hand the call over.
I'll just finish this. Did your inspections show that ASIO was giving procedural fairness in making its security assessments?
Look, I don't think I can go beyond what we've said in our annual report about the actual detail or particulars of any of our inspections. As you would know, I'm precluded from Section 34 of our own legislation from doing that.
Well, I'm not asking after any individual matter, obviously. I'm asking whether or not it was your observation that the processes inside ASIO provided procedural fairness in making that security assessment.
Senator, Chris Brooks, we didn't inspect whether ASIO provided procedural fairness, as there was no legislative requirement for them to provide that procedural fairness. What we did inspect as part of that inspection was, do ASIO have in place policies, procedures to guide the development of the advice that they give to the minister, and so that it's a repeatable, transparent process that allows our inspection team to actually get some assurance over the way they do their business. The first time we did that inspection, we did make a finding to ASIO and reported this in our annual report that they could have been better in terms of the procedures they developed. They have developed those procedures, and at our last inspection we found that they were being followed and quite effective.
But the common law would ordinarily find, if a administrative action is provided for, the assumption would be it would require procedural fairness. Surely the assumption here is, if we know there's no procedural fairness required by the minister, surely there must be procedural fairness at some point in these temporary exclusion order assessments.
Well, the role that we have relates to compliance with the laws of the Commonwealth and the states, not the common law. That may be a distinction without a difference when we're talking about a statutory function in which the requirement to comply with procedural fairness is implicit.
Correct.
So you would say, Senator, and I would probably agree with you, that that comes under the laws of the Commonwealth. that's the problem. But as you would know, procedural fairness is at the fringes. It gets a little bit imprecise as to how it operates and whether it operates at all.
But we are
Senator,
talking
this
of...
has to be your last question. I have to hand the call over. I've given you plenty of
Thank you,
time
Chair.
after indicating last question.
But we're talking about temporary exclusion orders that are
Yes.
keeping sometimes children for years and years and years from coming home to Australia. And there's no identifiable procedural fairness that you can point to at any point in that assessment. From your oversight of the process, there's no procedural fairness that you can point to in that
No,
process.
I wouldn't make I wouldn't draw a conclusion in such categorical terms, Senator.
I'm happy for you to correct my conclusion.
Thank you, Senator.
we-
Senator Scarr, you have the call.
Oh,
Well-
no further questions.
Okay. Senator Ciccone.
Look, thanks, Chair. I'll be quick. Just one question I wanted to ask. So with respect to the oversight capability review, if I may, what's the focus of the review, and are you able to provide the committee with any initial findings as part of that review?
The review of?
The oversight capability review. I know you're undertaking that review. It's
Oh,
on page 28 of your annual report.
Yes, yes. Well, that's ongoing.
So is there anything that you're able to provide the committee? Are there any initial findings?
No, we don't even have anything.
Okay,
at
so
a
what's the
preliminary
focus of that
level.
review? When did it commence?
Well, just to assess the question of whether our resources, our personnel, are effective at the optimum level for the oversight responsibilities which we have.
Okay. Well, thank you, Chair.
Thank you, Senator Shoebridge. Do you have any other questions?
I'd just like to complete that line of questioning, Inspector General, if possible. You didn't adopt my characterisation of your officer's oversight identifying the absence of procedural fairness. But how would you characterise the process in terms of procedural fairness, given your oversight of it, and perhaps if not through you, if Mr Brooks is the person who's been primarily responsible for it?
Yes, well, he is, but I think he probably said as much as he feels able to say without going over the line.
Well, it is a simple inquiry that I'm making. The inquiry is this: if children, Australian children, are going to be prevented from returning home to Australia, and in many cases held in harsh conditions in refugee camps, do they have procedural fairness when a temporary exclusion order has been applied to them? It's a fairly simple question.
Well, that's a question of law, isn't it? As I said, that's the very question which we find, looking at the statute, is not as clear as it could be.
But I'm not going. I agree with we had that discussion earlier about the law, and I agree with your conclusions. But I'm not asking about as a question of law. I'm asking about as a question of practice in your office's oversight of the process. As a question of practice, are those children provided with procedural fairness before they're excluded from returning home to their country?
I'm not sure that I could give an answer to that question, even if there were one. It's a question which is perhaps most directly addressable to ASIO, which is the organisation which actually conducts these assessments.
Well, their response to your critiques about a lack of your observations about a lack of formal procedures was to reject the idea and to assert that procedural fairness is in play in everything that ASIO does. So I suppose in light of that answer from ASIO, I'm asking you as the oversight body, do you agree with that? Is procedural fairness in play in their assessment of security risks for temporary exclusion orders?
Well, there's probably an answer to that. I can't give it to you off the cuff, but I will get back to you. But it will be a very high-level response. No doubt ASIO would point out that many of the people in question are not even, well, by definition, they're not in Australia, and their whereabouts may not even be known. And you refer to children. There may not be any awareness of whether children are involved or not.
Well, if you're providing the answer on notice, if you could address both children and adults, I would appreciate that.
Yeah.
And I understand the difficulties you face in answering this, given your legislative constraints.
Yes. Well, if so far as factually, if your question, Senator, is insofar as our inspections have actually revealed, and whether or not ASIO did have to comply with procedural fairness, did they in fact?
That is my precise question,
Yes.
Inspector General.
Well,
Yes.
I'll take that on notice.
Thank you.
Thank you, Senators. If there's no other questions for the Inspector General, I thank the Inspector General for appearing today, and I call the National Emergency Management Agency. I understand there will be a changeover of officers at the table, and I suspend the hearing to allow that to happen. I will just resume the hearing. Thank you. I welcome Senator the Honourable Murray Watt, the Minister for Emergency Management, representing the Minister for Home Affairs, Minister for Cybersecurity, Minister for Immigration, Citizenship and Multicultural Affairs. Minister, would you like to make an opening statement?
I would thank Senator Green, and good morning again, everyone. Since being appointed as the Minister for Emergency Management on the 1st of June, our country has witnessed Devastating loss of life, and communities, farmers and businesses have been displaced or are struggling to stay viable due to devastating storms and floods. Throughout Queensland, New South Wales, Victoria and Tasmania, thousands of people are trying to recover and rebuild, while others can't even return home to assess the flood damage. We've also seen serious events in other states and territories. As we sit here, hundreds remain in the midst of an emergency, and my thoughts are with the people in Victoria and southern New South Wales who are sitting in relief centres or cleaning up their homes as rivers continue to rise across the states. In the past month alone, we have had 106 activations of Commonwealth State disaster recovery funding arrangements, 43 in New South Wales, 17 in Tasmania and 46 in Victoria. And that gives you some idea of the scale of the current disaster. And of course, there's been many more before that for the previous floods this year. The government will always step up and do the right thing, standing with communities through the crisis and through recovery. We will continue doing what is required to support Australian communities before, during and after natural disasters. That is one of the reasons we established the National Emergency Management Agency, whose staff are, as I speak, supporting communities across Eastern Australia who are in varying stages of recovery from this year's events, including those currently playing out in New South Wales, Victoria and Tasmania. I'm in regular contact with my state and local colleagues, as well as emergency response authorities. Similarly, the National Emergency Management Agency, or NEMA, remains in close contact with state and territory government departments and their emergency services as we all work together, coordinating and leading the response. The Australian Government National Situation Room and Crisis Coordination Team are providing national situational awareness, information and data, and coordinating the Australian Government's response to support states and territories during these difficult times. At the request of the state governments, we've deployed Australian Defence Force personnel to assist in flood preparations and in search and rescue and clean-up. There are approximately 350 ADF personnel currently working in Victoria and 150 in New South Wales. And can I again thank the excellent work from the ADF personnel out there supporting communities. As floodwaters recede, we're sharing satellite imagery data with the states to help them understand the impact of the flooding. State governments can then determine what assistance will be required under the joint Commonwealth State Disaster Recovery Funding Arrangements, which is coordinated by NEMA. And just this morning, I agreed to extend disaster recovery allowance for individuals in 12 additional local government areas in New South Wales, as well as activating the Australian Government disaster recovery payments for Gunnedah, Moree Plains and Narrabri. The government is also taking action right now to make sure Australian communities like those impacted by the flooding are less likely to go through this ordeal again. This morning, the Prime Minister joined the Premier of New South Wales to announce $800 million worth of joint funding to buy back, repair or raise homes in the Northern Rivers region, following repeated, relentless floods there over the past few years. I note that Premier Perrottet stated this morning that this funding wouldn't have happened without the cooperative relationship between the federal and New South Wales governments. This program of works follows the rollout of a similar buyback scheme in South East Queensland, which has already seen more than 40 homes be purchased, because we want to do better when it comes to disasters in this country, not only in our immediate response, which should be swift and compassionate, but also in our longer-term response, which should provide hope and safety to communities. As a new government, we want to change how we deal with natural disasters, from reaction to prevention. With climate change delivering more frequent and intense disasters, we need to be much better prepared than we saw from the previous government. The federal budget, handed down on Tuesday, outlined several very important initiatives centred on risk mitigation and disaster resilience. And I'll just quickly run through those. First, we have reintroduced the Disaster Ready Fund, our flagship disaster resilience initiative. Up to $1 billion has been set aside over 5 years to mitigate potential disaster loss and damage and help reduce the physical, economic and psychological impacts. Where possible, this funding will be matched by state, territory and local governments, meaning up to $2 billion will be invested over 5 years. This, of course, will replace the former government's failed $4.8 billion emergency response fund, which in 3 years failed to complete a single mitigation project, failed to release a cent in recovery, and earned the former government, over $800 million in interest. We've also committed $38.3 million to the veteran-led Disaster Relief Australia to enhance their operations by funding them to increase their capacity and capability to put more volunteers on the ground so Australian communities have more readily deployable capacity for recovery. Last page. The budget also allocated $22.6 million to the Hazards Insurance Partnership and Strategic Insurance Projects measures, which will establish partnerships between government and the insurance sector to improve consumer understanding of insurance products and leverage private-public initiatives to inform mitigation projects that reduce premiums for Australian households. This government remains committed to ensuring there's sufficient funding for disaster preparedness and mitigation across the country, and I remain 100% committed to working with NEMA to support Australian communities who are affected by disaster and to assist in building resilient communities. As the Treasurer said on Tuesday night, in times like this, our government will always step up and do the right thing, standing with communities through the crisis and through the recovery. I'd now like to hand over to Australia's first Coordinator-General of the National Emergency Management Agency, Mr Brendan Moon.
Thank you,
Minister.
Thank you, Mr. Moon. Yeah, that's actually my job, Minister.
Indeed.
I will call officers for the National Emergency Management Agency also. Would you like to make an opening statement before we go to questions, Mr. Moon?
Thank you, Senator, and thanks to the committee for the opportunity to provide an opening statement. I am now 3 weeks into my new role as the Coordinator-General for the National Emergency Management Agency. In that time, I have been on the ground in Dubbo, Tamworth, Gunnedah and Bendigo in Victoria to hear from communities impacted by the current floods. Whilst we have a long way to go in terms of the response and recovery to this event, what is immediately evident to me is the coordinated approach the community, the private sector, local government, state government and also Commonwealth agencies have taken in supporting the immediate response and recovery and early relief to this event. Since the start of this year, 2022, the nation has experienced 41 natural disaster events that has impacted over 280 local government areas. This constitutes more than half the local government areas of Australia. Our system is under pressure from consecutive concurrent natural disasters. Since the Black Summer bushfires, many of our communities have been in a constant state of response and recovery. We recognise the increasing frequency and intensity of these events has been a feature of the past 3 years. Our communities are not only dealing with floods, but for some up to 5 times this year, but they are also dealing with the effects of COVID, drought, bushfires, mice plagues, locust plagues. Now we see we are moving into a high-risk weather season, at the same time as being impacted by the third La Nina event in the past 50 years. And whilst Australia's emergency management arrangements see the states and the territories as being responsible for leading response and recovery, the increased pressure on our emergency management arrangements highlights the importance of the strategic role the Commonwealth can play in coordinating and enabling additional support for the states and territories and their communities. The National Emergency Management Agency was established on the 1st of September 2022 to deliver a whole-of-nation, end-to-end approach and capability to all phases of emergency management. Our remit is to develop, lead and coordinate the Commonwealth's approach to emergency management while supporting preparedness, response, recovery and, importantly, risk reduction for all hazards. While we have been operational for only 2 months now, we have activated all of the tools available to us to respond to the current flood event, which is impacting over half the country. Since September, we have supported the states and territories prepare for the worst-case disaster scenarios through our national exercising program. The Bureau of Meteorology has officially declared Australia's third consecutive La Nina event with an increased chance of flooding this high-risk weather season and with the potential for cyclones as well to impact those communities. We have delivered briefings to all states and territories, the Australian government, the private sector and media outlets ahead of this season. And our Emergency Management and Response Group has delivered 4 national exercises this year with more than 250 participants across the nation. We have access to near real-time data intelligence and insights through the National Situation Room, the 24/7 Crisis Management Information and Whole-of-Government Coordination Facility in Canberra, which is vital in the protection of Australia and Australian interests domestically and abroad. Since the establishment of NEMA, the National Coordination Mechanism has held 8 meetings to bring together representatives from across sectors to coordinate efforts for disaster recovery and, importantly, temporary housing and accommodation. Our regional planning officers and regional recovery officers are embedded in 57 regions across the nation, supporting those communities recovering from natural disasters. Finally, we have facilitated financial support for those most impacted by these disasters, and a range of relief mechanisms have been activated over the course of this most recent event. Looking forward, I see three essential objectives guiding NEMA's strategic direction. We will work to ensure that we have a scalable, coordinated emergency management capability to ensure timely emergency support arrangements can be deployed in any geographical location for any disaster at any time on a national scale. Secondly, we will focus on supporting and facilitating a community-led approach to recovery, ensuring impacted communities understand that they will be heard, that their priorities will be taken into consideration, and that NEMA understands that Australia is made up of many diverse communities. A one-size-fits-all approach is not sufficient. Finally, we will use every opportunity to invest in disaster risk reduction and build more resilient communities. We know we shortchange our communities when we don't use every opportunity before an event, in response and in recovery to reduce their risk and build their resilience. Without resilience, our communities, our economies and our systems are not going to be fit to face what lies in front of us, a future filled with more intense and frequent natural disasters. This is my focus as the first Coordinator General of the National Emergency Management Agency, to support, strengthen and make safer our communities, to be ready for whatever may come by ensuring that our preparedness and all elements of our emergency management system are fit for purpose, sustainable and scalable. Thank you.
Thank you, Mr. Moon. And can I begin by thanking you and your team for the work that you're doing right now to support impacted communities. I'm sure my fellow senators won't keep you from those important roles for too long. I do have to hand the call over to Senator Davey. Thank you.
Thank you very much, and welcome, Mr. Moon. I look forward to seeing you often in your role and working with you to make sure that our communities are supported. My first question, however, is to the Minister, because we can't let the Minister have his new role without enjoying the benefits of estimates.
I'd be disappointed if you did otherwise, Senator Davey.
That's right. Minister, on the in March, after the devastating Lismore floods, when the then National Recovery and Resilience Agency Commissioner Shane Stone highlighted that we might have to rethink planning arrangements and where people lived, you called for his resignation. On the 13th of October this year, on the Q&A program with me, Minister Assistant Treasurer Stephen Jones said, and I quote, "The most honest conversation we can have is to tell people if we build a house in exactly the same place that has flooded 4 times in the last 3 years, guess what's going to happen?" End quote. Are you going to call for his resignation?
No, I'm not, Senator Davey. I think you are misrepresenting my remarks about Mr Stone, the former Coordinator General. I didn't have an issue with discussions about where we build and make development, and that you'll no doubt find that there are many comments that I've made and the Prime Minister have made as well. I had an issue with, in the middle of a flood, Mr Stone talking about people choosing to live among the gum trees. I can't remember exactly the detail of the other remarks, but he made a number of remarks that I thought were grossly insensitive to flood victims who were going through trauma, and was attempting to blame people for where they lived. I see that as a very different matter to having a sensible conversation at the right time about planning and development. If Mr Stone had simply said, we as a nation need to have a discussion about where we plan and develop housing, I wouldn't have had an issue. It was the insulting remarks that he made towards people who were going through floodings at the very moment that he was making those remarks.
And on the 13th of October, people were preparing for devastating floods, which has only just peaked in the Echuca-Moama region, and my hometown of Deniliquin is only just seeing our river receding today, and hopefully we don't get much more rainfall to bring it up again. But I've received feedback, and people didn't see a difference between what Mr. Jones was saying and what Mr. Stone was saying. So I just find it interesting that being on different sides of the table. But I will move on.
Well, I've actually just pulled up the tweet that I said at the time on the 4th of March, where I did say that Mr. Stone should be sacked for saying that, for blaming flood victims for their hardship, saying they want to live among the gum trees. So the remarks I made at the time were very much directed to the insensitive way in which Mr. Stone made those remarks, rather than a sensible conversation about planning and development. This morning, I don't know, you may not have had an opportunity to see this, Senator Davey, but in this morning's announcement that the Prime Minister made with Mr. Perrottet in Lismore, where again, as I said earlier, Mr. Perrottet welcomed the cooperative approach that our government has adopted in contrast to the former government's approach. The Prime Minister also announced that the New South Wales government would be leading a project to provide advice at National Cabinet around these very issues, planning and development. They are serious issues, and they don't deserve to be expressed in a grossly insensitive way, which is what Mr. Stone did.
Before I move on to this morning's announcement, which is welcome and good news, I'll just finish on with Mr. Stone. So, following your government's election and the announcement of the disbandment of the NRRA, Mr. Stone was terminated with effect from August 2022. I understand his original contract was until 2024. Was Mr. Stone paid out for his contract, or what severance arrangements were provided?
I might ask the department officials to pull together the exact details of the payout, and I'll also check whether his employment was terminated. I'm not sure that was exactly the way it occurred. What happened, as I think you know, is that the government made a decision initially to move the NRRA, which Mr. Stone headed, into the Home Affairs Department where Emergency Management Australia sat, and we then made a decision to merge those two entities, and what that meant was that we didn't need two people heading up organisations in the way that we did. So effectively, Mr. Stone's position was redundant. I can find the exact terminology that was used. I might also say that I made, and I think Mr. Stone would agree with this, that I made an effort to treat Mr. Stone respectfully in the way that all occurred. You won't find any media comments from me around that time bagging him. I obviously had a few things to say before the election, but I thought it was important to treat Mr. Stone with dignity in the way that was handled, and as far as I'm aware, that's the way he's felt. But perhaps people might have some information, or Mr. Pizzullo might.
Senator, I can speak to that as the Secretary of the Department. It's one of my responsibilities to assist a Minister with managing the appointments of statutory and executive agency heads. I can confirm in part confirming and validating the Minister's evidence that Mr. Stone's office ceased to exist upon the creation of a new executive agency, the National Emergency Management Agency. The Minister asked me to engage with Mr. Stone, and the Minister, I think, engaged with him as well, to explain to him the employment circumstances or the employment repercussions of a government decision to establish the new agency, which, as the Minister says, is an amalgam of the former agency known as NRRA, as well as a division of what was in my department, the Emergency Management Australia Division. With the cessation of the role, the entitlements of being paid out a severance for the balance of the term were honoured. They were honoured to the dollar, and I've made sure of that, and we worked that through our personnel area, and I acquitted that by reporting back to the Minister that had been done.
Thank you. I just want to come to this morning's announcement. As I said, very welcome announcement for the people of the Northern Rivers. $800 million is my understanding for potential home buybacks or raising houses, making them more flood resilient. The New South Wales government first announced that they would be pursuing a buyback when the New South Wales review into the northern New South Wales floods was released on the 17th of August. Why was there such a delay between New South Wales putting their money up and asking for Commonwealth government support and the actual announcement which occurred today?
Well, I wouldn't agree with how you've described that, Senator Davey. You're right. Around the time the New South Wales government released its flood inquiry report, which was around August, I can't remember the exact date, we started seeing media reports that they intended to ask or put up a flood buyback program. It had a range of different costs in it, depending on which media outlet was reporting it. But we only received a request from the New South Wales government for the exact amount of money and what they wanted to do with it somewhere between 3 to 4 weeks ago. I can get you the exact date. And so what we've been able to do is, and I commend the officers for working through this so diligently, we've been able to get approval of a still relatively novel program worth $800 million in a 3 to 4 week period while we've also been in the middle of floods. I'm not having a chop at the New South Wales government here, but the reality is these floods occurred in February. They made the request in, it would be late September, early October, so several months after those floods occurred, because they had to go through their own ERC type processes, and we've managed to turn it around within a month. So I actually think that that's a pretty decent time frame at our end to respond quite quickly in comparison to the amount of time it took before we actually got the formal request.
So in Queensland, there's a similar program, the Resilient Homes Fund, I believe it's called, which is also co-funded between the Commonwealth and the states, and that was released on the 12th of May. Obviously, the Queensland government had their proposal far earlier than New South Wales in August. But given there is that precedent, did it need to take 3 to 4 weeks for the Commonwealth to review the request from New South Wales?
Well, again,
or could it have been streamlined?
Well, again, I suppose you could make the same point about could the New South Wales government have made their request much sooner, given that there was a precedent from Queensland. They obviously had their own reasons for working through it for the amount of time that they did. But I do think that we've acted very quickly in getting that approval done, especially, as I say, when many of the officers involved are working very long hours to manage the floods that we're currently dealing with as well. So the feedback that I've received this morning is that people in Lismore and the surrounding area are incredibly happy that this announcement has been made and have welcomed it. So I haven't really picked up much criticism about any delays at the federal end.
Other than I know that our federal member has been calling on the Commonwealth to come up ever since New South Wales announced it, but
well,
as you say, no one is criticising the fact that it is out there now.
No. And to be fair, and I get on well with Mr Hogan, the federal member, he and I have worked really collaboratively through the recovery process. But to be fair, if he was out there calling for us to approve several $100 million the day the New South Wales government makes a request, I'm not sure that taxpayers would think that that's the way that we should be spending money. But as I say, I think we've acted very promptly, especially when you consider the length of time it took before we received the request and the work that other people are doing on the floods right now.
And just to clarify, the $800 million, can you explain to me where in the budget that falls? Is that
sorry,
part
Senator
of
Davey, could you just repeat that?
The $800 million that was announced, could you explain to me where in the budget it falls? Because we've got a lot of money being, a lot of headline figures against emergency management, including $3.1 billion for recovery and resilience. Because this was only announced this
Sure.
morning, I don't know where to look in the papers to
Sure.
find.
I might need one of the officials to point to the exact page. It's also possible that this was within that category of decisions taken but not yet announced. And now, of course, it's been announced, but one of the officials might be able to help you with a bit more detail there.
So this is Brendan Moon. This is an announcement. This has just been made today. So I do not believe it has been taken into account in the current portfolio budget statement, but we would expect, and if I may, Senator, confirm during the course of these hearings that it will be drawn down from the contingent reserves that have been set aside.
Thank you. And just a final, I know I've got to hand the call over shortly. So just a few final questions. On the $3 billion that has been mentioned on numerous occasions, I'm having trouble sort of trying to understand it, because Budget Paper 1 says $3 billion has been included in the Natural Disaster Relief sub-function in the 2022-23 budget. Budget Paper, sorry, that was Budget Paper 1. Budget Paper 2 says $3 billion has been provided over forward estimates to account for future expenditure on floods and other disaster response payments. In the Building a Better Future publication, there's reference to it as part of the contingency reserve to meet disaster recovery costs from flooding events this year. So I just want to clarify, is it forward estimates? Is it in this financial year? Is it from the contingency? Or can we have a bit of clarity?
Sure. You're right, Senator Davey. The Treasurer made public a few days before the budget that we would be setting aside $3 billion in the contingency reserve, effectively as a provision for the costs of dealing with the disasters that we're now facing, and that would include things like the payments to individuals and a range of other things. But again, I might ask one of the officials to give you a bit more detail on that.
So the difficulty is actually forecasting the timing and impact and scope of some of these natural disasters. So I think it's prudent economic policy to provision for natural disasters into the future, certainly informed by historical events. And certainly our strategy is to understand the impacts of these disasters, to understand them and the vulnerabilities of the communities that they do impact, and then to arrange and direct a series of targeted relief measures to those communities. And it makes it very difficult because we just can't forecast where disasters occur and what their intensity may be and which communities they impact. So in terms of actually defining it through the budget process, that's an extraordinarily difficult process, but it's certainly informed by our past history, Senator.
So, but it's safe to say it's more forward estimates than just this year. It's not fair to say $3 billion this year.
Correct.
Thank you, Senator Davey. That's your last question. We can come back to you. I will hand the call over to Senator Polly. And just flagging, we do have Senator Steele-John here today to ask questions, and we'll get to you next, Senator. Thank you.
Okay, thank you and congratulations, Minister. We're usually on the same table in estimates, so congratulations on being at the big table now. I want to go and seek out some further information after the opening statement. And when there was talk about the high risk of the weather season, I was wondering if you could give us an oversight about where that risk is and what the expectations are.
If I may, Senator, I would ask Deputy Coordinator General Mr Buffoni to outline the projected impacts of the high-risk weather season.
And what preparation is already underway?
Yeah, thank you, Coordinator General. Thank you, Senator. So to date, as you've heard, the Bureau has declared a third La Nina. So what we're seeing now is continued flooding, continued risk of severe weather, predominantly on the east coast and also on the east coast of Tasmania. The other elements are on the west coast. There is still high risk of fire, so fire is still still a risk, and also for Tasmania. Tasmania is a bit of a microcosm of the mainland at the moment, where the west coast, even with the current rain, is still quite dry. Then up in the north, we've just come out of fire season in northern Australia, and now we're facing again severe weather, but also the higher risk of cyclones. The current conditions for cyclones are that they will come on earlier. In actual fact, we could potentially see cyclones any time. And the other risk is, because of the sea temperatures are actually quite warm, that there is a risk of them actually moving to southern latitudes, which is a significant concern for us. In relation to our preparedness...
When you say southern latitudes, what are we talking
about? So similar to, if you saw in Western Australia, we had a tropical cyclone move down, Tropical Cyclone Seroja. And so if you look potentially down towards the Gold Coast, the Sunshine Coast, right, on the east coast. And then the other thing is that can also then transform into a deep-seated low, which then becomes known as an East Coast low. So it's not a tropical cyclone, but an East Coast low that then, we see more significant flooding. And Senators, you would know that we've been pretty much dealing with flood from February this year, with a cycle of February, March, June, July, and now September, October, with a number of sort of waves of both incredibly heavy rain, but also with severe weather and thunderstorms. And we've seen that, travelling all the way down from Queensland through to Tasmania. So that's the outlook. What we've done in relation to preparedness, we've run a series of preparedness sessions where we have the Bureau present on the outlook. We also engage with states and territories, industry. We're doing one actually on aged care today, and we will also be doing one for the disabilities sector, so that we can make sure that they are as prepared as possible for the outlook. We also run a scenario as part of those, similar to, unfortunately, it's actually, the scenario is based on the outlook, so we use the best information and science, and unfortunately that's actually playing out as we speak. So the scenario did talk about multiple flooding. We've also engaged with the commissioners and chief officers across the country and making sure that they are prepared across the Australian government. So we have all of the coordination arrangements, the Australian Government Crisis and Recovery Committee, the National Coordination Mechanism, that have all been stood up dealing with these current disasters. And then, as you would know, working across the Australian government, including the ADF, around preparedness and posture. We often talk about consecutive, concurrent and compounding events, and that's what's putting stress on communities, on the overarching system, but we've still got very, very well practiced arrangements. The other thing is, if need be, if it escalates to a point, we also can reach out to international countries that we have arrangements with to provide support. But that is really in the extreme end. But I just wanted to give you an indication that we're sort of prepared. The indicators from all states and territories are that the country is well prepared. But if we end up with this consecutive concurrent event, and we've seen some of those, like if we had a cyclone come in right now, and where it was a Category 4 and impacted on large communities, that would have a significant impact, but also on remote communities. So we're focused on every aspect and all communities across the country. Thank you, Senator.
Thank you. I just want to touch on cyclones and northern Queensland, and I know the chair is biased in that part of the country, but is it unusual for those cyclones to come down to the Gold Coast?
It is unusual. It is unusual, and it's classic of La Nina. 1974 was a similar period that we had to what we have now, and it is very unusual. It would only occur in these types of environments and where the sea temperatures, so 26.5 is the trigger point for cyclones to occur. The current sea state is, as I'm advised from the Bureau, around 27 plus in a lot of areas. So it's not usual for them to push south.
Thank you. And in terms of the whole of government, and could you run us through which departments are involved in terms of the briefings and a part of the preparedness. And obviously you've been talking to the states and territories. How often is that happening? And obviously they've got shared interests and responsibilities. So which are the other departments at a federal level, and what's the program, I guess, in terms of the regularity that you're meeting with states and territories?
Yeah, thank you, Senator. So every department is involved at the federal level because what we've got to make sure is that the services that the Australian government delivers continue to be delivered during disasters. Examples are Services Australia. They do more than just the disaster payments. They're a critical part to, support our communities and in particular vulnerable people. But Department of Agriculture, because of obviously the agriculture element, the environment aspects, industry, transport. So we cut across every aspect. So what we do is we've run these scenarios, we've brought departments together. During these events, we establish or we run an Australian Government Crisis and Recovery Committee. And just as an example, we can have up to 80 to 90 people, Australian government only, that actually would come to that to get situational awareness, understand what the lines of effort to support the states and territories, acknowledging that states and territories have primacy and have sovereign responsibility for emergency management, and the role of the Commonwealth is to support. So we meet, they have met 4 times for just these most recent floods. And then we have this mechanism called the National Coordination Mechanism that deals with a range of different activities. To date, we've dealt with temporary housing because that's been a bit of a pressure point for in the emergency context. We've also dealt with my colleague here, Mr Mason, in the immediate recovery element, so we bring the states and territories together. I also chair a committee, or actually a group of commissioners and chief officers, which are representatives from the state and territories, and that's to make sure that we're also coordinating the sharing of resources across states and territories. We also work very, very closely with industry. So industry is a critical part, in particular around supply chains, food supply, transport, fuel supplies, telecommunications, and also power. So making sure that they are first of all connected in to states and territories, but also to the Commonwealth. So our approach is very much around bringing all together to make sure that there is consistency in the situational awareness, understanding roles and responsibilities, and making sure that lines of effort are coordinated nationally. But I just reinforce that this is about working with and in partnership with states and territories. And then, of course, along those lines, also connected down to local government and with communities.
So in terms of being prepared in consultation, what about non-government agencies during this time?
So non-government agencies as well, we bring them in through our National Coordination Mechanism. We will also be running a preparedness session for a range, so we've done it with industry, but we'll also do another one with non-government organisations, again, so that they know what the outlook looks like, what the national arrangements are, how they will be coordinated. We also had the Australian Emergency Management the Australian New Zealand Emergency Management Committee meet, I think it was about 2 weeks ago now, Senator, and it was agreed that we would, if we get a serious and very, heading towards a severe to catastrophic event, we would use the National Coordination Mechanism to assist in the coordination of non-government organisations to support. Now, we're still working through that with those non-government organisations, but that's part of the overarching architecture.
So in terms of the National Situation Room, can you just briefly outline what and how that operates in responding to these natural disasters?
Yep. Thank you, Senator. So the National Situation Room runs 24/7. It's the Australian Government National Situation Room. So we look at all Australian interests. I describe it as a sort of global outlook with a domestic focus in the first instance. We work very, very closely with our colleagues in Department of Foreign Affairs for anything that is offshore, but our primary focus is on the domestic situation. We pretty much cover all hazards as well, so it's not just natural hazards, it's pretty much any aspect at all, and it runs 24/7. What it does is highlights where, so it's directly engaged with states and territories. We have direct data feeds with states and territories so that we know what the situation is. We then use the National Situation Room to coordinate Australian government support. And they also put out a series of products to make sure that ministers, our minister, the Prime Minister, secretaries are all apprised of the situation, and so that respective decisions can be made. So, it's important that we maintain near real-time situational awareness. We also have the National Joint Common Operating Picture, which is a new technology that pretty much gives a situational awareness nationally at any point in time, so very much bringing that data in. We also established a crisis coordination team, which again is a multi-agency crisis coordination team, to make sure that the requests for assistance occur, and I would activate ComDisPlan, which is the Australian Government Disaster Response Plan, and quite often I will do that in anticipation, and that provides the framework for states and territories to make requests for Australian government assistance, including ADF. So any ADF assistance basically is through the National Situation Room, through NEMA, then the Minister will approve that and then they're deployed accordingly. Also, engaging with other areas of the Australian government, including using satellite imagery, which is provided directly to states and territories. And as I said, the cross-jurisdiction coordination all happens connected up through the National Situation Room.
So just to go back to part of the opening statement and some of the information you've already shared with us, this is uncommon territory we've been in over winter and spring, is it not, in terms of the amount of flooding, rain, etc. So have you seen this type of weather pattern before, and why are we seeing these changes? What's the cause of this?
Well, Minister, it has been quite significant. In actual fact, if you think about, we've been sort of at response mode probably since the monsoon floods in Queensland, then pretty much moved into black summer, and then we've seen this frequency, and obviously with COVID, the overlay of COVID, which still is a consideration, and then we've moved into what I believe is an unusual pattern driven by La Nina. There's no doubt in the evidence that's provided by CSIRO that climate change is a key driver in this environment, and we are very much focused from our perspective around adaptation. And it's adaptation around approach, around attitude, around systems, around capabilities, because historically we would prepare for a season, and we started with fire season, become disaster season. It's now high risk season, and the Minister himself has actually referred to as the higher risk season, and that's only because we have the confluence of cyclones, flooding, and still fire and severe weather, plus the potential for human-induced crises as well. We've seen COVID. We've seen a range of other sort of crises that are all overlaid. So it's a complex environment at the moment, Senator, but the system is holding up very well.
In relation to the emergency management sector, you think there's a real understanding that this is being driven by climate change, and do you think that this impact that we're going to be able to manage the present situation that we are in, and what happens if we do get another disaster on top of what's already happening? Do we have the capacity to cope with that?
So, Minister, as I said, there's no doubt that the discussions in the emergency management sector are around climate change. That's front and centre to a lot of our dialogue, to a lot of our planning. In relation to your question around will the EM sector cope, It's about drawing on every aspect of governments, of civil society, of volunteerism. But there's no doubt if we had, say, floods running as they have been in this last month, if we had really significant fires in the west, and then there's potential to have more than one cyclone impact, if they were in a very compressed time frame, there's no doubt that the system, I believe the system would cope, but it would be under significant pressure. And the system is designed to scale. That's the other thing, is it's actually designed to scale and to use. The challenge we have at the moment, though, Senator, is communities are fatigued. And you've heard that in the opening statements. Emergency services, again, fatigued. Government, and public servant. So that's a factor, but I think it's just about the about resilience within the community and within systems as well.
Well, just before I hand it over, thank you very much. I mean, it's such important work and fatigue, but we are a very resilient population, I think.
We are.
So thank you very much. Thank you, Chair.
If I may add, Senator, just to
Of
round
course.
that reply off, Mr Buffoni gave us a very, very coherent understanding of the institutional arrangements that are happening at a Commonwealth level, but I think it also should be recognised coming out of the Royal Commission, it was asking for exactly this, and you are seeing this across many of the jurisdictions now, who are reorganising their emergency management services. They are investing, they are putting more people on, they are investing in their systems to be able to deal with this as well. But it's not only just in the response phase. Certainly the jurisdictions are changing the ways in which they deal with recovery and also disaster risk reduction. So we're seeing this across the board, that as a nation we are moving forward in terms of dealing and having that capacity and capability to deal with some of the significant issues that we face.
Thank you, Mr Moon. Senator Steele-John.
Thank you very much, Chair, and welcome Mr Moon, Mr Buffoni, Mr Mason to your very first session, and I look forward to working with you in what is a really important area for Western Australia and for the communities I particularly represent. I want to take you first to the NEMA website. Now, when searching the website for any support services and filtering for the phrase disability, the only two that appear are DES, so the Disability Employment Service, and the NDIS. So I'm wondering how NEMA has prepared DES and the NDIS to offer emergency and crisis support to disabled people experiencing floods, fires and other disasters.
Thank you, Senator. And this is a real issue for us because we certainly do recognise the most vulnerable people in our population are impacted the most during these disasters. And it was our experience, obviously, during the earlier floods that were on the eastern seaboard, that many of those communities who were most vulnerable were those most impacted. If I may, I will ask First Assistant Coordinator General Hannah Wandell to come to the table, and she can talk about more fulsomely some of the initiatives that we are taking in this sector, Senator.
Indeed. Thank you, Senator. Hannah Wandell, Acting First Assistant Coordinator General at the National Emergency Management Agency.
Hello there, and I'll just repeat the question
Thank
for you.
you.
So just the question is, since on your website, when you filter for disability-based services and supports, the two agencies or programs referenced or that are able to be found are DES, so the Disability Employment Service, and the NDIS. So my question is how NEMA is preparing the DES and NDIS to offer emergency and crisis supports to disabled people.
Thank you, Senator. So in terms of our broader website, we are undergoing a range of updates, noting we are a new agency since the 1st of September. So I would just note that from the outset. In terms of the broader engagement that we have, Mr Buffoni has outlined that we have really close engagement with other departments and agencies across the Commonwealth, and that occurs through the likes of the Australian Government Crisis and Recovery Committee, but also bilaterally between NEMA agency and also the other agencies that you've mentioned. So we do have regular engagement with those organisations. In terms of the broader work that we are doing, last year...
Sorry to interrupt you. Just before we move off that, so just to clarify, are the NDIS and Disability Employment Services part of those crisis committees, represented on them?
Yes,
They
are,
are.
Senator.
Okay.
Yes.
Who are their representatives on that committee?
Senator, I can't give you the exact names because we go out to the agency and then they will send a representative, but we do go out to them and they are definitely represented on those committees.
And could you give that to us? Could you kind of provide that a little bit later in the day?
Absolutely.
Just who is the person and how often can you tell me how often the committee meets?
Well, the committee is not a it is designed more in immediate preparedness and response and recovery. So it's in that actual. For this event, we've met 4 times.
Okay, so met 4 times, and that gives you NDIS in the room, gives you DES in the room. Is there anybody else representing the disability community on that committee?
Specifically, they are government agencies that we invite.
Of course. Yeah. But you'll know that there's about 500,000 NDIS participants, about a couple of 100,000 DES participants. I think last time I checked, there's 4 million disabled people more broadly. So just checking, there's no other disability representation on the committee.
Not if they're not within a government department.
Okay.
If I may, Senator, certainly on this committee, it is very much tied and integrated with the Commonwealth agencies. But I would also reflect the jurisdictional arrangements under their recovery group structures.
Yeah.
Especially in the human and social space, they will have a range of members, which not only includes government membership, but also many of the other disability support services that operate in the NGO sector and other allied groups as well. So it really is an integrated approach to dealing with this, given that the states have that overall response and initial recovery responsibility, and certainly our role is at that coordination end of the spectrum, but certainly we'll be obviously having a conversation after these estimates about it, the inclusion of a broader group in this conversation.
That would be very useful. I mean, in looking through your website currently, and I hear what you're saying about it being updated, but the link takes you through to the NDIS website. The NDIS website then informs you, and I'll quote it directly, that the agency should not be considered as the first or primary source of information in the event of an emergency. So my read of the way the website is currently structured, to just be frank with you, is that NEMA pushes you to the NDIA, and the NDIA says that's not we should not be used as the first resource. Correct?
The officials can elaborate on this, but there's obviously a really important role for the states and territories in this process as well, because I suppose the way we think about it, and I think the way most people think about it, is that the federal government's role when it comes to disaster management, dealing with an event, is largely one around coordination, funding. We still rely on states and territories as the primary, if you like, delivery agencies, and we would certainly have an expectation of them to be also meeting the needs of people with a disability in a disaster setting. But I'm not sure if anyone wants to elaborate on that, but obviously this is something that we can take a further look at.
Sorry.
Yes, I mean, I hear you, Minister, but I also am conscious, very supportive of the establishment of NEMA. It's a great idea. But when you yourself made the announcement that it was going to come into being, you said that it would provide end-to-end support in a nationally coordinated approach. So I agree, states and territories have a role, got to be coordinated, but at the end of the day, as we sit here today, the website actually doesn't facilitate that coordination. It just sends you in a bit of a circle. So that kind of just wanted to bring that to the attention, but also to emphasise as well the point around not making the mistake to conclude that if you've got the NDIS in the room, you've got all disabled people in the room, because there's a large cohort that isn't represented there. Just also taking you to my secondary line of questioning, which is really around, has NEMA engaged with the disability community, folks with lived experience, and worked with them to develop any national level, and that's the critical word here, plans for crisis management for disabled Australians?
Thank you, Senator. In terms of our engagement with the disability sector, in addition to the committees that have been outlined, and I note Mr Buffoni highlighted that there would be a high-risk weather season briefing, we do have a range of initiatives that we've been undertaking to support the sector. I would also note that on the 15th of June, we held a Charities and Not-for-Profits and Peaks Roundtable, which invited the disability sector, and we will be looking to host another one of those roundtables quite soon, hopefully in the new year, which looks not only at that response and recovery phase, but broader integration and risk reduction and how to reduce risks and improve the broader system for all in the community sector. So that is something that we are progressing. In terms of some additional pieces of work that we've been doing, last year the Australian Disability Strategy was launched, and as part of that there was an emergency management targeted action plan. So there are several features of that action plan that are being actively implemented. I could go through that, but I would just note that there are a couple of initiatives that we are undertaking at the moment, and one of those is through disability inclusion through something that we're calling the National Capability Package. So at the moment we're working with the community sector to roll out recovery exercising programs. So often we'll focus on exercising in the context of response, so how do we respond to a disaster event, but we're also very cognisant, as has been highlighted throughout this hearing, that recovery can take many, many years, and it's really important to make sure we exercise and prepare for that. And so as part of that, we're developing a national toolkit, and that includes a section about specifically supporting people with a disability. So that's just one of the initiatives that we're working on at the moment.
All right. So what I hear is there's conversations going on, and there are tools being developed, but my question is particularly in relation to seeking community feed-in to the development of a national plan. So is NEMA currently developing a nationally coordinated plan for disaster response for disabled people?
At the moment, Senator, we are developing something called the Second National Action Plan under the National Disaster Risk Reduction Framework, which is a really important part of Australia's implementation of the Sendai framework for disaster risk reduction. So it's implementing our international obligations, which includes obligations for people with a disability. As part of those consultations, we have worked with people in the disability sector. We held a range of consultations between March and June of this year, including a 2-day summit event where people with a disability were invited, and I can get the names of organisations for you. And we also sought input into a public survey as well as a public submission process for that second national action plan.
Thank you. Can I take you to the Disability Inclusion Disaster Risk Reduction Project? Is it yourself that's the best person to ask about that?
Can I confirm the delivery entity for that organisation? I just want to confirm that it is our agency.
It is NEMA. Yeah,
Thank you.
It's listed on your...
Acting Deputy Coordinator General Neil Mason.
Yes.
The Disability Inclusive Disaster Risk Reduction Project, is that the one you're referring to?
Yes.
Yes, we're working in with the University of Sydney's Centre for Disability Research and Policy.
So when does the agency anticipate the work of the project will be completed?
I I'll just check to see whether we've got a stated completion date. I think we're still in the early stages of some of that work, Senator, so...
All right, can you come back to us before the end of the session?
Unless Ms Wandell has that handy, yeah.
No, Senator, I'm afraid we're still negotiating that grant agreement with the University of Sydney, so we wouldn't actually have the milestone, so we'd have to take that on notice.
So you haven't actually completed the grant agreement yet with the university? So we haven't actually commenced the project?
I need to take that on notice, Senator.
Well, could you come back to us before the end of the session with that? That's pretty basic. Thanks. What plans, my next question, presuming because it's listed on your website, it was a bit further along, was around actioning the outcomes of the project, but we're not actually there yet. I'll take you then to outside of this particular project. Is the agency undertaking any other plan other than the ones you have listed around developing disability inclusive disaster preparedness, particularly in relation to, but not exclusively to, fire and flood?
So, Senator, the agency has not commenced that. Since our establishment, we've been very, very focused on dealing with the floods that we are facing right now. But I do note that at a jurisdictional level, that certainly that work is going on throughout the states as it is their core responsibility. And there are a number of preparatory, what we would call get-ready programs that are underway that deal with all sectors there at a state level. But nationally, no, we haven't had that opportunity yet to set our mind to that particular space.
It's very important that you do, and I understand the jurisdictional questions, but national coordination, as we've learned for the community broadly, it's why you exist, is important. Vitally important for the most at-risk communities. My final line of questioning is around the Disability Royal Commission. So I acknowledge the final report and final recommendations of the Royal Commission will be published in September of next year. However, their issues paper of April 2021 outlines the risks that disabled people face in crisis situations. And I'm wondering, given the government's own admission during that particular session, that we face, and by we I mean disabled people, face more frequent and intense national disasters. Has the agency engaged with the Royal Commissions and these findings?
Not at this stage, Senator.
What's the timeline for engaging with the Royal Commission to that end?
We will certainly, following this hearing, we will certainly establish a mechanism by which we do contact the Royal Commission and get an understanding of those key recommendations and the implications for NEMA.
Okay, thank you. And I understand that the usual process of government is to wait for final recommendations. The reason why I draw your attention to these is because of the timeliness of the situation, and we've seen in recent times, unfortunately, disabled people right now actually trapped in their homes, flooded in with no supports, and we're going to keep seeing that pattern unless we get urgency, and part of that urgency is Commonwealth leadership. And the Minister understands this. It's why you have championed the agency, and your statements make that clear. So I look forward to continuing to work with you all as the agency develops. And you get a new website. Awesome. Thank you.
Thank you, Senator Steele-John. That takes us fairly closely to the break. I understand other senators have questions when we return.
I should note that we had originally allocated 1.5 hours for this agency and questions for this agency up to this point in time. Despite your best efforts as chair, which I acknowledge, the opposition's only had 15 minutes really thus far to ask questions, which wasn't really how we anticipated this first block would go. So we do have further questions.
Understand. We will suspend for morning tea and come back at 11:15, and we'll be still with National Emergency Management Agency. agency. I do remind senators that we are now eating into valuable time with the Home Affairs Department, and I hand the call to Senator Davey.
Thank you very much, Chair. Just going back to today's announcement about the 800 million, I just want to double check, does that announcement, or will that announcement at all, impact homeowners that have already accessed the back home grants? Will there be any impact on those? Does that access to those grants preclude them from participating in potentially this buyback or home redesign?
Thank you, Senator, for the question. In relation to the guidelines for this particular package, they have not been established with New South Wales yet, but it'll certainly be a consideration as we work through the guidelines with New South Wales.
So that would also apply then to any person who may have received an insurance payout, and that would be taken into consideration when designing the guidelines?
That would be expected. I can reflect on the Queensland guidelines that were established with the Commonwealth Government back in May of this year, and any funds that are derived as a result of this particular grant were then offset against any insurance payout in the home buyback part of the funding program.
Okay, thank you. I now want to turn to the transition from the NRRA and the EMA to what is now NEMA. Minister, or probably Mr Pezzullo, the NRRA had an advisory board. How many board members were appointed to that board, and on what contract were they appointed?
Senator, the NRRA was vested in the portfolio of the Prime Minister, so it was for a temporary period from 1 July, if I recall correctly, transferred under a machinery of government change to my department, or to the Department of State that sits at the centre of the portfolio. I'd have to take the detail on notice, because between 1 July and then the disestablishment of NRRA and the establishment of NEMA, I don't recall any specific action that I had to take or that my office had to take in relation to those members. So some of that detail might well be held by my colleagues in the Department of Prime Minister and Cabinet, so I'll take it on notice and I'll come back to you.
Could you advise when the advisory board was notified of its disbandment, or for want of a better word, and what termination arrangements may have applied, or?
I think it best that I take that as a subset of the question taken on notice, because, as I said, the advisory board was set up in association with the establishment of the NRRA as an executive agency within the Prime Minister's portfolio when Mr Morrison was the Prime Minister. So the administrative details of their appointment, their paying conditions and the like would be probably vested in somewhere in PM&C, so I'll take that on notice, consult with my colleagues and come back to you on notice.
I would very much appreciate that. And as you mentioned, the NRRA came under your purview with the machinery of government change. In July this year, there were the NRRA advertised a number of staff vacancies with applications closing on the 28th of August. But at that time, it had already been flagged that the NRRA did not have an ongoing role. So why were staff vacancies being advertised under an agency that was on its way out?
Senator Davey, to be perfectly candid, I have no idea. It doesn't strike me as being something sensible to do, but there might well have been extenuating circumstances are applicable. This one's a slightly trickier question to take on notice because it relates to the actions of an agency that no longer exists, and even the officers who now work in NEMA by way of being transferred into NEMA are not properly qualified to answer that question here because they're not here as representatives of an agency that doesn't exist. So again, I think the best thing to do is that I'll take it on notice. I'll have my governance people examine such papers as they have. They'll consult with NEMA, who might well have records in their HR area that go back to that period. But I'm just a little bit reluctant to answer questions in relation to an agency that no longer exists, although of course the Parliament's got every right to supervise and hold to account the actions of government even in relation to agencies that don't exist. But I just would feel more comfortable taking it all on notice, including the question of why vacancies were being filled within months of its disestablishment. Now, that said, the agency, it was known under the directions given by the government, it was known that that function would be vested into a new agency along with the staff and the resources of the Emergency Management Division of Home Affairs, otherwise known as Emergency Management Australia. And so it might well be the case that the interim leadership and management took the view, well, the function's going to exist. We know that we're going to be through a machinery of government change and the establishment of an executive agency pursuant to the Public Service Act, established as an executive agency to be titled something like NEMA. I can't quite recall when the title was finally settled. So it might well be that a pragmatic decision was taken that the staff are going to be required, the processes are going to be vested across, the functions going to be vested across. So it makes sense just to recruit the talent. But again, I'll just take that on notice and just verify whether that is indeed what happened.
Because that was my next question. How many staff were transitioned from the NRRA across to NEMA, and by the same token, how many EMA staff were retained within NEMA?
I think the best way to divide the labour is if Mr Moon perhaps takes questions that relate to his current workforce, which of his workforce has come from NRRA, or how many have come from EMA or indeed elsewhere, and I might take the questions that relate to the historical entity that is not really under Mr Moon's remit. So I'll deal with questions pertaining to the historical actions of NRRA, and perhaps Mr Moon, by agreement, if you can deal with your current workforce. Thank you.
Correct. I can advise the committee that NRRA, the baseline staffing that came across was 166, plus an additional 59. Similarly, from the Emergency Management Agency, 83 was the baseline transfer of staff, and from the Australian Government Crisis Coordination Centre, an additional 13 was merged into the current NEMA.
So that would be a total staff now of?
334.
334. And you now have, you've effectively got the two roles, so you're not just emergency management, you're also emergency management and recovery and resilience?
Correct.
And how many, are all of those staff located here in Canberra, or are they located around the nation?
They are located around the nation. As I did indicate in my opening statement, we currently have 66 staff deployed in 57 regions throughout the nation. The balance operate here in Canberra.
And when they're deployed in other areas and other cities, are they ever co-located with state emergency management agencies?
We certainly, during different phases of a disaster, will co-locate our staff with agencies. However, in the longer-term recovery phase, that relationship becomes somewhat blurred in terms of our staff get a lot closer to the community and the local governments than they do with the state agencies, because that is an effective platform by which we can understand where the gaps are in recovery, and we can certainly address those promptly.
Thank you very much. I've got a lot of different questions. I might be bouncing all over the place. This one I think is for the Minister. I was wondering if you could potentially clarify, there was a report in the Daily Telegraph this week that disaster recovery grants, tax exemptions for disaster recovery grants, which had been implemented under the coalition government, were no longer accounted for in your budget. Can you just clarify to people whether their disaster recovery grants, particularly under category C or D grants, will be treated as income for tax purposes or will be tax exempt?
Why don't I tell you what I know, and again, officials can maybe elaborate on this for you, but my understanding, happy to be corrected, but my understanding is that The usual practice of successive governments has been that certain types of disaster payments, such as grants to small businesses and primary producers, are treated as taxable income. I think there's been a very small number of exceptions to that, but the general practice has been that they are treated as taxable, and again, that's occurred over successive governments. However, the costs that a small business or farmer incurs in, for instance, repairing their property or their fences or whatever it might be, are also taxable. Are tax deductible. So in effect, there's a tax neutral outcome. People certainly don't end up coming out behind as a result of this tax treatment of those payments. But I might get whoever the relevant official is to elaborate on that for you.
I think the Minister has indicated that this is a consistent practice over the grant process, and as I'm not a taxation specialist, I won't comment any further.
I might add, Senator Davey, that there are, of course, a number of grant programs that are exempt from tax, such as that Australian Government disaster recovery payment, the $1,000 per eligible adult. That's tax exempt.
So, and it's good to know that the individual payments that are going out are exempt. I'm just noting that in certain times, so for example, for Cyclone Seroja, for the 2021 storms and floods, Category D recovery grants, and for the 2019 North Queensland floods, Category C or D recovery grants were deemed non-assessable, non-exempt government grants. Would you consider making the same determination following these floods for businesses that qualify for and are granted Category C or D grants following this event?
Yeah, obviously I'm not aware of the circumstances that led to the decision about those couple of events that you talked about. But again, I'm happy to be corrected if I'm wrong here, but my understanding is that the former government, of which you were a part, treated these payments as taxable after the floods that we saw earlier this year. And my understanding is that that has very much been the usual practice, and it's our intention to follow that usual practice.
Thank you. I also...
But can I just re-emphasise
Sure.
that, you know, people can claim as a tax deduction the costs that they incur. So, you know, they would get a grant, it would be taxable, but they'd potentially get quite a large tax deduction depending how much they spend on their repairs.
So keep your receipts.
Always good to keep your receipts.
Always keep your receipts. I also want to go to the budget allocation of $38.3 million over 4 years for Disaster Relief Australia. This is a not-for-profit volunteer organisation who provide assistance following an event. Could you explain how it was decided? Did this go to tender?
No, it didn't. This was actually an election commitment that we made. So obviously there's no tender process for election commitments. The Disaster Relief Australia, as you're probably aware, are veteran-led or not-for-profit who mobilise volunteers to help with clean-up and recovery work. You may have come across them yourself, Senator Davey. I certainly have, in places like Lismore, where they do a really good job supplementing the SES, the ADF and other people who are out there doing clean-up and recovery work. And their volunteers tend to either be veterans themselves or first responders, and I should say, quite apart from the relief work, important relief work they do, the feedback that we've had from participants in that program is that it gives veterans and the other volunteers a real sense of fulfilment as well to be able to continue contributing to the community. We had some, you know, as an opposition, we had some discussions with DRA about the services that they provided, and you'll be familiar that I've made many public statements saying that I think as a country we need to think about broadening out that disaster workforce, if you want to put it that way, beyond and not overly rely on the ADF. And this organisation, we believed, brought a lot of capability. They'd already had, I can't remember the exact number, but I think it was in the thousands of volunteers on their books without doing any real advertising. They were really just relying on word of mouth, and this gives them an opportunity to significantly expand their capability and have more volunteers on the books as well. But no tender process because it was an election commitment.
And certainly I'm not at all trying to say that DRA are not, they are a great organisation, and I agree that their volunteers and the sense of fulfilment they get from participating in such a good community-focused organisation is very real. However, I'm just trying to understand, given that there are other organisations such as Blaze Aid, such as the Salvation Army, such as Red Cross, why Disaster Relief Australia were chosen above all others, and why there was no process put in place to actually make sure and ascertain that it was a transparent process where DRA proved to be the best organisation to get nearly $40 million, nearly $10 million a year for 4 years.
Well, again, it was an election commitment. Oppositions don't run tender processes for services that they commit to. I'm sure that's an experience you'll be involved in now that you're on that side of the table. And we obviously gave consideration to what more could we do to fix what we thought was a very clear gap in the nation's response to disasters, being people on the ground to help with clean-up and recovery, especially when we're talking about catastrophic events. I absolutely recognise the important work that those other types of organisations that you meant do, and again, I've met many volunteers from those organisations out in the field. But we thought that Disaster Recovery Relief Australia brought a particular skill set, could mobilise particular types of people with exactly the types of skills that were required to do that clean-up and recovery work. The Salvation Army, for instance, do a terrific job helping disaster survivors. I'm not sure that even they would say they're the people to go in and do clean-up with big hoses and equipment after a disaster. They do other work that's really important, but we thought that this was the type of group that particularly had the skill set and the networks to mobilise the people who were required for that clean-up work, which needed some improvement.
Senator Davey, we just do need to hand over the call. If you have a follow-up question to that answer, that's fine, Senator Scarr.
With respect, Minister, the answer, it was an election commitment, doesn't really deal fulsomely with the issue, does it? Because the issue is, surely you're going to get a better result if you go out to tender and you find out which agencies are available to possibly provide the services and what terms and conditions they can provide those services on. So the fact it was an election commitment doesn't change the underlying point that you're going to get a better outcome, or you'd expect to get a better outcome, or at the very least affirm you've made the right decision if you go through a tender process. Isn't that right?
Well, I invite you to give me one example in Australian history when an opposition has run a tender process to determine its election commitments.
No, well, that's a smart answer, but
well, it's an accurate answer.
you could have actually made a commitment to provide the funding, but you would go through a tender process once in government. Isn't that a reasonable response to that?
Well, again, and I'm sure you'll experience this in the run-up to the, well, I look forward to seeing your tender processes or similar arrangements when we come up to the next election. It's just not how it works.
This is us asking questions.
I've had the misfortune of being in opposition for 6 years, and all that time, I've never seen certainly the opposition that we were part of run a tender process to determine its election commitments.
I'm not saying you run a tender process.
Well, you
what
were
I'm
originally.
saying is you say there should be funding for X, Y, Z, and when we get into government, we'll run a tender process.
And there are commitments.
Sorry, let me finish. To ascertain who is the best agency to provide this service, to give taxpayer money, taxpayers' best bang for their buck. That's what I'm saying.
Well, are you aware of a better organisation to perform the kind of service that we're talking about?
Well,
there could be.
I don't know, because I haven't gone through a tender process, and that's something I'd
Well,
expect
I
government
just
to
think
do in government.
it's pretty ridiculous to suggest that an opposition would run a tender process. That's what governments do, and that's what we're now doing for a whole bunch of things.
But there's
Okay,
no
thank
reason
you,
why you couldn't
Senator
have said you were
Scarr.
going to run a tender process when you're in government. I don't understand why you didn't do that.
I can't
Senator
add to
Scarr,
what
I
I've
do
said.
need to hand over the call. Senator Polley, you have the call.
Thank you. I think it's opportune time. With the Disaster Ready Fund, at that $1 billion, can you actually outline to the committee the types of disaster resilience and mitigation projects that can be funded under that very important program?
Thank you, Senator. So we will, and we have been working with the states to start to design the guidelines to support the rollout of the Disaster Ready Fund. But certainly our experience has been over the last number of years that investment in not only grey infrastructure, but also blue-green infrastructure, such as the natural environment, such as building community resilience, does have effective outcomes. And to give you an example, there have been a number of betterment programs run throughout Australia where we've seen a significant investment in actually building the resilience of our infrastructure networks that not only have saved money in recovery, but importantly have been functional immediately after the disaster. These programs work, and certainly the Disaster Ready Fund will be focused on not only addressing some of the infrastructure risks we have, but some of the other risks that we certainly will face into the future. We will, over the course of the coming months, work very closely with the states to design the best guidelines for them that undertake not only an analysis and an understanding of historical risk, but also start to factor in some of the longer term risks that we potentially will face.
So will there be consultation with not-for-profits and the insurance sector as well in developing those guidelines?
There absolutely will, and certainly you will have noted another one of the election commitments of $22.6 million for the Hazard Insurance Partnership and Strategic Insurance Projects. Now, this particular partnership will look at working with insurers so that we can share data commonly held by state, national and also insurance companies to better understand the risks our community face, but also importantly to better direct our recovery efforts. If we have an understanding of the level insurance and also the scale of insurance in particular areas, we can better design recovery programs and also disaster risk reduction programs. So it is an integrated approach to actually dealing with risk.
Is this a different way of allocating money that's in this budget? If that was election commitment, so coming in within the budget, are we going through the normal processes, or are we more engaged and have a different process that we've put in place for this budget with this money?
So in terms of this fund, I'd make a couple of comments here. Is the Productivity Commission in 2015, the National Natural Disaster Bushfire Royal Commission, both recommended that there needs to be more investment up front in disaster risk reduction and also mitigation. It just cannot be left till after an event. So we are taking a more proactive approach rather than a reactive approach. So that will be the approach, and that is why this fund and this approach is different to previous funds. In terms of the governance arrangements for these funds, they will be consistent with the Commonwealth grant funding guidelines, but certainly we are engaging very, very early with the states and other stakeholders to get an understanding of how best to frame those guidelines to deal with disaster risk.
So in relation to building the resilience, will this help to actually push premiums down for insurance companies? Because that's obviously, a big cost after any disaster. So, is these steps all about trying to put pressure downwards in that area as well?
It's not only pressure on premiums that we're seeking to do, but it's also the level of coverage available. And I think there are some real opportunities to look at mitigating the impact of natural disasters that potentially will feed into the availability and the cost of insurance. Now, we've seen this work at a micro level throughout Australia previously. There have been resilient homes funds that have been delivered. I can reflect back on one that was for cyclone-exposed homes from Bundaberg all the way around the coastline of Queensland to the Northern Territory border, which actually involved the retrofitting of homes to withstand cyclones. And that resulted in a downward pressure on premiums. But I think we need to take a national approach here and have that conversation and have that engagement with the insurance industry so that we do take a nationally coordinated approach. Ultimately, the insurance companies, through a whole range of mechanisms, will determine their premiums. But this is an important part that will influence it.
So has there been any feedback from the stakeholders in terms of the arrangements that have now been put in place? And can you give us an example of the sort of mitigation project that would come under this fund?
So the feedback from stakeholders, we're very, very early in the process of engaging with stakeholders. But if I look at other funds that have gone out trying to and seeking to achieve similar outcomes, you will see that they have been massively oversubscribed. So there is appetite for investment in these particular funds. But to give you an example of some of the mitigation options that we would look at, I think we need to understand that mitigation options come in all shapes and form. There can be your structural mitigation options. These could be levies, they could be betterment, they could be a whole range of things. But also there are other options from a mitigation perspective. It's about better warning systems, a better understanding of risk. Similarly, investment in the natural environment as well.
Sorry, Mr.
Thank you, Senator.
That can be your last question, Senator Polley. We've got a few blocks to go before we can finish up.
Well, we have. Just that, with what our community right across the country has been dealing with, I feel at least that there's some reassurance that we're doing things differently than what has happened previously. How quickly is this money going to flow through?
So we're currently working with the states, and we fully expect that we will have settled those guidelines early in 2023. And the plan is for the fund to actually launch on the 1st of July 2023.
Thank you very much.
Thanks. Senator Patterson.
Thank you, Chair. I do know Senator Davey had a couple more brief questions. She might be able to complete her block and then leave us. Not that I don't want your company, Senator Davey.
If you can keep them brief, Senator Davey. Other senators have questions.
Yeah, understood.
Sure. And we knew you were waiting, so that's why I went to you, Senator Patterson. So if you could keep it very brief, Senator Davey.
I will do my best. Just two topics I want to investigate, and I'll be brief. So in March 2022, in the budget, it indicated funding for a regional small business support pilot program, which was transferred from the Department of Agriculture, and it effectively funded some rural financial counselling services. Has this pilot program been continued? Because I can't find it in the budget. I can't find mention of it.
I would ask Mr Mason to provide some detail.
Senator, Deputy Coordinator General, National Emergency Management Agency. Senator, the current program has been running, and the funding allocated at the moment takes us through to the 31st of December.
And so it's not being continued?
Senator, we're under consideration at the moment options relating to that particular program and whether it would continue beyond its current funding allocation.
Is the Minister aware that 30 qualified financial counsellors that have been operating in northern New South Wales towns have now been advised that the pilot will cease from the 31st of December and they will therefore be unemployed?
Well, I'm not aware that they've been advised that, and I'm not sure who provided them with that advice. Do you know who that was?
I know who gave me the information. I don't know who provided them the advice.
Right. As Mr Mason said, this is something that we're in discussion with the providers about. I've actually spoken to some of those providers myself. I should point out that there was an independent report that was undertaken into this pilot, and I actually can't remember whether that was a report that happened before or after the election, and and it did have some things to say about the effectiveness of this pilot, and especially because it seemed that many of the small businesses who used the financial counselling involved used it for assistance relating to the impact of COVID on their small business rather than natural disasters. But we recognise that there's a need for this kind of service out there, and we're working through that with the providers at the moment, but I wasn't aware of that.
Thanks. I'll be watching that process, and my final topic, and then I'll get out of your hair. What we're currently seeing, particularly along the Murray River and the associated tributaries, we've now got the Disaster Ready Fund, pending a report from a Senate committee and its passage through the Senate. The Disaster Ready Fund, which will provide $200 million per year ongoing for mitigation and resilience projects, including, and some of the examples that have been put is flood levies and helping towns prepare for floods and improvements to public infrastructure. So on the one hand, we've got $200 million a year for that. On the other hand, we've got an undisclosed sum of money to further buy back water in the Murray-Darling Basin in order to achieve outcomes under the Basin Plan, one of which in the original modelling is to deliver managed flows of 80,000 megalitres a day, 2 years out of 10, given that flows across the South Australian border reached 80,000 megalitres a day on the weekend, and we've had flooding in Rochester. Echuca Moama have the highest flood since the early 90s. Deniliquin has had its highest flood since the 90s. Is part of the Disaster Ready Fund going to be used to mitigate against what could potentially be man-made floods that is being striven for under a different section of government policy?
Well, I'm having a bit of trouble seeing the link between the Murray-Darling Basin funds and the Disaster Ready funds, and obviously there's another committee for you to be able to ask questions about the Murray-Darling Basin plan.
Yes, I believe you're repping on that committee, so
you'll
be prepared with good
I haven't
answers.
heard that, but maybe someone's got some good news for me. All I can really comment on is the matters within our portfolio. So the Disaster Ready Fund, as you said, is available for up to $200 million a year to invest. And I've given examples in the past, like what you've said, flood levies, drainage improvements, but we are yet to prepare the guidelines for those funds. There'll be consultation on that, which will result in decisions about what it will be used for.
And you've also put money aside to work with the insurance industry with a view to share data, and sort of the implication is maybe reduced insurance premiums, which would be gold if that did occur. I would also be very fascinated to understand whether that data sharing will also include looking at the proposed flood levels that may be achieved under other areas of government policy and the impact on insurance premiums along sections of the Murray River that may be impacted.
Senator, I think we all recognise catchment management, and especially during floods, is a really complex issue. Disaster management, disaster risk reduction is but one element of that. There are certainly other elements, land use planning, the built environment, and a whole range of other elements. The solution to this is taking that integrated approach and having all the stakeholders around the table in terms of determining what are the best outcomes that we need for a particular community, recognising that they are quite different. And when we were in Dubbo the other day, where we're talking about releases, we're hearing about releases from the dams, how the town was saved, but downstream, the irrigators and also the primary producers were impacted by the releases from those dams. So getting the balance right is a real challenge. The insurance sector and having an understanding of risk and hazard, their level of granularity of data will certainly inform some of those solutions, but it will require many people around the table, local governments, infrastructure owners.
The MDBA and Water New South Wales.
Correct.
Thank you very much, Chair.
Thanks, Senator Davies. Senator Patterson.
Thank you, Chair, and I am mindful that we are over time, and so I'll try and be as quick as possible with my questions. I'm interested in this statement made by the Minister for Home Affairs in question time on Tuesday, that she has asked her department to activate the National Coordination Mechanism to coordinate the work that's been done on the Medibank attack. Before I jump into it, this is the right place to ask these questions.
I was wondering that myself, but I think it is. Yeah.
Right, thank you.
Given it relates to the National Coordination Mechanism.
Yeah, thank you, Minister. What happens next after the National Coordination Mechanism is activated? What's the process?
Senator, if I can hand to Deputy Coordinator General Mr Buffoni, who manages this process.
Thank you.
Thank you, Coordinator General. Thank you, Senator Joe Buffoni, Deputy Coordinator General of the National Emergency Management Agency. Senator, what the National Coordination Mechanism does, it brings all the relevant stakeholders together to step through what they understand, again, is the existing situation, what are the potential consequences, what harm that could occur, and then what happens is both departments, the organisation that is actually that has been impacted, and also states and territories then start looking at what they do within their organisations, within their departments to mitigate certain actions. So the work then continues on, and then the National Coordination Mechanism brings them back together and then basically coordinates and synchronises those actions. But it is only dealing with the potential consequences only, none of the other elements of that element.
Okay. What is the process for the Minister to make this decision? Is it a power that's vested in the Minister, or is the Minister required to seek Cabinet or National Security Committee Cabinet approval?
No, the National Coordination Mechanism is part of the Australian Government Crisis Management Framework. So it's actually embedded as part of that framework, and a department, so a minister, the department, a state or territory, or even industry could ask that a National Coordination Mechanism be activated. In this case, the minister requested it.
Presumably, though, a private company can't commission this process to begin. They could request it, but the decision maker would be the Minister.
Correct.
And does the Minister consult the Prime Minister or any other colleague before doing so?
I'd have to refer that to the Secretary.
I think, Senator, it might be best to divide our giving of evidence into two components. Unlike the circumstances that have been canvassed this morning in relation to floods or matters that would say pertain to bushfires, where the Coordinator General both has a facilitating role through the auspices of the NCM, but is more directly involved in dealing with the incident and the consequence. In this case, as would be the case, say with the pandemic, where we activated the NCM as well, NEMA provide an established, enduring, connected, consistent and repeatable facilitation process for other parts of government to use. So it was at our request, the Department of Home Affairs, through our Minister, saying we think this Medibank matter has gotten to a point where the consequences are going to spill over into so many different parts of government. They're going to touch on questions of digital identity, consumer protection and the rest of it, that, and I can speak directly to this because I've got personal knowledge, the Minister and I canvassed the best way to deal with those consequences. I advised her that the evolution and the maturation of the NCM over a period of several years, obviously we went through a lot with the pandemic, it's a very well-established process, meant that outside of the strict technical response to the actual vulnerability that had been brought to light in terms of the breach, which is a matter for the Australian Cybersecurity Centre, and Ms Bradshaw and her staff, with whom we work very closely, are dealing with the incident.
Understood.
But to take the pressure off them having to deal with all sorts of other questions like, you know, are my sensitive personal health details going to be put on the dark web? Home Affairs leads on consequence. I spoke through our staff arrangements. We engaged with the Coordinator General and his staff. We said we're at a point now where the thresholds have been reached under the Australian Government Crisis Management frameworks. I consulted with Minister O'Neill. She endorsed that course of action because the consequential impact was getting to that point. And Mr Buffone, at our request, activated the NCM. You asked about whether the Minister conferred. I'll just need to check directly with her and personally with her as to whether she wishes to add anything. But she was certainly leading the whole of government, both incident response and consequence response. And I know just from being part of that process through many long days and nights, she was engaging collaboratively across government.
Okay. Which other departments or agencies of government have been engaged as part of the process?
I might, Coordinator General, if you're agreeable, on the question of Medibank itself, the cybersecurity coordinator who deals with matters outside of what Ms Bradshaw and her technical team do over at ACSC, that function is vested in the department, and Mr Ablong is the Commonwealth cybersecurity coordinator for consequence management purposes. It might be best, if you're agreeable, Senator, and through you, Chair, if we deal with it through the departmental outcome that deals with cybersecurity, and in questions regarding the mechanics and the logistics and the practices and processes of the NCM are best directed to Mr Buffone.
Okay, all right. Well, so you're not able to tell me now which other departments have been brought in to be part of the NCM? You don't know, Mr Buffone?
Senator, pretty much the majority of the Australian government departments. So I can't list them exactly, but Attorney Generals, AFP, Industry, Services Australia. They're just some examples, but it was quite widespread.
But perhaps on notice you can provide a full list. That's adequate for now. Thank you. The Minister said on Tuesday that the NCM has met 3 times. Is that still accurate, or has the NCM met further times since her statement?
It's met 3 times in total, Senator.
Okay, so up to Tuesday it met 3 times. Could you provide on notice who attended those meetings?
Yes, Senator.
Thank you. Of those attendees, though, I'm interested, does the Secretary of the Department or the Minister ever attend the meetings?
The Secretary and the Minister did not attend, but the invitation was there should they choose to.
It's certainly the case of the department. Empowered senior officers attended, and they, in both cases, Mr Ablong and or Mr Dowling, and we can hear evidence later under program 1.3 of outcome 1. I can assure you, Senator, they kept the Minister and I very intimately involved in terms of being informed about developments, and she was able to take decisions and take action as required.
Can I just add something, Senator Patterson?
Sure.
From my perspective, the NCM obviously operates in a range of circumstances, including cyber matters, obviously also natural disasters, and it's quite uncommon for a minister personally to attend those meetings. So there's nothing unusual in the Minister not attending, and as you heard, Mr Pizzullo was saying that she and the Secretary were kept very well informed.
Sure, I wasn't seeking to suggest that, I was just curious. NCM is obviously also the coordinating response and recovery agency for the flooding. How do you prioritise between these 2 crises, which are concurrent, a very serious cyber crisis and a very serious flooding crisis?
Yeah, the system is designed in that way, Senator, as I said earlier on, that we can scale up. So, and the other thing is that the NCMs are co-chaired as well, and therefore, as the Secretary said, Brendan Dowling was the co-chair of that, so taking a lot of those very technical elements of it, and we provide the facility to make sure that the NCM, the invitations, the agendas, and then the expertise about actually running the NCMs. So it's simply a matter of prioritisation. Senator, since the NCM was initiated, we've run about 440 odd for which picked up COVID and a range of others, so it's a well-versed machine.
I should add, just so that the committee's informed as to who individual public servants are, Mr Dowling is the Deputy Cyber Coordinator within the department.
So effectively you've got separate NCMs meeting in parallel, dealing with separate crises. Are there any officials who are sitting on both or members of both?
So the NCM does not have a sitting membership. What happens is respective officials or even industries are invited when they have equity in understanding what the problem is and also in the solutions.
Don't get hung up on my definition of membership. I just mean participation or attendance. Are there officials who are attending or participating in both?
Yes, they are.
Could you give on notice a list of the officials who are participating in both simultaneously? Thank you.
Sorry, Senator, if I could just clarify, they're not like simultaneously. So obviously we sequence them, and as I said, prioritise.
Oh yes, I don't mean literally meeting at the same time. I just mean they're concurrent disasters which you're dealing with. Yep, understood.
It might be worth, Mr. Buffone, adding for the Senator's edification and benefit, and for the committees, the NCM, when we refashioned some arrangements at the start of the pandemic with the concurrence of the then government, we very explicitly decided to drop or avoid any reference to committee, because that immediately gives rise to, well, who's the member, who's a standing member, who's a co-opted member. It literally is a service that the now NEMA, previously EMA, provides. I think it's fair to say, Mr. Buffone, that you are the common peg for the, if I can use that term, you're not a peg yourself, but your office pegs the function, and it literally is who needs to be at the meeting to solve this problem under the auspices of a facilitation provided by NEMA, but NEMA are not responsible for its governance other than its convening. The lead agency, in this case cyber, is a matter that rests across Home Affairs, AFP and ASD. We take the actions, we hold ourselves accountable. We don't put it back on NEMA to say, well, you run that committee, you're responsible for the action. So the reference to mechanism as distinct from committee is something that I just draw to your attention.
Thank you for that clarification.
Thank you.
Other than COVID, floods and now Medibank, have there been any other crises which the NCM has coordinated?
There's been several, Senator. The AdBlue shortage, so when AdBlue, rapid antigen tests, when there was a shortage on that, when we had the South Australian flooding and the north-south and east-west rail line, the north, south and east-west rail lines were taken out, and Stewart Highway, which had significant supply chain impacts to Western Australia and the Northern Territory. And then, as you've heard, on the recovery matters that we're dealing with right now, also on the March floods, on recovery matters in particular around temporary accommodation and workforce. Also, in relation to COVID, dealing with grocery supplies and a range of policy matters that were affected by COVID. So it has a significant list of different types of hazards and issues that it's dealt with.
Thank
Senator
you.
Patterson, do you have many more questions on this
maybe
block?
2 or 3, which I'll be...
I'm seeking to hand the call over. The government senators have had the last sort of 25 minutes, so can we do that shortly and have to come back to you if you've got further questions?
Thank you. Who decides when the crisis is resolved and the NCM is no longer required? Who's the decision maker for that?
Well, there isn't really a specific decision maker, Senator, for that. Basically what happens is, and the key thing in particular at the Commonwealth level, it is very much focused on coordination and collaboration is the focus, and we run the continuum. So as you've heard, we do operational preparedness, then there's dealing with the response, we transition through to recovery. I work with my colleague here in states and territories around when that cuts over, and it's generally on. So when there's no immediate emergencies, there's no rescues, there's less urgent requirements, then we transition into the early recovery phase, and in some instances, some of the communities now are in that phase.
Yes, look, I'm just mindful of the time and the Chair's admonition. There must be a decision maker though, right? Someone has to say, right, maybe it's you provide advice to the Minister and say, I don't think the NCM is required anymore for this crisis. Who says, yep, agreed, let's wind it up?
Well, it's not. It doesn't quite operate like that, Senator. It doesn't sort of like it deals with a specific matter, a specific problem, and then if that problem gets mitigated, stabilised, that's the decision-making point. Obviously, advice is provided to the Minister.
Yes, I know. Sorry, Mr.
Sorry. Well,
who decides?
well, it's quite often either in the current arrangements through the Coordinator General, but quite often it's myself working with other officials across the Australian Government with the advice to the Minister.
Okay, so at some point you'll say, I think we've dealt with this Medibank issue sufficiently, we don't need to meet any further.
Just in relation to the Medibank issue, as the Secretary said, not my responsibility to call that. It will be, Mr. Ablong or the Secretary or the Minister that will be advised separately. The role of the NCM is to provide that mechanism to problem definition, what are the potential issues and lines of effort to mitigate.
So in this instance, it'll be the Minister or the Secretary or the Home Affairs Department that will say, I think we've adequately dealt with this issue.
Yes, correct.
Okay, thank you.
Correct.
And so just my final question then is, unfortunately, I think cyber attacks are going to be frequent in the future. They're not going to go away. And you have limited resources as an agency, finite resources. What is your mechanism for prioritising if you're dealing with multiple competing crises? How do you order your priorities?
Well, again, right now, the way that we operate, and we have a prioritisation protocol, which is life is number one, so matters that relate to life, that relate to injury, that relate to property. The urgency of those matters as well is the priority, and then obviously we start to get into matters of environmental, etc.
Right. So how are they presently ranked?
Well, starting with life.
No, the current crisis you're dealing with. Is Medibank number 1, 2, 3? Is the floods number 1, 2, 3?
Oh, well, right now the floods are number one right now because we've got people displaced. We've had 6 fatalities. We've got still a whole range. That we're still in the response phase. So that's number one. And the Medibank one is still fitting within that priority range. But number one is the floods at the moment.
So Medibank is number 2.
Well, I think it wouldn't be appropriate to characterise it like that because that batting order doesn't take account of the fact that the MCM itself can be bolstered. So in the case of cybersecurity, we have staff who are dedicated, whose day jobs it is to deal with cybersecurity. They augment, so it's not as though you've got a fixed allocation of, say, 100 units of effort within NEMA, and the Coordinator General then has to say 1, 2, 3, 4, I'm going to move my 100 units. If you've got a flood, a cyber attack on critical infrastructure, a major data breach, we might plus up or aggregate his capability by pouring additional staff in.
Indeed, but even with those additional resources that you would provide, even your resources are finite. So
all resources in life are finite.
Indeed, and that's
Senator
my point.
Patterson, I think you've stretched that last question into about 5 last questions.
If the question was answered when I asked it, I'll be able to finish it at one.
Well, Senator Patterson, if you want to ask one last question to
Thank you.
clarify.
So if I can directly answer your question, I think in the terms that you're seeking to address, the department, along with our colleagues in ASD and elsewhere, in this area of cybersecurity, I'm not going to speak to floods and cyclones and other things, but certainly in this area, given the vulnerability of interconnected systems, given the frequency and the tempo that, as you say in your question, of these breaches, the Minister and I are giving thought to structure, capacity and capability, and whether we need to assign even more resources, not so much to bolster NEMA as an agency, but those fly-in resources that can come in. And similarly, I'm sure my colleague in the Department of Agriculture is thinking about biosecurity hazards. I know my colleagues in the Department of Health are. So as we build out capability, the idea of the NCM is always to be able to bolster so that the fine, hard-working staff of NEMA are not having to prioritise in that zero-sum way that was premised in your question.
Okay, thanks, Chair.
Thank you, Senator Patterson. I'll hand the call to Senator Shoebridge and then we'll come to Senator Scott. Noting the time, Senators.
You don't need to come to me. I'm done.
Thank you, Senator Shoebridge.
Mr Moon, I heard your evidence earlier about requiring multiple stakeholders to be consulted, particularly to deal with flooding risks within a catchment. I assume that includes state governments and state government planning authorities, is that right?
Correct.
So can I ask you about the catchment that has been described by the Insurance Council of Australia as Australia's largest flooding risk, which is the Hawkesbury Nepean catchment. Have you had engagement with the New South Wales Department of Planning about their plans to expand the number of housing subdivisions and therefore properties exposed to flooding risk in the Hawkesbury Nepean Valley?
Senator, I have not had any engagement with the Planning Council. Since my arrival at NEMA 3 weeks ago, I've been very, very much focused on this existing flood event. But certainly the process moving forward in terms of managing flood risk, we will rely very, very heavily on engagement with all of those people who are involved in catchment management.
Well, rather than you, what, if anything, has your agency done to prevent the New South Wales Department of Planning approving additional subdivisions and additional housing units, and we're talking tens and tens of thousands of additional housing units, smack bang in the middle of what the Insurance Council of Australia has described as already our largest floodplain at risk of inundation and damage?
The National Emergency Management Agency does not have powers to direct any agency in terms of planning or any such matters.
Can I add something here, Senator Shoeridge? I mean, you would have seen a number of comments from me, from the Prime Minister, since we've been elected about this being a really serious issue for the country. And one of the challenges is that the federal government has very limited, if any, powers to directly regulate the planning and development decisions of states or local governments. However, you may not have seen this, but this morning, when the Prime Minister joined the Premier of New South Wales to announce the home buybacks in Lismore, the Prime Minister also announced that he has asked the New South Wales Government to lead a piece of work to bring to National Cabinet about how we better regulate planning and development decisions.
Well, I think that's noble, but that's like putting the fox in charge of the hen house. This is the same government that's in the middle of approving literally tens of thousands of additional subdivisions, smack bang, in Australia's most at-risk floodplain.
Well,
you'll be buying them back next.
No, well, that's exactly what we're not going to do. And on that, one of the conditions around the funding of these buybacks that's now going to be happening in the Northern Rivers is that a parcel of land or a building that is bought back cannot be then used to rebuild on. But more broadly, the first point I'd make about the request that the New South Wales Government lead this work is that obviously whatever decisions made are a matter for National Cabinet, not just the government leading the work, but also I would argue that it's a good thing to put some responsibility on the New South Wales Government to make some good decisions here that can be then discussed at National Cabinet.
But don't you acknowledge the perverse outcome? You've got the federal government buying back flood-prone housing in and about Lismore.
We're jointly doing that with the state government.
With the state government. Yep. Meanwhile, that same state government is approving more flood-prone housing in Western Sydney, which they know will be inundated, that Infrastructure New South Wales has told them will be inundated. And that's happening at the same time.
Well,
don't you see the irony or the disjunction in that?
I actually think it's a good thing to have the New South Wales... Well, if you let me finish. I think it's a good thing to put some responsibility on the New South Wales Government to make some good decisions here and to bring forward a piece of work for consideration by National Cabinet. I'm not aware of any federal government that has ever asked any state government, in particular the New South Wales Government, to do some really serious thinking about these issues, and now they are.
You understand, don't you, that the primary flood mitigation measure that the New South Wales Planning Department and New South Wales Government is doing for new housing is to make the new housing more resistant to being inundated. It's not about not building it there, but the people you've asked to lead the national inquiry, their main flood mitigation measure is to build the housing, but make it more resistant to inundation. You don't see a problem with that?
Well, not having been a member of the New South Wales Upper House for many years like yourself, I'm not intimately across the details of New South Wales planning schemes.
The Prime Minister's made a national announcement with these people. Surely you did your due diligence before you made the national announcement.
As I say, I think it's a good thing to have the New South Wales Government lead a piece of work where they have to take responsibility for putting forward suggestions about how to do this work better. And that will then be discussed by National Cabinet. What they put forward may be approved, it may be amended, that'll be a matter for National Cabinet.
Well, if it's been led by the New South Wales state government, well, heaven help National Cabinet.
Sorry, Chair, can we try and move. I know Senator Shoebridge is making some political points, and he's every right to do that. But this is Commonwealth
there are
estimates
tens
as
of
opposed to New
thousands.
South Wales. You've made your point well, Senator Shoebridge. I'm just looking at the clock, and we've got an agreed program, and I'm keen to get on to cross-portfolio as soon as we can.
I'm in no hurry.
Thank you. I think that has concluded that line of questioning and questions for the National Emergency Management Agency. Thank you for your time today. I now call on officers from the Department of Home Affairs, including the Australian Border Force, in relation to cross-portfolio corporate and general matters. I think we'll suspend the hearing for a very short period to allow officers to come to the table. Yeah. Hearing there, because I understand, Mr. Pizzullo, do you have an opening statement you would like to make? If we could keep that fairly brief today.
I do, Madam Chair, and I've written it rather brief. I've written it to be brief.
Thank you, Mr. Pizzullo.
Do you mind if I?
No, go for it.
Yep. Thank you, Chair. In the interest of time, I'll proceed.
Very brief, thank you.
Thank you. In line with the government's focus on immigration as a nation-building function which supports economic and social policy objectives in relation to Australia's prosperity and cohesion, and with the support of the Secretary of the Department of the Prime Minister and Cabinet, and with the strong endorsement of the Ministers for Home Affairs and Immigration, Citizenship and Multicultural Affairs, I've established the position of Associate Secretary Immigration, who is the second most senior officer in the department. I'm pleased to be able to inform the committee that Ms Stephanie Foster, PSM, has agreed to take up the position and indeed commenced with us on the 10th of October. The Associate Secretary will lead the existing Immigration and Settlement Services Group, as well as the recently established Immigration Reform Task Force and the People Smuggling Policy and Implementation Task Force, which works very closely with OSB and its joint agency task force. I refer the committee to the recently published 10th edition of the department's publication known as the Administration of Immigration and Citizenship Program report. The report highlights efforts underway in the recovery from COVID-19 to enable more people to enter Australia and address critical skills shortages while simultaneously addressing the visa backlog. In particular, I wish to draw attention to data which shows that from 1 June to 30 September this year, the department finalised close to 2.29 million temporary and permanent visa applications, including nearly 1.45 million visitor, student and temporary skilled visa applications. To ensure that we are organised to deliver on the government's policy agenda, the department will undergo a significant restructure on 1 November, which is next Tuesday. In addition to the establishment of the position of Associate Secretary Immigration and the aforementioned Immigration Reform Task Force, I've decided to establish a Strategic Initiatives Group under the leadership of Deputy Secretary Mark Ablong. He will lead a number of task forces which will focus on longer-term initiatives in the areas of cyber security strategy, national resilience as it relates to natural and other hazards, I should say, and the protection of our democracy from foreign interference and other threats. Following amendments in the last Parliament that were made to the Security of Critical Infrastructure Act 2018, implementation of the new regime is well underway. The mandatory cyber incident reporting obligations and the Register of Critical Infrastructure Assets obligations have commenced, and the Risk Management Program obligation is out for consultation, as is required under the Act. The Minister for Home Affairs has also designated 82 systems of national significance under the Act. This will trigger associated enhanced cybersecurity obligations for some designated systems, which are being worked through by the department in consultation with affected parties. Noting that this is the department's first appearance before this committee since the recent machinery of government changes, I welcome, and indeed we've just heard from them, the National Emergency Management Agency's inaugural Coordinator General, Mr Moon, to the portfolio. As you know, on 1 September this year, the National Recovery and Resilience Agency, known as NRRA, was merged with EMA to form a new executive agency in the Home Affairs portfolio, known, as you know, as the National Emergency Management Agency, NEMA. The Coordinator General commenced in the role on 6 October, as you've just heard. I wish to assure the committee that other recent machinery of government changes, which were related to law enforcement and criminal justice matters, have had no adverse impact on cooperation and integration of effort across the areas of activity which fall under the oversight of the Counter-Terrorism Coordinator, Deputy Secretary Andrew Kefford, the Counter-Foreign Interference Coordinator, again Mr Kefford, or the Cyber Security Coordinator, Mr Ablong, who will continue in that role after he takes up the Strategic Initiatives role that I mentioned earlier. Finally, for the benefit of new members of the committee, I should like to very briefly explain governance arrangements as they relate to the Australian Border Force, the ABF. The ABF Commissioner is a statutory office holder who is operationally independent, who also holds the office of, who holds the role of Controller General of Customs under that Act. As the Secretary of the Department, I am the accountable authority under the Public Governance Performance and Accountability Act, or the PGPA Act, for the ABF. The Commissioner oversees day-to-day operations of the ABF, including implementing Australia's border enforcement policies and managing maritime frontline border law enforcement and customs activities, and the Department provides corporate and other enabling services to the ABF. It would be convenient, if it pleases the committee, if questions regarding the ABF, including Operation Sovereign Borders, be dealt with under Outcome 3, at the start of which the Commissioner would, I know, appreciate the opportunity to also make an opening statement. Thank you, Chair.
Thank you. And just before we begin, I just want to remind senators we had a very short amount of time allocated for cross-portfolio matters this morning. We will have the opportunity to ask Minister, the Secretary and officers questions about Outcome 1, Outcome 2 and Outcome 3 throughout the day. So if we could restrict our questions to those matters. I give the call to Senator Scarr.
Thank you very much, Chair, and thank you, Mr Pizzullo. And can I thank whoever prepared in the department your helpful aide memoir in terms of which questions fall into which outcome. That was very useful. In your opening statement, you referred to Ms Foster joining the department as an Associate Secretary, and again the department was very helpful providing this organisation structure, and which has Ms Foster on it. At the moment under this structure, Ms Foster is sort of self-contained as her own blue cell, but which parts of this organisation will now be reporting to Ms Foster?
I'd have to check the date for version control reasons, the date of the document you've got. When she first joined us some weeks ago now, she had a standalone role, just as she learnt the ropes very quickly. She and I decided with the retirement of another Deputy Secretary that she would come on and take on line responsibilities sooner than we originally had planned, and she's now responsible for the entirety of the functions that I described. In other words, if you look at your organisation chart, and again I do apologise, I don't know which version you've got in front of you, the totality of Immigration and Settlement Services Group, formerly under Ms Moy, who his last day in the public service in fact is today. She's down in Melbourne appearing before the Disability Royal Commission, the People Smuggling Policy Task Force, and a newly created Immigration Reform Task Force. So those entities that I mentioned are all under Ms Foster's remit, and a new organisational chart will be released, or in fact perhaps has already been released to our staff, ahead of the formal standing up of those new structures on the 1st of November. But I can come back to the committee with an updated organisational chart.
Yeah, that'd be helpful.
The one that you've got seems tabbed and annotated, so it might be a few days or indeed a few weeks old.
Well, your description's been very helpful as always. What's the difference between a Deputy Secretary and an Associate Secretary?
So an Associate Secretary, and there are a number across the Commonwealth, and it was an office introduced, as I recall it, in the late 80s, typically is a very senior officer with greater seniority than a Deputy Secretary, but not of the same rank as a secretary. A secretary is a statutory office which is described in Section 57 of the Public Service Act. We've got certain roles and responsibilities that we perform pursuant to that section of the Public Service Act. A Deputy Secretary, or indeed in this case an Associate Secretary, is a member of the public service at large, or the Australian Public Service. Their roles and functions are regulated by the Public Service generally, so it's really a question of rank. They are more senior to a Deputy Secretary, and where they are employed typically, there's typically one of them in a department, so the Defence Department has one, as I recall it, the Foreign Affairs and Trade Department has one, and they are typically the second most senior officer in the department.
So Ms Foster will report to you?
Yes.
She will. Okay.
Yes. And I continue to hold, under the PGPA Act, the Act that I referred to in my opening statement, I retain the legal responsibility of being the accountable authority, which is a formal legal concept described in that Act for the entire department.
Okay. I'd like to move on to your annual report, which I've read in detail, and congratulations to everyone who was involved in preparation of the annual report. Just one opening comment before I go into the machinery of government changes, and that's in relation to the performance results description on page 33. I note that there's a description in relation, you provide the percentages of where the metrics required have been met or partially met, but you don't specifically, or the report doesn't specifically refer to the percentage where it wasn't met. But having said that, my reading of the performance results is that in those areas where the metric wasn't met, it typically was as a result of COVID, the impacts of COVID, or there was some pretty absolutist benchmarks, 100% performance, and you were just a shade under that in a few cases. Just from, is that a pretty credible representation of how we should interpret the performance results at large?
I judge it to be. I might just ask Ms Sharp, our General Manager for Executive, who reports to me on governance and performance reporting. I just might see if Ms Sharp has got anything to add. But while she comes forward, it is the case that we follow the relevant style and other guidance that's provided in the relevant manual for the preparation of annual reports. I take that to be the case, Ms Sharp.
That's correct. Sophie Sharp, Group Manager, Executive International. And Senator, in relation to your question, that is an accurate representation. The majority, well, a lot of the metrics that were not met were as a result of challenges experienced during COVID or actual specific instances which are described.
Yeah, okay, that's fine, Ms Sharp. Mr Pizzullo, in terms of the portfolio itself, and I've been on this committee some time, as you're aware, you've in the past described the department as a department for the times. What did you mean by that when you made that statement in the past?
It might be said that there was a degree of flourish perhaps in that phrase. I can't quite recall whether it was a prepared written statement.
No one would ever accuse you of that, Mr Pizzullo.
Doesn't sound right.
All departments for their time, and they evolve and adapt over time, and matters under the administrative arrangements orders either come into a Department of State and are scheduled by His Excellency the Governor-General in those orders. In other cases, matters depart a Department of State and move to another department. So at any one time, the Prime Minister of the day, who of course advises the Governor-General in the making of those orders, or that order I should say, singular, has a view about how to arrange their administrative machinery.
But from your perspective, in terms of looking at the period covered by this annual report, the department was working well, and the structure itself, and I can take you to specific examples where you've referred to the benefits of the structure during the period in which this annual report covers. The structure in itself promoted cooperation and integration of the various functions of each of the agencies within the department. That was the case, wasn't it?
And I would hold that continues to be the case. It was the case when I made those statements, and that case continues to hold now.
But the difference in the position now is, if one turns to the Home Affairs portfolio, as it was outlined in your last annual report, and there were seven elements to the portfolio structure. Department of Home Affairs, Australian Border Force remain as it is. The Australian Transaction Reports and Analysis Centre, that's no longer within the department, that's correct?
It's not associated with the portfolio, that's right. It was never a part of the department, just to be strictly legally correct.
Yep. ASIO remains. The Australian Federal Police, they no longer remain.
Has transferred to the Attorney General's
It's transferred to the Attorney General's Department. The Australian Criminal Intelligence Commission, they've been transferred out as well.
That's right.
And the Office of the Special Investigator, they've been transferred out as well.
Those four components, yes.
Right. So what input did you have as the Secretary, and what input did the department have with respect to the decision that was made to materially change the structure of the department?
What input? Was that the question?
Yes.
None.
You had no input?
Well, these are matters that preserve the Prime Minister. They're typically, in my experience, after a very brief 35 years doing this, typically the Department of Prime Minister and Cabinet would advise the Prime Minister on the design of his or her government, and it's very much in the personal remit of the Prime Minister to shape their government as they see fit, and obviously he or she, as the case may be, gives advice to the Governor-General in Council, and the order is adjusted accordingly, either after an election or as a consequence of a reshuffle or during the course of a parliamentary term.
So there was...
It's not unusual. In fact, I think it would be unusual, to be perfectly blunt about it, with the exception, there are exceptional cases. So Mr Turnbull in his memoirs, for instance, speaks about the rationale and the thinking that he gave to the personal decision that he made to create a Department of Home Affairs, or indeed recreate it. We're one of the foundational departments of the Commonwealth, having been first established on the 1st of January 1901 as the third department in order of precedence. So when Mr Turnbull made the decision through the course of 2017, he chose, because it was a very significant reordering of across many portfolios, to reach out and to engage in consultation. But in my experience, after 35 years of being a public servant and being in this town, it's in fact it's unusual for there to be extensive consultation, because bluntly, to be quite candid about it, people are going to have different views about what works. If you end up consulting, you're never really going to get a solution that ultimately you're accountable for as the Prime Minister to get your government arrangements fit for purpose in the way that you want to lead in machinery terms, and it's very much a matter that should be the personal preserve of the Prime Minister, taking such advice as he might take from the Secretary of his department. So I find it neither unusual nor indeed would I recommend that practice be changed.
But just in terms of the facts, just to be clear, you weren't consulted as the Secretary of the department with respect to the costs, the benefits of a change, given your 35 years ago? You were informed?
I was informed.
You were informed.
But again, I want to stress contextually that I don't find that either unusual.
No, you've made that point, Mr Pizzullo. You've made it very well. No one in the department was consulted, to your knowledge? None of the deputy secretaries?
I would doubt that very much, and if they had been, I'd be surprised if they were to subsequently say after this evidence, oh, by the way, I was consulted. So right. I doubt that very much.
And just to be clear, none of the agency heads who are impacted by this material change in terms of machinery of government, none of them were consulted?
You would have to ask them, I don't know.
But to your knowledge, none of them were consulted?
To my knowledge, no. And again, I'd be surprised insofar as these are matters that very much are in the personal preserve of the Prime Minister of the day.
And from your perspective, it's early days yet in terms of the change, the machinery of government change. From your perspective, what were the benefits over your prior to the change, over the period covered by this annual report, of all of these agencies being within the same portfolio structure? In your experience, what were the benefits of that?
Just to be clear, because I'm going to answer the question in a particular way, but before I do it, what are the benefits of the previous architecture?
What were the benefits of the previous architecture from your perspective of the Secretary with responsibility from the department?
Well, having given a number of opening statements and given evidence, otherwise I'll refer you to those, and if it assists you, we'll get those extracted. But in terms of the suggestion of whether this structure compares favourably or unfavourably.
Well, I'm not talking about this structure, I'm
But
talking
you're
about the
not- okay.
past. Let's focus on the benefits of this department was set up, and you and your colleagues produced some very helpful documents about the tracking the years of the department, the structure, and there's a consistent theme throughout those documents with respect to, and I'll just quote from the Home Affairs, the 4th year report, where this was from the agency heads forward, so presumably this expresses the view of all the agencies.
Yes.
Where it was stated in the 3rd paragraph, I quote, the portfolio structure, and I know you don't use words lightly, the portfolio structure continues to bolster our strategic planning and coordination capabilities, facilitates greater information intelligence sharing and enlivens opportunities to streamline common administrative functions. In doing so, we remain focused on the delivery of our collective operational priorities, end quote. So could you just expand on those, on the benefits of the portfolio structure before the change in structure under the current government?
Well, the benefits are really, as can be inferred from that statement, that it enabled, in that circumstance, the ability to collectively plan resource sharing and the like, all the elements that are contained in that statement, and it's not a statement that I would resolve from. It was accurate at the time and continues in a historical, as a historical reference point to have validity.
So isn't the corollary of that if the previous structure actually bolstered strategic planning and coordination capabilities, etc., as stated in that 4th year statement, isn't the corollary of that any departure or a material departure from that structure, and this is a material departure, as we've noted, there's no less than 4 agencies being shifted out from the portfolio, isn't the corollary that will actually have a negative impact in terms of those capabilities, or at the very least won't have a benefit in terms of promoting those objectives?
No, it doesn't follow necessarily, because there's another factor that needs to be put into that equation when you seek to draw an evaluation along those lines, and that is there's a higher order question of how the government of the day, and before I expressed it in earlier evidence, I expressed it as being ultimately the preserve of the Prime Minister, how to balance competing approaches to how to govern. So if the view that you take, and I'm not going to express an opinion on this, it's not my job to, it's my job to explain.
I'll ask the Minister in a minute.
He might well want to address this point, but if the view...
Senator Scar, you're getting close to having your last question in this block as well. Thank you.
If the view, Senator, that one takes is that the administration of justice, the administration of the criminal justice system, particularly the oversight of law enforcement, is better vested in the first law officer, for instance, if that is your organising principle that you start with, then that is the design principle that then would animate a decision to say, well, a number of these functions then are better in that vertical sense that our Constitution requires, where ministers are appointed to administer departments of state. It's better to shift those functions over here. But it doesn't detract from the horizontal collaboration and ongoing integration of effort, irrespective of, if you like, portfolio boundaries, which perhaps not in the way that would have been required in 1901 when the Constitution was activated, having been drafted in the 1890s. But now, wherever you place a function, horizontal integration of effort, coordination, collaboration is an absolute necessity. We just heard earlier from our colleagues in NEMA, everything is done through horizontal partnerships. So really, the starting point has to be, where does the Prime Minister want to place, if you like, the responsibility for accounting, for instance, to Parliament? That's the starting point. You vest agencies' functions and powers in those vertical columns, and then you expect your ministers, your secretaries, your heads of agencies to put in place compensating or adjusting, offsetting arrangements to ensure that horizontal collaboration is still a feature of the government. And I can assure you this is not an opinion, it's a statement of fact. It's in my opening statement that there's been no adverse impact on what I would describe as that horizontal integration of effort, notwithstanding the movement of some of those functions that are represented by those agencies, but not just the agencies, Senator, also the movement of functions like oversight of the criminal code, for instance, the powers part of the criminal code as opposed to the offences part that was formerly vested under the previous AAO, under the Minister for Home Affairs. By shifting that to the Attorney-General, What the Prime Minister is indicating is I want that minister to take responsibility under responsible government for, if you like, and I'm going to use a sort of management term here, for that vertical accountability to the Parliament. But I still expect there to be no gap seams or problems caused by, if you like, the disintegration of effort across those horizontal links of coordination. And I'm giving evidence, and I know the profundity of giving evidence, there has been no adverse impact on that horizontal partnership and integration of effort whatsoever.
That's your last question, Senator Scarr.
And sorry, Chair, I should have made
the one
clear.
you're about to ask.
Well, I'm happy to. I've got a number of further questions in relation to this point, so I'm happy to go back to it if you'd like to share the call.
Senator Shoebridge is.
Sorry, I shouldn't have cleared it.
I believe you have a short amount of questions.
He recommended taking the high ground.
Right.
I just wanted to, Mr. Pezzullo, to ask you some questions about the budget, page 28 of the portfolio budget statements for Home Affairs. And I see that there's a surge, and this is for cybersecurity funding. There's a surge in this year's total expenses going from, I think, 17 million last financial year to 56 million this financial year. Is that primarily the cyber hubs?
Senator, it's been the practice of this committee, I might just get some guidance from the Chair, that under cross-portfolio corporate and general, movements of funds certainly typically are dealt with in this section. When we start to get into particulars where I might be best assisted by some of my officers, in this case cybersecurity being program 1.3,
I intend to drill down more in cybersecurity. I just want to get the general nature of what that increase is.
Well, I prefer to deal with that with both my CFO and my cybersecurity coordinator by my side. So, Chair, my preference would be, if it's agreeable to the committee, to deal with that under program 1.3.
And if it assists Senator Shoebridge, the less questions you ask in this section, the quicker we can get to outcome 1.
Oh no, I was hoping
So you
to
can
use
ask
some
those
of this to preempt the question and structure the question in outcome 1. But I might hand over to my colleague then, and I'll drill down in this in outcome 1.
Senator McKim, you have the call.
Thanks, Chair. Good afternoon, folks. Thanks for coming in. I wanted to ask some questions around the process for awarding contracts and tendering. Is that do you have someone here who could assist you with that, Mr. Pezzullo?
Certainly, Senator. In terms of general, to be consistent with what I've just said to Senator Shoebridge, in terms of our general governance of contracting and procurement, this certainly is the area to consider that. So the Chief Operating Officer is responsible for procurement, Ms Saunders, and she might wish to be assisted by one of the division heads who particularly works on procurement. If you wish to ask about a particular contract or a particular area of expenditure, again, my preference through you, Madam Chair, would be to deal with that under the particular program.
All right. Well, how about we just head off down the track, Mr. Pezzullo, and we'll see how we go. But given that you do have some assistance at the table, hopefully my questions can be responded to. So could you just talk me through the process for awarding a non-competitive tender or a non-competitive contract, and how the Treasurer's instructions and any other relevant governance frameworks apply?
So, Ms Saunders, perhaps if you could answer the Senator's question in general terms, how procurement's undertaken consistent with Commonwealth guidelines. If potentially, let's venture a guess here, we end up speaking about contracts pertaining to, say, the delivery of services on Nauru, it might be better dealt with under program 2.4. But Ms Saunders?
That would ultimately be a matter for the committee to determine.
Quite indeed.
Yes.
Secretary, if I could, I might invite our Chief Procurement Officer to come
Yes.
into Amelia-Anne.
So the essence of the question relates to procurement without, essentially without competitive tender is the question. Yep.
Correct. Yes, indeed. I might prefer to give a general overview. Thank you.
Leanne Monterosso, First Assistant Secretary, Procurement, Property and Contracts Division.
Thank you.
If I could just ask for the question to be repeated.
I'm just
so-
after an explainer, please, of how the department goes about awarding non-competitive contracts. That is where there's no bidding process and only one entity is invited to pitch.
There are a couple of options under the Commonwealth procurement rules that the department might take a number of pathways. The first is the application of paragraph 2.6 of the Commonwealth procurement rules, which does enable the accountable authority, in this instance the Secretary, to make a decision that we don't apply certain elements of the CPRs, generally Division 2, in the instances where we need to either protect human health, national security reasons, for archaeological or artistic purchases and things like that. So that's one option that the department has used in certain scenarios. In that circumstance, under the application of paragraph 2.6, the department would then approach a certain firm to put in a quote for the works. That would still go through a value for money assessment and would still go through our standard evaluation, delegate due diligence requirements. The other option is through limited tender provisions of the CPRs, which do, there are a range of...
What's the CPR, sorry?
Commonwealth procurement rules.
Yes, thank you.
My apologies. The limited tender requirements, paragraph section 10 of the Commonwealth procurement rules lists a range of reasons why the department might undertake a limited tender, which would be, for example, it might be that we've already run a procurement process and there was no successful applicants out of that. It might be for provision of, software, things like that, where we've already made decisions. So there are a range of sections under that 10.3 which the department can utilise as well. To single source is a term that's often used as well. Again, somebody would be approached under that framework to submit a quote, and again they would go through the department's standard evaluation process to ascertain value for money, and the same due diligence checks, delegate approvals and the rest of it. But the two frameworks are limited tenders and paragraph 2.6.
Okay, thank you. And I think you said, paragraph 2.6 of what?
Of the Commonwealth procurement rules.
Of the CPR, yeah. Thank you. And I think you said the Secretary was the decision maker in the first of those circumstances. Who makes the decision ultimately in the second of those circumstances, section 10?
Yeah, so if it's a limited tender, myself as Chief Procurement Officer will determine if the justification is appropriate in meeting one of the requirements of the limited tender rules. But then it would go to the delegate itself in terms of deciding who the successful tenderer is, would be a business area delegate.
I understand that, but in terms of making a decision about whether the pathway is going to be through 2.6 or section 10, under paragraph 2.6, that's the Secretary who makes that determination, but under the section 10 pathway, that's you.
That's correct.
Yep, all right, thank you. Well, I'm going to anticipate the Chair's ruling that I can't ask about specific tenders in this area, because I can just feel the Chair wanting us to move along.
You'll have plenty of time once we get there.
I beg your pardon?
Senator Kim?
I'm sorry?
You'll have plenty of time once we get there, Senator McKim.
I believe that that we will. Thank you very much for that, and might see you back up the table a little bit later on, you never know. Chair, I'd just like to ask a couple of questions of the legal team, which traditionally we have dealt with in cross-portfolio.
Yes.
That is right, Madam Chair. That typically is dealt with as a corporate matter. So, thank you.
Thanks. So, would you like... I can see, I think it's Ms DeVoe.
Ms DeVoe is the General Counsel as well as the Group Manager for Legal Services.
All right, thanks, Mr Pizzillo, and good afternoon, Ms DeVoe. I wanted to ask about whether the department has sought legal advice or generated legal advice either internally or externally in regards to your responsibilities post the Love and Tom's case in the High Court in regards to both your responsibilities to release certain people from immigration detention and then how you deal with their status post-relief.
Pip DeVoe, General Counsel, Department of Home Affairs. Thank you, Senator. It's always been the case that if someone identifies as a person who might attract the Mabo 2 tripartite test, either being taken into detention, who already is in detention, or indeed might give rise to issues in relation to either a revocation application of a cancellation. In all of those instances, the department will generate legal advice. The legal advice has always been and continues to be tied advice, and so it's given by AGS in relation to the application of the test that's established by the jurisprudence in relation to the particular circumstances of the individual. That might give rise to a number of questions saying we might need some more information, or it might give rise to an assessment that the person should be released because it's reasonably suspected that they can't be continued to be detained, or it might be that an assessment is made that they don't reach the test. So in every instance, yes, legal advice is generated.
You might just quickly explain what is tied advice.
Sorry, I wasn't...
Just as the Secretary was reminding me that, of course, tied advice is advice under the Legal Services directions that relates to constitutional issues, and the jurisprudence in relation to Love and Tom's is one of those.
No, I appreciate that. Thanks for that clarification. But that advice, nevertheless, is sought on a case-by-case basis, Ms DeVoe, because you said that the advice pivots on the circumstances of each case. Is that correct, that you seek that advice on a case-by-case basis?
Yes.
And would it be right then to, by implication, understand that you haven't sought general advice about your departmental responsibilities post the Love and Tom's decision?
No, I wouldn't say that's a fair assessment. More general advice in relation to the status of the jurisprudence has been sought right from when the first Love and the Tom's cases were running, in relation to individual cases that might come before the court, and we still have 2 cases that are relevantly before the court, and in relation to the submissions and arguments that are put more generally around how the test is applied in those cases, and more broadly as well. So both before recent events, but continuing, we also seek general advice.
All right. Thank you, I understand. I mean, it's a fair characterisation of the High Court decision in Love and Tom's that the plaintiffs were Aboriginal Australians and therefore they were not aliens under Section 5119 of the Constitution. That's a reasonable characterisation of the decision, isn't it?
I would say no, and only because a person who identifies in terms of their indigeneity may not meet the test that was set out in the jurisprudence, which is a smaller
the
subset.
tripartite test. Yes. I mean, I'll just quote from you the High Court decision.
Yes.
The plaintiff is an Aboriginal Australian and therefore the answer is no. To the question, is the plaintiff an alien within the meaning of 5119 of the Constitution? Now, but to be clear, I'm reading out the second sentence, not the first, so I will rephrase the question. Is it a reasonable interpretation of that judgment to suggest that an Aboriginal Australian, according to the tripartite Mabo test, cannot be an alien under Section 5119 of the Constitution?
That's an accurate statement.
Thank you. So Senator Watt has told the Senate this year that 18 people have been released from immigration detention as a result of Love and Tom's. I'm not sure if anyone has an update, and I'll ask it in an outcome later unless anyone has it now.
It might be that Mr Vo can dispense with that. I mean, we're starting to verge into the operational side, but Mr.
I understand, but I just want the questions to be accurate.
And I can give it
okay,
a short answer.
Thank
the
you.
answer is not this year. It's up as at the 26th of December 2022 from the commencement of the judgment coming down. So 13 people have been released from immigration detention based on meeting or reasonably suspected of meeting the tripartite test. That includes Mr Tom's.
Yep.
5 additional people have been released in relation to directly or indirectly court judgments.
Okay.
And in those ones, generally it's been in relation to a habeas test, so it's related to the reasonableness of the suspicion and not always with any findings that a person does in fact meet the test.
Understood, and presumably the 13 plus the 5 gives us the
Yes.
18 that Senator Watt referred to in the Senate, but he can clarify that if he wishes. So what I'm trying to understand here, Ms DeVoe, is, or perhaps I could ask one further question. When those people are released from detention, are they issued with a visa?
It will depend. Definitely not if they're released by a court. And then there may be complexities as to whether they in fact could subsequently be issued with a visa, because provisions like 195A of the Migration Act, which vests the Minister an ability to intervene and grant a visa, is predicated on the person being in detention. So you can't even then take them back into administrative detention to allow them to come within that scope. Those who are being released from immigration other than a court order, it might be that they're released because they're being granted a visa. It might be because a revocation decision has been made, or it might be because they meet the test.
Nevertheless, some of the 18 people have been issued a visa either before they were released or as they were being released. Is that
I don't have the specific details, but that is a legal possibility.
Okay. I guess I'm trying to understand, given that the court's ruled that that group of people are not aliens, why do they need visas?
They may still be seeking them.
Seeking what, sorry?
They may still be seeking to have a visa.
But I can't seek a visa for Australia, can I? I'm an Australian citizen. Can I seek a visa for Australia?
Because you're an Australian citizen.
I understand that, but that's where I'm going, Mr. Vogt.
But they're not citizens, and this is the difficulty. There is now a third category of people who are neither citizens nor aliens, and the degree to which different parts of the Migration Act extend to them has not necessarily been finally determined. What has been determined is that for a person who meets the test, as you identified earlier, an Aboriginal who meets the Mabo 2 test cannot be considered an alien for the purposes of the Act, but that's not to say that all aspects of the Migration Act, so aspects that relate to migration clearance, for instance, also apply to you as you come through the country. So what has been established is that the ability to detain as a non-citizen and the ability to remove have been taken off the table.
That's right.
But I wouldn't say it's been firmly determined at law that other aspects in terms of whether you can hold a visa have been.
Would you say that it's been determined? Sorry, if I could just ask, happy for you to obviously offer your thoughts, Mr. Pasullo, but has it been, in your view, Ms. DeVoe, determined at law whether those people have an entitlement to citizenship?
No, it hasn't.
You don't think it has?
No.
So they can't be aliens, but they don't have an entitlement to citizenship?
It's the case that, and the former government had a policy position that was announced. In fact, Mr. Vogt and I have given evidence that the jurisprudence needed to be tested. There was a case, in fact, that was authorised to be run, known as Montgomery, where, based on advice, that there are some vexed constitutional issues here that your questions go to, that would be best clarified by further judgments from the court, because obviously the court needs something before it.
Or perhaps amendments to the Act.
Or perhaps,
Mr.
indeed.
Pasullo.
I anticipated you earlier and you've anticipated me, Senator, so thank you for that. So that's really an active policy to question that goes beyond our legal advisors, and that's a matter that is actively before ministers as a policy question, because the Constitution clearly talks about aliens. It grounds a power to create a citizenship law, the Citizenship Act of 1949. It doesn't expressly, we can't find anywhere that kind of deals with this third category. So we've got jurisprudence that says that there's a third category. We now need to square that with, if you like, the constitutional architecture that's set out in the powers enumerated under Section 51, and obviously that's a complex question to work through. It's as much a policy question, which ultimately ministers will have to turn their mind to, as it is a matter of strict legal advice.
Absolutely, except that I'm very nearly...
If you can wrap up your questions.
Last question,
thank
Chair.
you.
Yep, thank you. And I'll direct it to you, Minister, because it does, as I think Mr. Pasullo has implied, cross over into a matter for government, not a matter for the department. Am I correct in understanding what Mr. Pasullo said, that the government is actively considering that issue, that is the issue of whether people in that category do have an entitlement to citizenship, and whether any legislative amendment is needed in that space? And if it is a matter that government is actively considering, are you able to provide any update for the committee in terms of process or timing?
Obviously, as the representing minister, I'm not fully across the details of this, but I can only agree with what Secretary Pizzullo has said, which is this is something that is under consideration by the government. I don't have a time frame for that, but it's under consideration.
Could I just ask you to take on notice whether you're able to provide any further details to the committee?
Thank you, Senator McKim. Senator Scarr, you have the call. Just for Senator's information, we have Senator Patterson seeking the call as well, and I am endeavouring to move to outcome 1 after lunch. Thank you. Thank you.
Chair. Machinery of government changes, Mr Pizzullo, you've given evidence that you were informed of the changes. What were the implication of those changes in terms of logistics, the costs of the department, people shifting from place A to place B, new organisational charts being prepared, new letterhead, the list goes on and on. Have you got have you made an assessment? Has the department made an assessment of the costs incurred?
Indeed, there's guidance that the Chief Operating Officer and the Chief Financial Officer might come forward and speak to. There is guidance that the Department of Finance, as I recall it, issues about the checklist or the processes by which you go through. We're public servants, so everything's got an acronym, a MOG, a machinery of government. So we've turned it into a verb, Senator. You'll be...
to be mogged.
Yeah, you'll be disappointed to hear everything becomes
a verb. Has the department been mogged, Mr Pizzullo?
Well, departments themselves are typically not mogged. The verb form applies typically to agencies or functions that get mogged. Departments tend to kind of sit in place unless they're abolished or created, and that's a different consideration.
So you don't consider yourself to have been mogged?
No, quite.
Okay.
Quite. I don't know. I haven't been mogged, indeed. So the Chief Operating Officer, will speak to the question of costs. In terms of the department's impact, it was relatively modest in terms of the scale of MOG changes that I've seen in my career. This was hardly a speed bump because the agencies in 4 cases, so AFP, ACIC, AUSTRAC and the Office of the Special Investigator were shifted and lifted in one go, so that's just a move. In terms of the department, there was some requirement to disentangle a number of functions, principally around law enforcement policy, because obviously departments of state own policy, so there were staff who would have dealt with, for instance, aspects of the criminal code, law enforcement policy and the like, child protection and child exploitation issues, for instance. They were the subject of transfer, so I'm sure we've got details as to both the logistics of that and the costs. So, Ms Saunders.
So, Ms Saunders, I'm assuming you heard about it, the changes in machinery of government about 2 minutes after Mr Pizzullo heard about it. Is that about right?
That's correct, Senator. Yeah, shortly thereafter. Thanks, Senator. Justine Saunders, Chief Operating Officer, Department of Home Affairs, and also have my colleague Stephanie Cargill, Chief Financial Officer. As the Secretary indicated, obviously we had very clear guidance, across the APS. Machinery government changes are, not unique, quite routine in practice, and so obviously the costs of actually undertaking the machinery of government changes are undertaken as part of business as usual within affected departments. So both, in this instance, the Attorney-General's Department, ourselves and Prime Minister and Cabinet, as it related to the machinery of government changes regarding the NRRA and the establishment of NEMA. Obviously there was a lot of work to be done, though, to facilitate those changes, and I'm happy to talk those through for you, Senator. But if there's a particular area of interest you'd like us to focus on, please do. As the Secretary indicated...
Well, I'm interested just to get some overarching comments from you as to what you actually do in practice, the process you practically go through after you've been informed of a machinery of government change. How extensive is that process? How many people do you have to mobilise to assist you in terms of discharging that process? And what sort of timeline do you have to execute the plan you come up with?
Sure. Well, it's a very good question, and thank you, Senator. So in terms of, there was obviously establishment of a working group involving senior officials from both the Attorney-General's Department and ourselves and Prime Minister and Cabinet as it related to those machinery of government changes, including both obviously Stephanie Cargill and myself, and I chaired it on behalf of the department. Obviously there's a whole range of issues that needed to be worked through, right through to any any guidance required in regards to administrative arrangements. We had to look at legislative implications that might be incurred as a result of the moves. We had to work through what it practically means to operationalise the AAOs in terms of those functions that would need to be moved across departments. We had to work through the implications as it relates to the individual people that are affected by these changes and making sure appropriate movements of people and funds associated with the functional moves. And of course, then arrangements had to be considered in terms of the administrative arrangements, noting shared services arrangements and joint contracts and other arrangements with portfolio agencies within the portfolio. So very expansive. There's a very detailed checklist that's provided by APSC to work through and specific timeframes within which we needed to adhere to milestones associated with those machinery of government changes across the APS.
So do you have a breakdown in terms of the costs that were incurred in terms of relocating staff, and you can take this on notice, relocating staff, the costs involved in terms of, you talked about the shared services, so having to go through some process of unsharing shared services in terms of agencies leaving the department and all the other costs involved in the team that you had to assemble. Is there an actual plan or an execution plan that was developed with its own budget that you could perhaps provide us on notice with?
Well, certainly there were terms of reference and a set of guidance in relation to what we needed to actually undertake for the process. As I indicated, in terms of actual cost in implementing the machinery of government changes, that is dealt with as part of business as usual for the departments affected, and so therefore I don't have a breakdown of costs. But I'm happy to take on notice what information we do have that might go to answer your question, Senator.
Okay. Well, you understand the intention of my question, so I'm keen to know the size of the enterprise, if you like, in terms of executing the machinery of government changes, what the costs were, the human element in terms of how many people had to be mobilised in order to make it occur. So I'm happy for you just to take that on notice if you can. I can provide some more detailed elements to that perhaps on notice, but I think you understand what I'm after.
Yes, thanks, Senator, we do.
And by the same token, Mr Pizzula, I assume and we have the benefit that you've had continuity as Secretary during this stage, it would have been an immense task to bring all these agencies together in the first place, and that would have required quite a mobilisation of staff to execute the initial change of machinery of government to bring the department together, and there would have been costs in that regard too, wouldn't there?
There were. The creation of Home Affairs went, as Mr Turnbull's expressed in his memoirs, went well beyond the kind of bilateral or binary trade-off or movement of functions between what is now Home Affairs and the Attorney General's Department. In fact, I think, and I've given evidence on this, so I'll just have to refresh my memory to the extent that I vary from that. But between July of 2017 and the establishment of, or the re-establishment of Home Affairs in December of 2017, we did much more work on unpicking what was frankly a fragmented and disparate set of related functions from across the rest of government. So transport security was sort of over here and multicultural affairs was over there, and I think I found cybersecurity in several pantries and looked under a few cushions, and I found it there as well. As I recall it, and Secretary Moraitis, if I recall, was in the job, he and I had a fairly straightforward task once Mr Turnbull and his government had made it, well, I should say Mr Turnbull, it's the Prime Minister's decision to do the machinery of government change as between taking a number of functions out of the Attorney General's portfolio. That was relatively straightforward. What was much harder in the stand-up of Home Affairs, and I oversaw the process reporting to Mr Dutton and to Mr Turnbull at the time in late 2017, what was much harder was really getting the big magnet and sort of finding all the sort of filings and elements of metal that were scattered right throughout the rest of government. So this has actually been quite a straightforward, we're literally across the road, movement of some functions back across a road, and nothing like the challenge involved in the creation or the re-establishment of Home Affairs in 2017. This has been quite a straightforward excision exercise compared to what had to be done 5 years ago.
So, Minister, what...
Your colleague is waiting for the call. just to remind you.
Well, I think he's quite happy for me
Yeah,
to finish
I'm
these
just
questions.
letting you know.
Are you happy, Senator Patterson?
I am, Deputy Chair.
I thought you might be. Minister, what was the rationale for the change?
Well, Mr Pizzullo has also already made the point that machinery of government changes, and these types of changes are a matter for the Prime Minister, and I would encourage you to direct those questions to the relevant Estimates Committee.
So you don't know?
Well, I'm not the Prime Minister.
No,
You may have noticed.
I acknowledge that. I think everyone in the committee acknowledges that.
And I don't.
Very fine, Senator,
Never
but not
aspire
Prime
to it.
Minister yet. But you're representing the Minister in relation to this portfolio. This is an extraordinarily significant change in the machinery of government, and you're telling us you're not prepared to answer the rationale, provide the rationale to this committee, which has oversight of this department. You're not prepared to provide us with the answer for the rationale for the change.
Well, I would argue that the changes that have been made here are nowhere near as significant as the changes that were made to this department when your government was in office. And besides, I don't remember ever asking questions about those changes in this committee because they get put to officials and ministerial representatives at Finance and Public Admin.
So
I'm sure they'd be happy to answer those questions.
So you don't know the rationale for the change?
Well, I am neither the Prime Minister nor the Minister for Home Affairs, and therefore, and besides, these are matters for the Prime Minister. I mean, to give you a different example, the Prime Minister's decision to correct decision, in my view, to relocate what was then the National Recovery and Resilience Agency to this department was a decision entirely of the Prime Minister. It was a decision that, as the relevant minister, I was very supportive of, but that was his decision as well.
And what was the rationale for that decision?
Well, you should take that to the Prime Minister's representatives at Finance and Public Admin as well.
So you're not going to tell us?
No, because for the third time, I'm not the Prime Minister. That's who makes these decisions.
So-
and that's the Minister who should be asked these questions.
So this committee's in a position where there's been a material change of government structure impacting this department, and the Minister at the table is unable or unwilling to tell us the rationale for that change.
Well, in the same way as I'm not able or willing to tell you about changes that have been made to Medicare because I'm not the Minister for Health or representing the Minister for Health. The appropriate minister to answer questions about these changes is the Prime Minister and the Minister representing the Prime Minister, and in fact I think that committee is meeting today.
And can I ask you when the decision was made?
Well, again, that's a matter for the Prime Minister, and that there's a there is a forum where these questions can be asked. It happens to not be this forum, and I'd encourage you to put those questions to the relevant forum.
Okay, so, well, can you tell us today you're not prepared to answer any questions?
Well,
to
it's just that they're not.
the-
This is not the committee to ask questions about the NDIS, Medicare, any number
No,
of
I
matters that
understand.
are
You've put it on the
decided by
record,
those
Minister. There's no,
ministers,
we've got limited time. I just stated the fact that you're not prepared to answer questions in this forum.
Well, you're
with
asking the
respect
wrong
to the
questions in the wrong committee. I'm
Well,
happy to answer any questions that are under the responsibility of the Minister
You can
for
give
Home
as many
Affairs.
reasons as you like. Are you prepared to tell us how the change in machinery in government is actually going to deliver a better government, as outlined by the Finance Minister in her media release announcing these machinery of government changes?
Well, wouldn't you think that you'd put that question to the Minister who put out the statement?
Well, I actually
In
thought
the-
I
in the
might put
relevant
it to the
committee?
Minister who's at the desk with the Department of Home Affairs, but again, you're not willing to answer
Well-
that question in this forum either?
Well, with respect, I think you've answered your own question. You've held up a statement from the Minister for Finance. There is a committee called the Finance and Public Administration Committee, and that minister happens to appear in person. I'm sure she'd be very happy to talk to you about her statements.
Do you acknowledge the benefits that Mr Pizzullo outlined in terms of the operation of this department under its previous structure, in terms of the structure itself promoting coordination between the relevant departments and between the relevant agencies which came under that department?
Again, these decisions were made by the Prime Minister. They're entirely appropriate questions to ask, but this is the wrong committee to ask them in.
Okay. Very interesting. So, Mr.
Have you got a couple more questions?
I just have one more question, and I just want to seek guidance from you, Mr. Pezzullo, as to where you would like me to direct this question, and that relates to some of the multicultural grants which appear to have been cut or at least shifted from this department's jurisdiction. The rationale, if I can use that term again, for that decision, is that something I should raise, or you'd prefer me to raise in cross-portfolio?
My preference, consistently with how we dealt with Senator McKim's question, if the question goes to, if you like, the governance of grants, who gets appointed as being the decision maker, how the funding works, then I'm sure both Ms Saunders and Ms Cargill can speak to that. If it's about a particular program that's got as its focus, I think you said multicultural engagement or similar words, that would be program 2.5.
Okay.
It's just a question of which officers at the table who's got a more granular understanding of the area of interest that you have.
Right. Okay. Well, will the officers currently at the table still be here when we get to that area, just in case there's a bit of overlap?
The Chief Operating Officer and the Chief Financial Officer are here for as long as I'm here.
Okay. Good.
So the answer is yes.
Okay.
Thank you,
I'm
Senator.
happy.
In the interest of moving on to outcome one, Senator Patterson, you can ask your questions now. I know that puts you in the awful position of being the person in between people's lunch, but I'm sure you can keep your questions concise.
These are still cross-portfolio ones,
These are still cross-portfolio, and Senator Patterson has the call.
Thanks, Chair. I have two quick follow-ups from Senator Scarr's questioning. I have two housekeeping matters, both of which I hope will be quick, and I have one substantive matter, which I also hope will be quick, but will depend on the answers. Just to follow up Senator Scarr's questioning, Mr Pezzullo, you've given evidence that you were notified but not consulted about the machinery of government changes. When were you notified?
I was, in my own mind, turning that over as I was considering some of Senator Scarr's question. I'll check my records. I think during the course of what I'd call that brief interim ministry, where the 5 ministers were in place, and I suspect before the commencement of 1 June, when the full ministry took effect, but I'll check.
My memory is that the ministry was sworn in on 1 June and the machinery of government changes were announced on 1 June.
They took effect. I just need to check in my own memory, but my records, as to whether secretaries and other affected parties might have been advised in the days before the swearing in.
Okay, thank you. And Minister Watt, you said in relation to your own portfolio that you supported the Prime Minister's decision to move Emergency Management Australia into the Home Affairs portfolio. Does the Minister for Home Affairs support the machinery of government changes that were made to her portfolio?
Of course she does.
She supports the fact that her portfolio has been gutted and that the Attorney-General has taken responsibility for very substantial areas of national security that were previously the Minister for Home Affairs' responsibility.
I absolutely reject the proposition that this department or portfolio has been gutted, and the Minister for Home Affairs supports the decision that the Prime Minister made, just as I do. I might point out, you seem to be making an issue about these MOG changes, whether Mr Pezzullo was consulted. I seem to remember another Prime Minister recently who appointed himself as the Minister for Home Affairs or Minister for various portfolios and didn't tell those ministers. So, you know, if you really want to have a talk about this stuff, let's go for it.
Okay, well, I'll be guided by the Chair in terms of the time. We could have that discussion, but it probably wouldn't be productive, I imagine.
I'd be very happy to have questions about Mr Morrison swearing himself into multiple portfolios without telling his
let
ministers.
the Senator ask his question.
But not the rationale for this decision.
Senators, I've just called to order. Senator Patterson has
Thank you,
questions and he wants to ask them now.
And so just to be clear then, Minister, was the Minister for Home Affairs consulted or notified about these changes and on what date?
I don't know the answer to that.
Could you take it on notice, please?
Well, again, these decisions are matters for the Prime Minister.
I understand that.
He's not required to consult. He's not required to consult with ministers about that. So they are entirely a matter for him.
I'd be grateful
they
if
have been under previous governments.
The Secretary has taken on notice when he was notified. I'd be grateful if you could take on notice when the Minister was notified.
Sure, but can I also say I was not consulted by the Prime Minister when he made the decision to move the NRRA into Home Affairs. I didn't expect to be consulted about that because it's his decision, and I 100% supported it.
But presumably you were notified?
Yes.
When were you notified?
Well, I'd have to check the date that I was notified, but I was notified after the decision was made, and that was entirely okay with me.
I'm glad to hear that. I'm still interested in when the Minister was notified, but moving on in the interests of time, 2 housekeeping matters. Mr Secretary, I wrote to you on Wednesday this week and copied in the Chair and Deputy Chair. I just tabled that letter for transparency for the committee, and I asked whether or not you would be able to bring to this hearing a detailed timeline of events for the Optus and Medibank breaches. Have you been able to do that?
Well, whether it's to your satisfaction or not, I'm not sure, but the officers who can speak to the timeline will be available to speak to that matter under Program 1.3.
Thank you, but can they table the timeline to assist the committee?
I'll just check with Ms Sharp. Do we have a document that can be
Senator Patterson, I received your letter as chair, and I don't know if that was actually, if a written timeline was requested.
I'm asking whether it can be.
I'll check. The officers, I'm sure, would have notes, but typically it's been acceptable for them to read from their notes without necessarily being required to table a document. I'll check over lunch.
Yeah, the reason why I ask is actually to assist the chair, given the limited time we have. I could sit here and ask for when did this happen, when did that happen, when did this happen for each of those incidents, but that would take a lot of time of this committee. It'd be much quicker if a timeline could be tabled.
I will check over lunch. I suspect the officers have got notes to support them in giving their own evidence. Whether they've got a document that's able to be tabled is something that I'll check.
Thank you. Moving on to my second housekeeping matter. As I flagged with you this morning personally, Mr Secretary, there is an official of the department that I would like to ask questions to that doesn't appear on the witness list, and Mr Peter Anstey, the Assistant Secretary for Cyber, Digital and Technology Policy Division. Is he available to appear before the committee today?
In relation to the matter that you raised with me this morning, the Deputy Secretary of that area, Mr Ablong, will take those questions.
The reason why I'm interested in hearing from Mr Anstey directly is that based on an order for production of documents that I sought through the Senate, it appears that he has met directly with the Chief Counsel of TikTok in the last number of weeks. I'd like to question him about that meeting. Is he available to answer questions about it?
My preference and the practice certainly adopted by this committee over many years and others is that it's the Secretary who determines who gives answers to or who engages in giving evidence, and it's my decision that the Deputy Secretary will deal with that matter. It's in the Deputy Secretary's knowledge as to that meeting and when it took place and what occurred as a result, but the Deputy Secretary is responsible for the functioning of his group, and that officer works within that group.
Well, I imagine he didn't attend the meeting. The
I'm
Deputy
sorry.
Secretary didn't.
I'm not sure. I'm not sure, but even if the answer is no, he didn't, Mr Ablong will give the evidence.
Okay. Is there precedent in the Department of Home Affairs for Assistant Secretaries to appear before the committee?
We don't normally go that, I'm just trying to think, that far down the chain, if I can use that term. As to whether there's precedents, I would doubt it, but I would check. But typically, the most junior officers who give evidence tend to be first assistant secretaries, which are typically one rank up.
I can assist you on that. The witness list provided to the committee for the 31st of March hearing, there was a witness at the assistant secretary level. It was Mr Sean Hugo, the Assistant Secretary for Cyber, Risk and Services. I don't know whether he was called upon to answer questions, but he was on the witness list.
And the reason why he appeared is that he's our Chief Information Security Officer. As a Band 1, he reports directly to the Group Manager, Mr Milford, so there's no intervening level of management.
Okay. All right. Well, I hope that the Deputy Secretary can answer my questions. Moving on to just the substantive matter that I flagged at Chair. Secretary, how much was the total resourcing for the Department of Home Affairs cut in the budget?
This budget that's just been brought down?
Yes.
I'm not sure it's been cut as such, but Mr Cargill, it'll depend on whether you're asking about departmental expenses, administrative expenses, capital budget, but Ms Cargill, if you can give an overall answer.
Certainly, Stephanie Cargill, First Secretary Finance. So the net outcome of the budget on the Department of Home Affairs in 22-23 was total funding, new funding of $128.6 million, which was predominantly administered funding of $101.2 million, and across the forward estimates is a total funding of $561.3 million. And by way of comparison to the 21-22 funding, you'll see the department has a slight increase of funding in 22-23 to the tune of $17 million, so it's very consistent.
I think I might be asking a different question to the one you're answering. I'm interested in the total resourcing for the Department of Home Affairs.
Yep.
It is traditionally provided in the portfolio budget statements.
Yes.
In this budget, I believe it's page 14 of the portfolio budget statements. It says at the bottom of that page, it's table 1.1 if that assists, total resourcing for the Department of Home Affairs, about $7.8 billion in 21-22 and $7.3 billion in 22-23.
Yep, so this table is actually a cash appropriation table, so it doesn't represent the total expenditure that we're going to incur between the 2 years. It's actually a reconciliation of appropriation bills. So the table that you need to go to is the revenue from government table in the portfolio budget statement. I can find you the page number.
Could you just explain to me why it's not relevant to ask about the total resourcing for the Department of Home Affairs?
Sorry, I didn't mean it wasn't relevant, Senator. So what I'm suggesting is this is actually, as I said, a reconciliation of our appropriations. So it's referring to the cash that we have available. So you'll see, for example, in the table that it has key areas such as prior year appropriations, which have been rolled over from prior years.
Yeah.
So it's reconciling those appropriate bills in particular. Doesn't represent what we're actually going to expend in 22-23.
Well, can you explain then the reason for the fall in the total resourcing for the Department of Home Affairs as listed on table 1.1 of about $500 million from 21-22 actual to 22-23 estimate? What's the reason for that fall?
Yes, I can, Senator. So if you look at the departmental funding, just as a starting point, you'll see that there's the difference is we're looking at $3.8 billion versus 3,802. So that is actually a very small differential. And there's a large majority of that which is related to prior year appropriations, which is the $420 million. But the key reduction is actually in administered appropriations. You'll see there that there is a substantial reduction between 21-22 estimated actual and the 22-23 amount. And that is actually explained by the fact that we have a substantial movement of funds in our administered budget between 21-22 and 22-23. So what that means is the cash doesn't have to move over into 22-23, and that is $153 million of that differential. And then the remainder of the differential actually is related to two particular underspends in the administered program. So one is in relation to offshore management, and the other is in relation to onshore detention. And we have a series of underspends there that are actually represented in our annual report. You can see them there as well. And we have moved some of that money into 22-23, but the net result is a $400 million differential. And the reason that shows us such a big decrease is when money is no longer required in the administered funding line, it's required to be quarantined, and until that happens, that money is still represented in 21-22. So there is $212 million effectively of money that's required to be quarantined. That looks effectively like a reduction.
Okay. When I compare it to the budget statements from the March budget, the estimate for 22-23 of that total resourcing figure was $8.59 billion, whereas in this budget it has declined to $7.3 billion, so that would be a reduction of about $1.24 billion. What is the reason for the discrepancy between the two budgets?
I'd have to take that on notice specifically. I haven't got a reconciliation here between the March budget and the 22-23 number. But there would be there's an enormous timing difference there in relation to the annual appropriations and the prior year appropriations available. So I'd have to do a full reconciliation in terms of that cash.
It's a very significant difference, $1.2 billion.
Yes, that's right.
And you're not able to give any reason for it?
That's total. Separate again.
That's just
Yeah. I'm happy to take on notice, provide a full reconciliation. But there's obviously timing differences in relation to that. And we have had a significant reduction in the funding that we have profiled over the forward estimates, particularly in relation to offshore processing, as we look to exit PNG and to put in place an enduring capability.
It's that may well be the reason for it, but $1.24 billion in 6 months, would you really attribute all of that to offshore processing?
No, not at all. No.
Right,
So I
what are
need
the
to provide a
possible-
full reconciliation, as I've said, and there's timing differences here. And at that point of the year, that we didn't have a full end of year process, so appropriations were still being drawn down. Hence, there's a timing issue here. So I'll need to do a full reconciliation. But as I said, if you refer to the revenue from government line in the financial statements, which is actually the amount of money they were intending to spend between the 2 years, on page 66 of the portfolio budget statement, you'll see the revenue from government has increased from $2.7 billion to 2.794 between 21-22 and 22-23.
Okay. And what was that compared to what it was forecast in the budget in March?
I'd have to go back and check the March number.
Okay, you don't have that on you?
I would have it back at... I don't have it in front of me right now.
Okay. I think it's an important figure. I'm happy to wait if it just takes a minute to grab those budget papers.
Sure.
Thank you.
I don't think it'll take a minute. I think it'll take a bit longer. We're trying to get through.
Well, Chair, this is the relevant part to ask these questions.
I think Ms Cargill was moving to get it. I think she can do it pretty quick.
If you can do that quickly, but I mean very, very quickly.
Certainly.
Consistently with a safe workplace. No tripping, please.
Do you have other questions, Senator Patterson, you can ask in the meantime?
No, this is the last topic I have. So once this question's answered, then that will be it from me for cross portfolio.
That was rather quick.
Yes. So, Senator, in the revenue from government line in the March budget for the 22-23 budget was 2.838 compared to 2.794 for departmental expenditure.
Okay, so there has been a cut.
There's been a reduction to the amount of departmental appropriate available. That's correct, but not compared to 21-22.
No, but there has been a cut compared to what
From
was
the March
in the
position.
budget in March. So the department was told by the government in March that it was going to get 2.838 billion, and the government, the new government in October has decreased that to 2.794 billion.
That's correct.
Otherwise known, I think, as a cut.
Well, it's a reduction, yes.
Yeah. Okay. What is the reason for that reduction in funding to the Department of Home Affairs?
Again, so that'll be the outcome of the measures that were taken forward in this budget, and also there are obviously savings initiatives that the department has, that the department is required to provide through this budget process.
Yep. Right. So what's the quantum? I can try and calculate it myself, but what's the quantum of that cut?
Just the difference between the March position on revenue and this position, and then I'll add a comment.
2.794 for 22-23 versus 2.838. So that was $44 million.
So, Senator, I think
$44 million, sorry, was that?
That's the difference, yes.
Thank
In
you.
the March forecast versus the October budget
And
forecast.
that's real numbers, not in taking into account inflation? Or is it then taking into account inflation?
It's a nominal number.
it's always a nominal number, that revenue line. And as Ms Cargill took on notice, we'll present to the committee a reconciliation table that'll account for any timing changes, or whether in part that might reflect the movement of staff back to the Attorney General's Department, as we canvassed earlier. So there'll be a decomposition of why that number is reduced, and some of that would go to timing, some of it might go to the movement of staff. Would it be potentially explainable by the 100 or so staff who moved back to the Attorney General's Department?
Correct. So the machinery of government is now reflected, changes are now reflected in the 22-23 budget, and they clearly were not there in the number
Which
that
would
was
affect
represented.
your appropriate as reflected in the revenue line.
Correct.
So just to be clear, that's a nominal figure, not a real figure. So if we took into account inflation, it would be an even greater cut than 44 million.
Well, I think it's important, Senator, that when you say cut, that implies that government programs or activity have been cut. I'll be concerned to ensure, because I'll review this material myself, that if it reflects a function that's gone to another department, the government's still spending that money. It's spending it on salaries, for instance, for officers of the Attorney General's Department. It's not a cut in government activity. And so I really would want to see Ms
full
Cargill's reconciliation of how you get to that $44 million reduction in revenue to see where else it's gone in government.
And to give you an example, the amount of departmental operating funding that was transferred to AGD under the machinery of government was $39.1 billion.
Right, so then the net cut between the two departments would be about $5 million.
And there was money transferred to NEMA as well. So as I'm saying, we'll have to do a full reconciliation.
Yeah.
The reconciliations that I have in terms of our funding refer back to 21-22, not to the March budget. But the amount that was actually transferred to NEMA in the 22-23 budget from EMA is $27.6 billion.
Okay. So
that would get us to
It could actually be more that's
Thank
moved.
you. So, Chair, I'll just
Additional
conclude.
funding.
With your permission, Chair, I'll just conclude my questioning here. Where in
That's your last question.
budget paper number 2 does this cut to the department's funding of $44 million in nominal terms appear?
Well, we don't, as I've just said, Senator, there is no cut to the department's funding. There is an adjustment for machinery, government changes and other measures. And the budget papers do not refer back to the March budget. They refer back to 21-22, and that's how all the movements are reconciled.
Right. It seems to me not to be very transparent to not be upfront that the department's funding has been reduced by $44 million.
Well, I don't think anyone is conceding that's the case, Senator Patterson. That's your interpretation. You've heard that.
Well, what's the correct figure then, Senator Watt? If the department's funding has not been reduced by $44 million, what is the correct figure?
What you've been told is that there have been MOG changes and there have been there's timing issues, there's various other factors that influence these figures.
No, the timing factors were due to
the
other figures.
They do not
Senator Watt.
represent cuts in the way that you are trying to portray them.
We need to move to lunch. Senator Patterson, you've got the option to ask a final question so we can move to outcome 1 when we return.
No, I think I'll leave it there, Chair. Thank you.
Chair, could I take 10 seconds to correct an answer?
Of course you can.
Mr Hugo is the Deputy CISO, but nonetheless, I might have said CISO, Chief Information Security Officer. He's the Deputy CISO, but my evidence stands that he reports directly to a direct report to me, so he reports to a Deputy Secretary equivalent or Group Manager.
Okay.
Thank you.
Thank you. I think that is all the questions we have for cross-portfolio and corporate matters. So we will be going to lunch, and when we return, we'll begin with outcome 1
Thank you, Chair.
at 2:10.
Thank you, Chair.
Thanks. Is that what time? We'll resume the hearing there, and I'll begin by calling officers from the Department of Home Affairs in relation to outcome 1, and I give the call to Senator Patterson.
The answer is no as to tabling. We obviously read your letter very, very literally, which is to say, assist if the officers had with them a detailed timeline of events, which they do have. I didn't take that to be a requirement to produce a document, so we're not in a position to. But the officers are seized of the issue and have got detailed notes for themselves in terms of the timeline.
A number of questions for them, but just to be clear, what's the reason that there is no document that can be tabled? What's the form of? Is there a document in a form that's not appropriate to table, and that's why you don't want to table it? Or
they're embedded in briefs that might have background material or other matters. So we would be we'd be very happy, subject to what's asked of us, of course, always to produce a document that is produced in a form to be tabled. I'll take this on myself. I didn't read your letter as requiring that, so I didn't give that direction.
Yeah, I'm just conscious of the committee's time and the chair's anxiety to try and keep us to some semblance of order, but we'll just have to go through this item by item and start from the beginning.
Chair's determination.
Determination, I'd
Yes,
say.
sorry. When was the government first informed of the Optus attack?
So we're starting with Optus?
Yes, please.
Yes. So Mr Ablong is the Cyber Security Coordinator. He'll be joined by Mr Dowling, I mentioned earlier, is the Deputy Coordinator, and between the two of them we'll work through the answers to your questions.
Thank you.
Would you like to immediately defer to Mr Dowling? Or? Okay. So Mr Ablong is the Cyber Security Coordinator for the Department of Home Affairs.
Thank you.
Senator, your question, if you wouldn't mind.
Yeah, of course. When did the government first learn of the Optus attack? We'll call it an attack. We can have a discussion about terminology later, but for the purposes of this discussion, when did they first learn of it?
For the purposes of this discussion, on Wednesday the 21st of September, Optus reported a compromise of its network to the Australian Signals Directorate's Australian Cybersecurity Centre.
At what time?
I don't have an exact time. I can certainly get that for you, Senator.
Thank you. When was the Minister's office or the Minister notified about this incident?
So on the same day, the 21st of September.
And and you might need to also take this on notice, but on what time was the Minister's office notified? And in what form did the notification take? Was it a phone call or an email?
So there's firstly a cyber incident report is produced. It's a fairly standard report saying something's happened, giving the initial details. Because
sorry, Mr. Ablong, just before we proceed, it's important, and I'll take advice from Mr. Ablong. Notifications to the Minister as the Minister for Cybersecurity from the Australian Signals Directorate, those questions should be directed to the Australian Signals Directorate. So the way we divide up the work, operational and technical matters are the responsibility of the Australian Signals Directorate, and particularly the Australian Cybersecurity Centre within that directorate. The Minister for Cybersecurity is a minister appointed to the Department of Defence for the purposes of overseeing that function. I'd ask Mr. Ablong to stick not just closely but precisely to the involvement of our department, and any questions about the Minister's state of knowledge or who notified her or when it was notified, unless it's a matter that is directly under our remit, I'd ask that those questions be directed to the appropriate agency, in this case the Australian Signals Directorate, and we'll obviously consult with them to make sure that they're ready to answer any questions that as they're required to. And then secondly, Mr. Ablong, obviously there are a number of now regulatory actions on foot, which include investigations being undertaken by statutory officers who, again, don't report to me or aren't in my portfolio. So I just would caution this discussion from those 2 points of view. Mr. Ablong.
Mr. Pezzullo, can I just double check? And that agency is due to appear at under another committee.
The Australian Signals Directorate is in the Defence portfolio.
Thank you.
Yes, thank you. I certainly will have questions for ASD and the ACSC when they appear in the other committee, but let's proceed as best we can to the state of your knowledge. I've asked when the Minister was notified and in what form. You've started to answer by saying that the ACSC was notified by a particular form.
So Optus informed the ACSC. The ACSC then puts out a cyber incident report.
Right.
That is circulated to both ourselves as well as to the Minister's office.
Yeah. Okay. So the time and date that was provided to the Minister's office would be helpful. When did the Minister first request a briefing from the department about the Optus incident?
So that same day, Home Affairs had a call with the Minister's office in the first instance, notifying them of the Home Affairs equities with respect to our responsibilities under the Security of Critical Infrastructure Act. And the department then held a call later that afternoon with Minister O'Neill herself.
Okay. And so the briefing was provided in the form of a phone call. What time did that phone call take place? I presume that was on the Wednesday?
Yes, it was. We'll just take the exact times on notice. I've got the dates, but not the exact times.
Yeah. Okay, thank you. How many subsequent briefings has the department provided the Minister?
Quite a few,
I imagine.
Senator. We were engaged with the Minister multiple times a day on the Optus matter.
Yeah, or perhaps on notice, because I don't expect you to be able to do it today or efficiently, an itemised list of those briefings, when they occurred and how many of them there were. And I will ask ASD and ACSC on their state of knowledge. When did the Minister first receive a briefing from Optus as distinct from the department?
We'll have to take that on notice. There were some calls and briefings to which the department was party, and I can't give you any kind of assurance that they were the only engagements that the Minister or her office had with Optus, so we'll take that on notice and refer it to the Minister's office.
Well, I mean, there are some facts about this matter on the public record,
Indeed.
which I can potentially assist you with. So the Optus CEO has said that the briefing that the Minister received occurred after her pre-recorded interview with the 7:30 program on the ABC. So you're not able to say...
No, I'm not. And what the Chief Executive Officer has contended is something that we'll take into account, but I would prefer that Mr Ablong and his staff consult with the Minister and her office about, because we're not a gateway, so we don't manage all of her engagements, and as you would expect to be not the case. So we will check that and take it on notice.
Did the department participate in the briefing provided by Optus? Was there a departmental staff member present?
In some cases, I'm sure that was the case, because I've seen reports where my officers did participate in briefings, either in Mr Ablong's area or when initially it might have been thought that some critical infrastructure had been impacted within the meaning of the relevant act. Mr Hansford and his staff might have been involved. So the answer is almost certainly yes, but were they the only engagements with Optus? I just don't know, and that's why I would prefer to take the whole matter on notice and just to reconstruct a timeline.
Okay, well, how about we just zero in on your department for whom you are responsible?
Thank you.
When was the first briefing from Optus provided to any member of the department?
Thank you. I'm more assured and comfortable answering that question, because I'll answer questions in relation to my responsibilities. I might just ask Mr Hansford to join us as well. The reason being, there's a regulatory framework that that I know you to be very familiar with as our former chair of the committee. Mr Hansford, do you want to perhaps go on this side so I don't have to look too far down the right wing, as it were? And so if it required, as initially might have been thought to be the case, an impact in material terms on critical infrastructure within the meaning of the 2018 legislation, Mr Hansford would lead as regulator, and otherwise it's a function for Mr Ablong and Mr Dowling as coordinators. So first of all, perhaps Mr Hansford, if you could respond to your state of knowledge about your own or your office's involvement in those calls.
Certainly. So,
calls or briefings.
Well, I think before Mr Ablong referred to a call as a briefing, so let's take them to be the same thing.
Okay. Mr Hansford, you and your office's first involvement.
Certainly. So, Hamish Hansford, I'm the head of the Cyber and Infrastructure Security Centre and a group manager in the department. So, just to take you back, Optus formally reported under the Telecommunications Act, and we received that report on the 21st of September at 19:59 p.m. or 19:59.
Sorry, start that again. At
Wednesday, the 21st of September, 19:59. We formally received the mandatory cyber incident report, which was lodged with the Australian Cyber Security Centre and automatically forwarded to my centre because Optus ticked that yes, they would inform the regulator as well.
Yeah. So sorry, just before we go any further, presumably though that wasn't the first you had learned of this incident, that official report. Presumably there was some kind of advice before then that this had happened?
Prior to that, we were engaged with the Australian Cyber Security Centre, but not with Optus.
Yeah, so it's possible the ACSC was notified earlier than 7:59 p.m.
Indeed. But that's the formal mandatory cyber incident report under the Telecommunications Act.
Understood.
At 9:21 on Thursday, the 22nd of September, I provided some information to the Minister's office on possible regulatory actions and the notification of the mandatory cyber incident report under the Telecommunications Act in a purely regulatory function. So that's distinct, as the Secretary said, from any role that the Australian Cyber Security Centre might have played. We also had a very brief discussion with the Minister's office, the Minister's Chief of Staff and a Senior Advisor on Thursday, the 22nd of September at about 1900. We were en route to a different location, so we held that at the airport. Then throughout the course, just of Saturday the 24th of September through to Sunday the 25th of September, my records indicate we collectively in the department went with the Minister 8 times throughout that period.
Sorry, can you repeat that figure?
So on the weekend of Saturday the 24th of September and Sunday the 25th of September, my records indicate that a number of departmental officials met with the Minister via teleconference at least 8 times.
Okay. Sorry, I didn't hear you the first time.
Sorry, that's okay. On Saturday evening, I personally spoke to a senior member of Optus at about 2100.
Sorry, that was Saturday?
Yes, Saturday the 24th of September.
Yep.
And as the Secretary said, we're aware of other meetings with the Minister and Optus.
Could I just interrupt you, Mr Hansford? You seem to be preparing from a very detailed timeline, which would probably assist the committee. Is there any reason why that document can't be tabled?
Well, for one reason, I haven't seen it, and I'm not going to permit him to table it unless I have a look at it and consider it.
Okay, please continue, Mr Hansford.
And I think that takes us to the balance of your questions today.
Right, okay. Going back to that regulatory advice that you provided to the Minister on Thursday morning, did the Minister act on any of the regulatory options you provided to her, and if so, when?
Just to be clear, the advice was to the Minister's office, so two of her advisors copied formally to a registration process that we have to register emails that aren't submissions or otherwise. It was a brief update on actions, both to inform the Minister's office that a mandatory cyber incident report had both been provided, but also to outline some of the next regulatory steps that were underway from the Cyber and Infrastructure Security Centre.
Okay. So as for Mr Hansford's team, as I understand it, your evidence is that your first meeting with Optus was on Saturday the 24th. There were no meetings between your team and Optus prior to that?
Correct.
And as to Mr Ablong's
that, of
team...
course, doesn't rule out the possibility that other relevant government agencies
I know,
did
that's
that.
where I'm coming to right now. As for Mr Ablong's team or anyone else in the department, did they meet with Optus prior to Saturday the 24th?
Well, it would only otherwise be Mr Ablong's team, so
Okay.
can you address that question?
Not before that date, Senator. No, correct. And to be quite precise, excuse me, at the time the incident was first notified to Mr Hansford and to the Australian Cybersecurity Centre, it was that there had been a cyber incident. But the details of that incident as to what it involved was still subject to both Optus's own processes and those of our colleagues in other agencies. So there was no more information available than there has been a cyber incident.
Sure, I understand that. So when was, if it was not prior to Saturday the 24th of September, when was your first meeting or someone from your team's first meeting with Optus, Mr Ablong?
That would have been on the Monday, Senator.
Monday. Who else was present at that meeting on the Monday?
That was mainly our team and Optus representatives.
Was there anyone from the Minister's office present?
Not at that meeting, no.
No. What time of the day was that meeting?
I'll take that on notice in terms of time of day.
When is the first meeting that any departmental official participated in that the Minister's office also participated in with Optus? Or the Minister herself?
Senator, it was a little later in the process, around, according to my records, the 28th of September.
The 28th of September, so that's a Wednesday?
So we'll just check. There's two different things at play. Let me just take a step back, because otherwise the committee will get an incoherent picture. In the first 48 to 72 hours, the emphasis is very much on there's a fire brigades attending. That's ASD. There's been a penetration of the network. Mr Hansford is particularly looking at, is there a material impact on Australia's critical infrastructure? In other words, the provision of essential services. As it became more apparent through the course of, Mr Hansford will assist me through Friday and Saturday, that this was really a terrible a breach of data integrity, which would impact the lives of many, potentially from an identity point of view, but no material impact on Australia's functioning within the meaning of the SOCI legislation. Mr Hansford's team started to back off because it was clear that there was no immediate critical infrastructure harm, and that's where the consequence coordination team in Mr Ablong's area started to then move forward. What do you do about stolen identity? What do you do about replacement of passports, replacement of Medicare cards? So, because I've got personal knowledge of this, because I was on some of these calls, Mr Hansford, can you just carefully go through in sequence? You go first, Mr Ablong goes second, so we don't mislead the committee. On that Friday and Saturday, when we're looking at, has there been a significant material impact on Australia's critical infrastructure? When you were leading, in your knowledge, to the Senator's question, what involvement did the Minister or her staff having meetings that you were party to or facilitating?
Only so far as they are with Optus. That's the
understood.
aspect I'm interested in.
Sorry.
I'm aware of one meeting on Saturday evening, but I was not present. I spoke to Optus, as I said, after that meeting, and that was a meeting between the Minister
Sorry,
and
Mr Hansford, I've just got the urn in the background, so it's a little bit difficult
I was not
to hear.
at a meeting, but I'm aware of the fact of a meeting because of my conversation with Optus after that meeting.
And that was, to be clear,
Saturday
that
the
was the
24th.
Minister's office?
Involving
with the Minister.
The Minister's office and Optus. I was party to that call. I'll have to check my records as to when that occurred. We debriefed Mr Hansford and asked him to look at some options.
Yep.
Again, at this early stage when we're grappling with, is there an impact on critical
Understood.
infrastructure? So that took place through the course of Saturday
Okay, so I
evening.
just want to be clear. There was a meeting on the evening of Saturday the 21st of September. It was with Optus. It included members of Mr Hansford's team, but not Mr Hansford. And
No, it included, I think the Secretary said that
I think it was just me, wasn't it?
the Secretary
From
and the
department.
Minister.
Yeah.
right, so just to be clear, the Secretary and the Minister met with representatives from Optus on the Saturday evening of the 24th.
And we can take the details of that on notice as to participants and time.
Okay, I'd appreciate that, but can you tell me if the CEO of Optus was present at that meeting, that phone call?
I've got a clear recollection that that she was on the line, but we'll confirm that on notice.
Okay. So why would Optus say publicly, I think on the Tuesday, that the Minister had not yet received a briefing from Optus prior to her 7:30 interview, which I think was on Monday night, but I stand to be corrected?
Well, I'll check my own recollection and records. What the CEO might classify or categorise as a briefing might be different from what I understand it to be, but there were officers of her management team speaking in terms that I would consider to be providing factual updates to the Minister. I certainly heard those words. They were speaking in terms that I would consider to be an oral briefing. So I have no idea why either the CEO or her management team at Optus would say that. But again, we'll check the records. There was a debrief given to Mr Hansford, and there were some actions that arose that looked at whether particular sections of the legislation that he administers might be applicable, and that I think we worked into the late hours of Saturday, early Sunday.
Early Sunday morning?
Yes. So we'll have records of what was said to us, but I would find it difficult to accept that there was no engagement with the Minister by the company before that Monday. There's some reference to a media interview. I didn't quite catch your question, but the point's immaterial.
Yep.
I've been in this game for a long time. They were giving the Minister an oral update.
Okay.
I've no doubt about that, and I have personal knowledge of that because I was on that call.
Do you think it's possible that therefore the Optus CEO has misled the public about this?
I wouldn't care to comment on that. I'd need to see exactly what statement you're attributing to her. I'd want to look at the facts. I'd want to refresh my memory as to the call that we had with her and her management team, which from memory included both government relations as well as technical advisors. And I would be loath, in fact, I'd be more than loath, I would simply not wish to characterise her statements in any way, shape or form.
Sure.
Can I just very briefly make a point, Senator Patterson? I understand why you're asking the questions that you're asking, but of course one issue that hasn't been canvassed is the range of action that the Minister took in response to this as well. So I think it's important that a complete picture is provided.
Yes. Oh, yes.
As to avoid a perception that there's a lot incoming to the Minister. There was also a lot of action taken. And
this is the reason why I asked for a timeline, Minister, and I'm hoping on notice that all that information is provided. I want a complete picture of what the government knew when it knew it and what action it took.
Well, I'm sure the officials will be happy to talk you through some of the action that was taken in response to these issues as well.
Senator Patterson, I know you've got several blocks of questions to go through. I do need to hand over the call. If you could have one last question in this block, we will come back to you.
Thank you, I will. So as far as we know, based on the evidence presented here, the first interaction between the Minister and Optus was on Saturday night, which was 3 days after the attack occurred. It was quite clear, in my view, from media reporting on the Thursday that this potentially affected up to 10 million Optus users, and if so, would constitute the largest data breach in Australian history. Why did it take the Minister 3 days before she sought to meet with Optus?
Well, there's an assumption built into the question that there was no other engagement. From the point of view of the department, we're not operational. So from, when was it, Wednesday evening? Yes. Yep. So from the first reporting by the Australian Signals Directorate, and you can direct your inquiries to them, they are, if you will, the first responders. There's a fire there, the fire brigade, they turn up. They report to the Minister for Cyber Security, also happens to be my Minister as Minister for Home Affairs, so to properly reconstruct what the Minister knew, what she did, and picking up the Minister's comment from the table, if it's the Minister's if it's agreeable to the Minister, it might well be that the best way to deal contextually with the full chronology is if the Australian Signals Directorate and ourselves, perhaps, noting that we're under two different committees, of course, perhaps collaborate to give you an integrated chronology, because we both report to the same minister, and so there'd be then no chance of you being inadvertently misled through an omission of facts.
And of course, and if, again, Senator Patterson, no one should read into this, firstly, that there was not earlier contact with Optus by the minister, but secondly, that no action was taken in that intervening period. Even I haven't followed this as closely as you have, but even I'm aware of a range of action that the minister took and directed, even over the first initial period, as was appropriate.
Well, we are constrained by what is on the public record and what the department can put on the public record. All that we know from the evidence you've given, and I'd be happy to hear further evidence if it's different, is that the first phone call happened on Saturday, and we also know from the public record that the first statement was put out on Saturday, even though the minister was informed on Wednesday, i.e. 3 days after what appeared to be the largest data breach in Australian history.
Well, again, I think to be fair, I think you're trying to create an impression of a lack of action when what you're leaving out, because you haven't asked questions about it, is the action that was taken. And again,
on
I'm
the
sure
contrary,
the officials would be happy
Minister,
to
I
take
have
Senator
asked for a detailed
Senator
timeline.
Patterson, you've asked a couple of questions as a last question there. We will come back to you.
Thank you.
Senator Ciccone.
Thanks a lot, Chair. Look, I just wanted to probably take a step back around the framework and what are the practical operations with the SOCI framework, the Security of Critical Infrastructure Act framework, have on the protection of Australia's critical infrastructure?
Mr Hansford.
Well, a pretty broad question, Senator, but
I think it's an important one because it does put, I guess, the parameters and the framework and the context, thank you, Senator Polley, around what we're actually discussing today.
So, well, I think the first point is that in a definitional sense, following passage of legislation and royal assent on the 2nd of December in 2021, there's now a legislated definition of critical infrastructure in Australia across 11 different sectors and 22 types of critical infrastructure assets. So definitionally, we've effectively created a new community of critical infrastructure at law. For those critical infrastructure providers, there are three things that the Minister for Home Affairs can ask in terms of preventative or positive security obligations. And so the first one is mandatory cyber incident reporting, particularly relevant given the discussion just now, and being able to report relevant or significant cyber incidences that have actually impacted the functioning of critical infrastructure. That was commenced on the 8th of April with a grace period out to the 8th of July, and I think relevantly for 20 classes of critical infrastructure asset. In the first period, which is a period in the grace period from the 8th of April to the 30th of June, there were 12 reports as outlined in our annual report. And so we're getting a better understanding of successful cyber incidents that have occurred on critical infrastructure. So that's first obligation. Second obligation then is to provide information to a register of critical infrastructure, which again was switched on or commenced rather on the 8th of April with a grace period out to the 8th of October for those critical infrastructure assets not otherwise captured in the 2018 Act. There were a number of critical infrastructure that already provided information to the register. The Secretary of the Department's required to keep a register of critical infrastructure assets to really understand who has direct interest in those assets and who also has a direct influence in their operation, as well as where physically they're located. So really builds up a good corpus of understanding, particularly from our national risk perspective, about how infrastructure is interoperable and interrelated. So that's the second. And then the third obligation is a risk management program, effectively trying to say to critical infrastructure, can you look at the material impacts that might material risks that might impact the functioning of your infrastructure asset, and as far as practicable, mitigate those risks. And the Minister for Home Affairs, Minister O'Neill, is currently consulting industry on that obligation from the 3rd of October through till the 18th of November, and we're inviting submissions into that process, so that's open till the 18th of November. And so that's the critical infrastructure element. that there are some critical infrastructure that are so important to the functioning of our society, to our prosperity, security or defence as a nation, that Minister O'Neill has also declared 82 systems of national significance, as the Secretary outlined in his opening statement on the 30th of June 2022 from 38 entities. And we're working with those systems of national significance to really look at, first of all, the incident response planning and how we might collectively be able to respond to a cyber incident and have the plans in place to enable that to occur, as well as working on either exercises, vulnerability assessments or the provision of systems information into the Australian Signals Directorate. And then finally, in the event of a cyber incident where no other regulatory system of the Commonwealth or a state or territory would be able to be used, there's an escalating series of powers now at law that are able to be used in a cyber incident to gather information, to direct certain actions, or indeed for the government to intervene and respond.
And is this sort of unique just for Australia? I mean, are we a world leader when it comes to the critical infrastructure protections? Or are there other examples around the world?
Certainly, I think in a legislative sense, it's unique across the world. There are other jurisdictions which have similar concepts. France, for example, have had a framework on the protection of critical infrastructure since 2013. Doesn't have some of the powers that are in the critical infrastructure laws that we have. America, for example, has 16 critical infrastructure sectors, but doesn't have a cohesive single legislative framework. The UK, on evidence before their parliament, are developing a framework for critical infrastructure. India, for example, has a framework for the protection of national information infrastructure, and Singapore and Japan very, very similar. But in a legislative sense, I think this is unique. For example, we're one of 2 jurisdictions in the world, Germany being the other one, that have now called out data processing and storage as critical infrastructure.
Can you tell me how many companies have made mandatory reports on cyber security incidents in line with their new reporting obligations?
So there's been 12 mandatory cyber incident reports between 8 April and 30 June. There's also been a number of reports since 1st of July to the current period. We're seeing a continued number of reports, and as people get more familiar through our outreach programs, that we're seeing more and more people provide reports, some of which don't conform with the legislation. For example, might be a physical attack on an infrastructure provider, but we're starting to see a number of infrastructure providers provide those cyber incident reports, as well as telecommunications assets providing mandatory cyber incident reports under the Telecommunications Act.
And when was the first report?
When was the first report?
First report made. When was that made?
Well, we were counting it after the 8th of April, given the scheme was operable. I'll have to take on notice the specific date, but it was shortly thereafter.
Okay. You explain to me, maybe the benefit of the other committee as well, what are the thresholds that get applied here? Like, should a company report all incidents? At what point do they or don't they have to report?
Yeah, so there are 2 thresholds. The first threshold really goes to an incident having a significant impact on the functioning of a critical infrastructure asset, and the law now asks that is reported as soon as practicable within 12 hours. You can either do that orally or in a written form. If it's an oral report, there's 84 hours after to provide a written report, cognizant of the fact that an infrastructure provider might well be in the middle of an attack, and an oral report really puts them in contact with the ACSC, the Australian Signal Directorate's ACSC, and notifies formally under regulation. Our role is to set the regulatory framework, and it's really designed to get first advice into the ACSC to enable an effective response. So that's the first one. And the second relationship is really the notification of other cybersecurity incidences which are having a relevant impact on the infrastructure asset. So it's really looking at things that are actually having a successful cyber incident and something that's impacting the infrastructure asset, maybe the confidentiality of data, the integrity of the system.
Could you also explain to me what was the consultation that was undertaken to develop the critical infrastructure security reforms?
So the consultation started back in 2019 with the commencement of consultations under the development of the 2020 cybersecurity strategy. They both happened in 2019 and 2020. think it's fair to say one of the key features of the 2020 cybersecurity strategy was really a focus on critical infrastructure. And the launch of that strategy in August of 2020 really set off a consultation process on critical infrastructure, including legislative reform. A discussion paper was produced in August of 2020, and then a draft bill was consulted with infrastructure and introduced into the Parliament on the 20th of December. Then in December in 2020, and then between December 2020 right up until the 1st of April 2022, there was three pieces of work. The first it was really the first bill, which was then split in two after a Parliamentary Joint Committee on Intelligence and Security recommendation. So successive legislative reform, but also throughout that whole period, the department was undertaking consultation, for example, on the development of a risk management program, drafting the rule between October and February 2021 to 2022, including a range of town halls. The former minister, I think, did 5 roundtables with industry, a range of engagements, which then led to the introduction.
Which former minister?
Former
Andrews?
Minister Andrews.
Okay.
And so lots of engagement throughout that period. Then obviously passage on in March, and then Royal Assent on the 1st of April. And then since then, it's been a significant implementation task, including, for example, the current minister holding 5 roundtables with industry in August, the 30th of August, to really start the consultation process with industry on the risk management program. And as I said, now formally consulting on between 3 October and 18 November. But I think, fair to say, I think I counted up the other day that I'd spoken to or touched at least 15,000 people across Australia throughout the consultation period in one form or another. Some of those might have been double-ups, but quite a significant amount of consultation over at least 2.5 years.
And out of interest, did Optus participate?
Yes.
In those consultations? They did? Were the departments of infrastructure, transport, regional development, communications aware of the concerns, or any other departments aware of the concerns raised by Optus?
Of what concerns?
Well, as part of that consultation, had Optus sort of spoken to not just the department, but were there any concerns that those departments were aware that Optus had raised at the time as part of those consultations?
I think, as a matter of public record, Mr Hansford will correct me, there were submissions that that company made through the legislative process when the bill was being examined in committee. We work across government, so all the departments, there might be a lead department, we had carriage of the legislation, but we certainly consult within government, take views from our colleagues in, whether it's infrastructure, transport, Attorney Generals and the like. Whether Optus put those concerns directly to that department, which is responsible for communications, you'll have to ask that department in the appropriate committee. But Optus itself voiced concerns that we did not agree with. And indeed, we made the point in our own evidence, principally to the Parliamentary Joint Committee on Intelligence and Security that had carriage of the oversight, that it would be problematic potentially to have a complete carve-out. The government of the day decided by way of resolution of whether to regulate for telco compliance as a critical infrastructure provider, to vest most of the provisions, although I would contend to this committee on the face of the legislation probably of a lower standard in the Telco Act or the Telecommunications Act, and that's the only sector that was so treated.
And I'm glad you raised it, because as I understand it,
sorry, I think that's right. That's and Defence had particular...
Defence as well?
There are some defence critical infrastructure matters that are dealt with under the Defence Act, is it, Mr Hansford?
Yeah, and the Defence Industry Security Program as well.
But legislatively...
legislatively, yeah, correct.
It have to be the Defence... There's got to be an Act of Parliament. You can't pursue legislative power without an Act. But anyway. So, but largely it's the telco industry that sought, and the government of the day effectively, if you will, fashioned a compromise whereby a degree of critical infrastructure protection was vested into the Telco Act that's not otherwise available to other industries that are managed or overseen through the SOCI Act.
So were the obligations under the Telecommunications Act then deemed to be unsuitable?
Deemed to be unsuitable by
Yes.
whom?
Well,
Sorry.
by government, because and just to go from that point, my understanding was that government had advised the Joint Parliamentary Committee on Intelligence Security that the SOCI obligations would only be switched on for
Yes.
the telecommunications sector if the obligations under the
In certain
Telecommunications
circumstances,
Act
that's right. So,
weren't suitable.
That's right. So,
Is that right?
So we provided evidence through the legislative process that there were interdependencies between the two acts, and perhaps Mr Hansford could briefly summarise how the two acts work in harmony.
Certainly. So I'll take the three obligations. The first is a mandatory cyber incident report that Minister Rowland made a declaration or a determination, depending on whether or not it's a carrier or a carriage service provider, on the 5th of July, which came into effect on the 7th of July. So that dealt with the mandatory cyber incident reporting under the Telecommunications Act, as well as the register requirement, which is a second obligation, a positive security obligation for critical infrastructure under SOCI, but it was done under the Telecommunications Act also on the same date.
So did you say Minister Rowland?
Yes.
So under under the new government?
Yes.
Okay.
So two instruments there, or declarations of determinations rather, and then the risk management program obligation has not been turned on or commenced for telecommunications assets, and the reliance there is on Part 14 of the Telecommunications Act, which effectively says for telecommunications providers to do their best to prevent against unlawful interference in telecommunications networks or to prevent the commission of a criminal offence, and that's the obligation which is relied on in terms of the security obligations on telecommunications assets, as opposed to the imposition of a risk management program under the Security of Critical Infrastructure Act.
So just so I'm clear, the former government failed to include the telecommunications sector.
No, that's not the burden of the evidence. The government, which obviously puts bills to the Parliament and then they're adjusted subject to amendments being pursued, took the view that for this sector, take a step back.
Yep.
Imagine if you had the 11 sectors regulated under individual pieces of legislation. You would regulate for critical infrastructure protection of banking under the Banking Act, 1958, I think it is, and so on and so forth. So you'd have this vertical set of separated pieces of legislation, but all of which deal with the same horizontal problem, which is a cyber attack on critical infrastructure that takes out essential services or security or economic infrastructure. In the case of the telecommunications sector, which has been long regulated and had a lot of designed-in regulation built over many years, the government took the view, and it's apparent on the legislation that was both put forward as a bill and then ultimately passed, that there were certain thresholds that, as long as telecommunications companies met those under the Telecommunications Act, there was no need for an override or of an over-the-top action coming out of SOCI.
Okay.
So they weren't carved out or excluded, but they were allowed, if you like, to act under the Telecommunications Act to a certain level of threshold.
Right.
And then, as Mr Hansford's described, if certain thresholds were met, SOCI would come in over the top. So they're not excluded.
So the former Home Affairs Minister never had to, switch on those obligations?
You might just answer the question about switching.
Those reporting obligations?
So, there's the communications sector, so that's a legislative definition.
Yes.
Critical telecommunications assets are also the asset definition. The Part 2, the register, was not turned on or commenced under SOCI. The mandatory cyber incident reporting has not commenced under SOCI for telecommunications assets, nor has the risk management program. For a complete answer, the telecommunications assets are available, if you like, to receive a ministerial direction for certain activities if there's an adverse security assessment from ASIO, also in scope to respond to a cybersecurity incident if one occurred. And I think the last point is, in terms of the Declaration of Systems of National Significance, our annual report at page 343 includes entities in the communications sector.
Okay. I might just leave it there for now and
I do need to give the
pass back to the
call.
chair.
We can come back to you, Senator
Thank
Ciccone.
you.
Senator Shoebridge, you have questions?
Thanks, Chair, I do. Mr Pizzullo, I might go back to page 28 of the portfolio budget statements in relation to the department. You'll recall I asked questions earlier about this. The budget has the total expenses for the cybersecurity program in Home Affairs increasing from 17 million last year to 56 million, 56.7 million this year. What is that increase for, apart from, and does it include the cyber hub?
Yes, thank you. I might ask, Senator, if Ms Cargill joins us initially just to give us the breakdown of the figures, and then Mr Ablong and his deputy can speak to what those functions entail. So perhaps Ms Cargill, if you go first, just to explain, as you did earlier in another matter, what just the breakdown of those figures involve, and then any questions about the functions or the technical details can go to Mr Ablong.
Certainly. So, Program 1.3, Cyber Security.
What's the increase for?
Yes, so the movement in the departmental expenses between 21-22 and 22-23 is an increase of $19.2 million. It's made up of a number of measures. So we had the first measure in the Cyber Hub series, so the March 2022-23 budget measure, named the Digital Economy Strategy, was an increase of $9.3 million in 22-23. We also had 4.
Sorry, was that nine? Was that you said for the Cyber Hub?
That's correct, which was a part of the Digital Economy Strategy measure from the March budget.
But the Cyber Hub is valued at 8.6.
That's correct. That's the October measure. So there's two in 22-23.
So there's an initial 9.3.
That's right, 9.3, and the second measure was in the October budget, which was called the Cyber Hubs Pilot Extension. That was an additional $6.4 million to the department. In addition to that, there was
just stopping you there. In the payment measures part of the budget, it gives a value to the Cyber Hubs Pilot Extension for Department of Home Affairs at 8.6 million.
That's correct.
I thought you said 6.4.
Sorry, my mistake. $8.6 million is the Department of Home Affairs share.
Okay.
In addition, there was a measure in the October budget called Fighting Online Scams, which was an additional $2 million in 22-23.
Yep.
And there was an offset in terms of savings from external labour and savings from the government's election commitment of $1.2 million.
All right.
And the net is actually a measure from March, which was in relation to the Women's Safety Package, which had a number of elements for the department of $4.9 million. So that's the net increase in 22-23 for departmental.
So 17.
So that's a total of
$17.9 million for Cyber Hubs.
Correct, departmental.
Yep. And that's for the Cyber Hub inside Home Affairs?
Correct. There was a whole of government measure, which was, I think, from memory, $31 million. Our share was the 8.6.
All right, but in this 8.6 in the October budget, but there'd already been 9.3 kicked in
March
earlier. So the total for the Cyber Hub is 17.9.
That's right. The initial measure was for the first 6 months, and then the second measure extended it for the second 6 months of the financial year.
And then you've got $2 million on scams.
That's right.
All right. And what about the increase in appropriations also for cyber security, the $16 million there?
In the administered expenses? So the explanation for that is it was a movement of funds in relation to the Cybercrime Capability Fund due to some delays in project commencements.
So nothing new, just unspent
No,
funds.
it was a movement of funds. So it's a net reduction in 21-22 and an increase into 22-23.
And the Cyber Hub is only funded until the 30th,
That's
until the
correct.
end of this financial year?
That's correct.
And absent additional funding, I assume those resources will be lost?
Absent additional funding.
I think it's fair to be, in the interest of completeness, Senator, we've been given authority to work across a number of agencies to look at what a broader hardening of government infrastructure would look like. And so we've been asked to go back to government. I just can't quite recall, but it's in the May budget.
It would be as a terminating measure, yes.
So in the May budget of next year, a number of agencies, there are agencies that focus on the delivery of government services, which typically are highly internet connected, obviously the Australian Signals Directorate our role as coordinator. The Attorney-General's departments involved, given their responsibilities for the protective security framework, will come together as a collective group and advise government on, in the current state of cyber, what additional measures might need to be contemplated to harden up government systems.
But looking at the budget, there's from the October budget, there's an additional $8.6 billion for cyber security, and that's for the continuation of the hub, and that's really the only additional cyber security money in the October
Plus the
budget.
fighting online scams, the additional $2 million.
Yes, but that's
offset by
more
saving.
educative. That's not actually preventative.
So
That's
those
educative,
funds
isn't it? Yes.
will get us through to June of next year. It's a terminating measure, is it not?
Correct.
But as I've just, in the evidence I've just given you, the government is seized, not just in relation to the data matter that we spoke about earlier, but just more generally, given its access to threat intelligence and likely developments in this area. The government systems that are internet-facing have to be hardened, and the government's asked us for advice that we'll coordinate with the Australian Signals Directorate and with other departments and give a joined-up view to ministers about what they might wish to consider in next year's budget.
Yeah, but that's awkward, isn't it? In light of the fact that the forward estimates, the estimate for next year's budget, actually has the cyber security budget for Home Affairs going backwards from what it was in 2021-22. It actually has it going backwards by more than $1 million. Is it anticipated there'll be less of a cyber risk in 23-24 than there was in 21-22?
Well, as with any lapsing or terminating measure, when you look at the in-year funding and compare it to the forward estimates, by definition, if a measure is terminating, it gets zeroed out. But that's the thing about budgets. You then come back and have another budget, and then that creates new forward estimates.
I'm talking about the 21-22 budget that's already been spent. The forward estimates, just despite the savage series of cyber security threats that we've seen, the forward estimates in this budget has your department spending less in 23-24 on cyber security than was spent in 21-22. That seems extraordinary, an extraordinary lack of foresight.
So, sorry, spending less when you compare it to what's
21-22.
On actuals?
Correct.
21-22 estimated actual 17,144 and 23-24 is 17,879.
Well, the departmental total was 13.5 and it goes down
Yep.
to 12.279.
That's correct. The administered number goes up
Yeah.
from 3.6 to
at
5.6.
best, well, the departmental goes down and the total spend flatlines.
That's correct, and that's due to the series of terminating measures as the Secretary has outlined. So the Cyber Hubs pilot, as we've said, is only funded till June. Then the other measures from the March budget, particularly as they relate to the digital economy strategy, are also terminating, and the women's safety budget measure.
Senator Shubridge, I mean, it's important to recognise that the government has already begun a thorough review of our cyber security environment, which will feed into next year's budget. So you shouldn't assume that the forward estimates as they currently stand remain that way. What we've done, and frankly...
You only just did them in October.
Yeah,
you're junking them already. We're still in October and you're already junking your forward estimates.
There are a number of ministers, myself included, who have used the October budget as a, if you like, a stopgap opportunity to put extra funding into important priorities, cybersecurity, biosecurity, a range of other things, pending more detailed work that will feed into next year's budget, and cybersecurity is a good example of that.
Well, Minister, you're not even 4 days out from the budget and you've already junked the forward estimates that were delivered in the budget. Because it's embarrassing, isn't it? It's embarrassing that there's less money being spent.
What's embarrassing is your
23-24 than there was
deliberate misinterpretation of the budget. I'm not junking the forward estimates. The budget reflects the forward estimates as they stand. What I'm saying to you is that they are likely to change in next year's budget once the thorough review of cybersecurity is undertaken. You could make the same point about items in the agriculture budget that I oversee or the emergency management budget that I oversee, where figures are like...
rubbery.
They're not rubbery. They're
Not to be
accurate as they
trusted.
currently stand. They're accurate as they currently stand. But this is what we predict to spend in the next 4 years based on current policy settings. In next year's budget, those figures will change because different policies will have been decided, including in the space of cybersecurity.
The only meaningful additional expenditure on cybersecurity in this budget is on a pilot project that's going to terminate in about 7 months' time. Minister, how do you explain that? How do you explain that the only additional expenditure is on a pilot program that's going to come to an end in the middle of next year? Given we've had not just Optus, we've had Medibank, we've had AFP, we've had Mofo. I mean, we've probably had another today while we've been sitting here. And your only spend is not strategic, but on a pilot program that ends in 7 months' time.
Well, again, the departmental officials are more across the details of this department's budget than I am, but my understanding is that this budget has extended the existing pilot.
The Morrison government pilot.
Yes, provided...
That's your only idea.
Yeah, it's there. It was brought in by the former government. It's been extended by our government as an immediate injection or continuation of funds while a more thorough piece of work is undertaken. If we had had a government that at any point over the last 9 years had taken these issues seriously, we may have a more thorough piece of work already undertaken around cybersecurity, but that has fallen to our government and this Minister O'Neill, to do.
Well, what are the parameters of this inchoate work on cybersecurity? Who's leading it?
When you say inchoate, I'm not sure that I would accept it, but I won't engage in a debate about it.
By all means, give me details.
Thank you.
About
So
it.
there's a formal comeback that sits across necessarily a number of agencies, because some of it relates to the design of government service delivery, which falls to the Digital Transformation Agency that has overriding responsibility for government architecture, because if you don't get your architecture right, you can't do cybersecurity. The Australian Signals Directorate, which has highly classified as well as other means of providing advice on the threat picture. The Department of Home Affairs, which is the Commonwealth Cybersecurity Coordination Department, and then the fourth entity that's critical here are our colleagues in the Attorney General's Department, who oversee what's known as a protective security framework.
My question really was who's leading it? Is it a committee?
Partnerships and collaboration work this way. You bring the team together. We'll pull the work together with the DTA, because they're the technically competent agency that deals with what's known as government IT architecture. I can unpack that term if you wish me to. And the Australian Signals Directorate is the advisory body on threat, and we'll pull it together as a submission.
So you will be leading it. Home Affairs will be leading it and putting a submission ultimately to the Minister and/or Treasury for funding. Is that right?
It'll be a whole of government review, and then decisions will need to be taken in accordance with the budget rules as to whether within that framework individual departments and agencies have to bid in through new policy proposals, or whether it's done as one job lot. I'll just check with Ms Cargill whether any guidance has been delivered by government under the budget rules as to whether it will be one omnibus submission with a single new policy proposal, or whether it will be an overarching framework within which departments and agencies will have to put forward NPPs individually. Ms Cargill, do you have any guidance on that from government?
Whether it's an omnibus or an overarching framework. Okay, sure.
So there is no specific guidance at this point
Thank you.
in relation to the 23-24 budget.
Thank you.
So what is the purpose of Home Affairs Cyber Hub? What's its purpose?
A hub...
the Home Affairs one?
Yep. So it's, to give it its full context, there are a number of hubs where you cluster, aggregate across, what was the last count, 195 PGPA authorities, something like that. So across government there are, under the public governance and...
I really just want the purpose of the hub, though.
I'm explaining it to you. Thank you.
Not a full history, just the purpose.
Well, without the context, you'll ask me questions that won't be informed by context.
Focus on the question.
I am.
Yep.
So cyber hubs are an attempt to aggregate, consolidate and move from a circumstance as a decision taken by the former government that the Minister Watt has spoken about, to go from each PGPA accountable authority, like I am, to say, you've got to look after your own system.
You'll have to, excuse me, PGPA accountable authority.
Well, that's what I was explaining before you interrupted me, Senator.
No, just don't do the acronym. I don't know the history.
Senator Shoebridge, the Secretary doesn't need direction from you how to answer the question. He can answer the question. Thank you.
I'll answer as I was setting out to. Under the Public Governance Performance and Accountability Act, Commonwealth 2013, a departmental head or an agency head is what's known as an accountable authority for everything that goes on in their department. IT systems, workforce, you name it. Through what I would describe, and this is my term, the fragmentation of IT procurement that's gone on over 25 years, there is something like 195, this is over a quarter of a century, 195 vendor arrangements, cybersecurity, gateways, protective systems. Any attacker looking at that would say, and I'm not going to give away exactly how they do it, gosh, there are a lot of gap seams and fragmented seams between government. So hubs are an idea of harbouring all of those agencies into a number, 3, 4, 5, it might end up being a number greater or less than that, so that there is a single overarching shield around whether you're the Bureau of Folding Chairs, and I'm not going to name agencies, so I'll just use descriptive terms, or the Bureau of this, that or the other. You are harboured within a hub and protected by the hub. Let's say there's 4. The government hasn't made a final decision.
I think there's currently 4.
In the pilot stage. Yep. Let's say the final architecture gives us 4. Let's just, for argument's sake, say that. The Australian Signals Directorate then would be an overwatch authority because they've got what are known as what are very highly classified tools that can then protect those 4 hubs. So it's about bundling all agencies within 3, 4 or 5, whatever number ends up being. That gives us scale, and it means that our defenders have got fewer gaps and seams to have to protect.
So what happens in the middle of next year when the hub funding runs out? Does the hub fall over?
All I can do is repeat the Minister's evidence of my own. The government will consider this matter in the May 23 budget.
But I'm looking at the
Senator
budget.
Shoebridge,
There is no
sorry,
funding
Senator
for it.
Shoebridge,
I'm sure you'll be aware that...
You can take us to the break, but it means you'll have a few less questions time afterwards. Otherwise, I need to hand the call to another senator in the interest of fairness.
Well, if I could just finish on the hub. On the current budget, and looking at the forward estimates, on the 30th of June, the hub falls over and we go back to the, I think, as you described it, fractured framework.
I've got a very high level of confidence that's not going to happen because I think a compelling case will be made to the contrary.
Thanks. Senator Patterson, do you want a call to the break?
Yeah, I have. I want to move on to a Medibank timeline, but before I do that, I might just do a few quick questions that will take us to the break, and then we can resume after the break on that. Some of them go to Mr Hansford and relate to critical infrastructure, so he might like to rejoin us.
Mr Hansford.
Mr Hansford, these are follow-up questions from the questions that Senator Ciccone asked you about the Critical Infrastructure Act. I heard you make a couple of references to other countries and other regimes. How would you characterise Australia's critical infrastructure laws compared to other like-minded countries?
I think I'd describe them as unique. That I think Australia is, to my knowledge, the only country that has legislated a full set of critical infrastructure powers, definitions, positive obligations, and indeed created a new class of systems of national significance comparative to other countries. I look across the world at the moment and different countries are trying to do elements of the reforms, but I haven't seen anywhere that people have approached it in quite this way. I think different countries are looking at a sectoral basis, perhaps looking at their own cybersecurity and supply chain settings on different sectoral levels, and some countries get to a stage where they think about frameworks to pull it together, but I haven't quite seen a Security of Critical Infrastructure Act equivalent in the same way that Australia has.
Would you describe it as world-leading?
I think you could describe it that way, yes.
Why then does the Minister for Home Affairs repeatedly and publicly say that Australia is 5 years behind on this legislation? Which country is 5 years ahead of Australia on critical infrastructure legislation?
Well, I think that when you look at particularly the cyber security uplift under the risk management program, it's trying to set a baseline for critical infrastructure in the Australian economy. Other jurisdictions have elements of their critical infrastructure have high-level cybersecurity standards. For example, currently in the US on pipeline security, there are more and more cyber standards that the Transportation Security
Sure, but just to be clear,
Administration
Mr Hansford, you wouldn't say that the US critical infrastructure laws go further or are more powerful than ours, would you?
I think that as a package, no one's done it in quite the same way.
I think, Mr Hansford, just to, in the interest of us all being able to get a cup of tea, if you don't mind, I think the Senator's question goes to Minister O'Neill's commentary about legislative evolution, and I'm familiar with those remarks, and in fact, I'm quite familiar with her views, given that I advise her on this. On critical infrastructure, so as to not create a misleading impression of what Ms O'Neill has said. She has commended the passage of the critical infrastructure legislation that Mr Hansford's been describing for what you might describe, and this is my term to paraphrase her, the sort of harder perimeter protection that unfortunately Senator Shoebridge won't hear about because he's left, but that cyber uplift and the perimeter protection, we have, there's no question, unique, and indeed I would double down on the evidence to say it's world leading, especially in relation to the ability of government to be able to share highly sensitive information, and in extremis, as you will know, given your other roles, to be able to deploy some of our most sensitive national security capabilities onto domestic networks, which is a very vexed question. Most of my colleagues say to me, so your signals in agency can actually deploy onto your banks. We could never get that through our parliament. What Ms O'Neill has been referring to, and this has been our lived experience, and regrettably I think we're going to see this recurring, it's the interplay between that hard protective layer, the critical infrastructure perimeter protection, with what then happens when, despite all best efforts, data leaks out. So questions about consumer law, questions about digital identity, questions about notification regimes under other regulatory arrangements. Her commentary, as I read it fairly, relates really to the consequence management, not so much of managing the immediate incident. So I spoke earlier about how ASD, turn up when the cyber fire is happening, and the cyber fire is happening, and in this case that started on that Wednesday and Thursday. But once the data is exfiltrated, you are beyond a cyber incident. You're into a massive or significant data spill. And whether our laws are fit for purpose, as I recall the public commentary that she's made, really speaks to other adjunct laws, regimes and regulatory schemes that are consequentially impacted, say take digital identity as an example, not to say that they're deficiently dealt with under the Critical Infrastructure Act, although as I was perhaps alluding to gently to Senator Ciccone before, perhaps there is a need to revisit the question of telco obligations, and perhaps that's a question that we'll need to come back to in subsequent sessions of this committee after the government's considered that matter. But in relation to moving beyond what I describe as the cyber security treatment, the incident treatment, how do you deal with consequence? And Ms O'Neill, I think, quite properly focused attention on that.
And it was those things that we are 5 years behind.
Pardon me?
And it was those things that we're 5 years behind other countries.
Okay, well,
The committee will suspend for afternoon tea, being 3:15, and we will return at 3:30 p.m. And you'll have the call at that time, Senator
Thank you,
Patterson. Thank you. The hearing there, Senators. We're still with outcome 1. I just want to note, for the purpose of senators and officials, today we still have outcome 1 to finish, outcome 2 to start, outcome 3 to start, and ASIO appearing at 4:30. That doesn't seem like a very manageable time period, but I'll ask senators to work with us, put questions on notice if they can, and we'll have a discussion about where we're at 4:30 when ASIO is due to appear.
Could I just check, Chair, on behalf of my colleague, the Director General, is it anticipated that the Director General and his officers will be called?
There's a strong desire from some senators to call the
Thank you.
today.
He'll be watching, or his staff will be watching, so that's very helpful. Thank you.
It will be on the basis that senators may need to move other outcomes to another day or another time. We're having that discussion. So
thank you, Chair.
Just to remove any doubt, to assist you in chairing, from the perspective of the coalition senators, we don't think there's any prospect of us reaching ASIO today. But I just wanted to make that clear in case you're, I don't know who you're having discussions with, but from our perspective, we don't see any prospect of getting to ASIO today.
Okay, thank you. Senator Patterson, you've got the call.
Thank you, Chair. I just want to return to one other area of follow-up, and then I'll move on to Medibank in relation to Senator Ciccone's questioning. Mr Pizzullo, you answered a question from Senator Ciccone about the extent to which the telecommunications industry was captured by the Critical Infrastructure Act.
Yes.
And you said, and I quote, they are not excluded, they are not carved out.
Yes.
I'm trying to reconcile that statement with a statement that the Minister made on ABC Radio Melbourne, speaking to the presenter Raphael Epstein on the 26th of November, and she said, and I quote, "One of the things that your listeners might be interested in is the former government put in place very significant new laws to try to help us manage cybersecurity as essentially a national security issue, acknowledging that when something like this happens with Optus, this affects not just customers at a private level, but actually creates problems for the whole community. So they created this new law, but excluded telecommunications companies from that law." That's not a true statement, is it? They are included in the law, aren't they?
Can I just confirm, did I hear you say the 26th of November?
Yes. Oh, sorry, no, that wouldn't be right, would it? It would be the 26th of September.
Right.
Yes, it was the 26th of September. Thank you for that correction.
I'd want to see the full context of the transcript, because I know that she's also been asked about whether the differential obligations that I explained earlier require attention, and I know it to be the case that she does think that they require attention. So I'd be loath to comment just on that specific extract without seeing the context of the rest of the paragraph of the transcript that sits around it. On its face, it's clear that telcos are included at a lower, let's say at a lower threshold of involvement, and the obligations principally occur, and she's absolutely right on this point, the obligations arise in the first instance under the Telecommunications Act, and then certain trips have to be, or thresholds have to be met before SOCI provisions start to cut in. So Mr Hansford might want to return to the table.
Yeah,
but that's
and perhaps just to assist you, I can include a bit more material from the Minister from that interview. She went on to say, "So I, as Cybersecurity Minister, will have the power to set minimum cybersecurity standards for lots of sectors of the economy." And then Raphael Epstein said, "But you can't for telcos?" And she said, "Exactly, yes." That's not a true statement, is it?
Her powers to do so in relation to telecommunications assets are fettered, but Mr Hansford might wish to explain better what that means.
So I think the Minister's comments may well refer to the application of a risk management program under SOCI, and in order to apply a risk management program, the Minister has to have regard to other regulatory systems of the Commonwealth that might exist, or states and territories indeed. And so in order to apply the risk management program, the Minister would have to have regard to those requirements in Part 14 of the Telecommunications Act and the extent to which they either do the same thing or a similar thing, so she'd have to have regard to that. And so effectively, if you applied a risk management program to telecommunications assets, it would be potentially a duplicative obligation between Part 14 of the Telco Act and the risk management program.
What are the criteria that the Minister needs to consider before deciding to apply it to the telecommunications industry?
So the Minister has to undertake consultation under the Act and either set out a draft application rule, i.e. who the obligation would apply to, and can make subordinate rules about more granular details about what would be included in a risk management program. And then the Minister has to have regard to the elements of the... Just finding the place in the Act.
While Mr Hansford doing that, just for the benefit of the committee, I've just got the full transcript in front of me. The Minister very clearly, after she's interrupted by Mr Epstein in the way that you've described, does go on to say that the government will be looking at this question: is it appropriate that telecommunications companies can basically manage their standards under other laws? So she does make the reference to the fact that the telecommunications sector is governed principally under another law, that is to say the Telecommunications Act, and that harmonisation, by a clear reading of her transcript, is something that the Albanese government is going to be looking at.
I think it's a very generous reading of the transcript, given the Minister said that they're excluded from the Act and that she cannot set minimum cybersecurity standards. Isn't it true, Mr Hansford, if the Minister is satisfied that it is necessary, the Minister can include the telecommunications sector and their assets in the risk management program?
So under section 30AH, subsection 6, the Minister has to have regard to any existing regulatory system of the Commonwealth, state or territory that imposes obligations on, in this case, telecommunications assets, the costs that are likely to be incurred, the reasonableness and proportionality of the requirements, and any other matters that the Minister considers relevant, and that may well include other duplicative obligations and the extent to which two laws duplicate each other.
But the Minister is not prevented by the Act from issuing regulations in respect to the risk management program for cybersecurity for the telecommunications sector, is she?
Well,
she just has to be satisfied of
she has
certain criteria, and then the Minister's able to do so.
Well, she has to have regard to any other regulatory system of the Commonwealth, and I think at law there is a regulatory system of the Commonwealth that does elements.
Have regard to does not mean cannot.
That's correct.
So if the Minister, for example, Minister, I will come to you.
No, I think the point that has been made a few times and you haven't taken on board is that, which I think I've heard, is that the Minister's powers are severely fettered.
I don't think I agree with your characterisation of severely.
Well, they are fettered. Those powers are fettered. They are not as strong as they are in relation to other sectors.
The Minister did not say my powers are fettered. She did not say I have to have regard to other regulation. The Minister said I cannot issue regulations for minimum cybersecurity standards for the telecommunications industry, and that is not true. Is it?
We're just having a look at the transcript.
Okay.
It makes very clear reference to the fact that those companies are regulated under other laws, and she has to have regard to the fact as to whether that's sufficient. I mean,
it doesn't actually. Where does it say she has to have regard?
I'm just reading. I'm just trying to paraphrase. I'm just looking at the transcript.
Secretary, you're doing an admirable job of explaining and cleaning up for your Minister, and I commend you for it. You're showing real dexterity in doing so, but the...
Well, it's incredibly small. I'm just trying to read this. These
let
devices
me
are
assist. Perhaps let's move this conversation on to a future focused. Mr Hansford, is it your evidence that the government will not include the telecommunications sector in the risk management programs?
Well, I think the government also has to have regard to the Parliamentary Joint Committee on Intelligence and Security's report as well, of which the government will consider a response to that committee's report, which also goes to the point about duplicative effort between TSSR or SOCI, and the committee makes the recommendation that... the telecommunications sector reform. So Part 14 of the Telecommunications Act, as well as SOCI, the committee effectively, to paraphrase the recommendations, says you shouldn't have duplicative obligations. So the government will have to consider that report and respond, as well as consider any public interest criteria in SOCI.
Thank you, Mr Hansford. I'm familiar with the recommendations, given I was the chair of the committee, as you know, that made those recommendations. The committee did not say that we should apply a lower standard to any sector. In fact, I think the committee was very clear that it wanted a bare minimum standard which everyone should have to meet, and that some sectors should have a higher standard, and if it was necessary for them to have a higher standard, then so be it. It doesn't make our country safer to tell a sector to do the same thing twice, to the point about duplication. But if it is the case that the TSSR regulations are inadequate, the committee wanted the Minister to have the power to impose obligations under SOCI, which they do.
And I wouldn't disagree with any of that by way of characterisation of the current position, save to say that given that the Act requires the Minister to have regard, and as you know, that there's potency in those words, it creates a litigation opportunity in terms of both a merits review process and potentially a judicial review process, because these are always in the eyes of the beholder, where an affected party might come along and say, oh, hang on, Minister, you've made a decision, but you haven't had sufficient regard to the fact that we're well regulated, we've protected our systems, we've patched this and we've patched that. I would certainly contend, and I did so to the committee of which you were a chair, and I would say it to this committee, it would be better to ensure that there's regulatory harmony, not to have... I've called it a fetter. That was the phrase I advised the Minister to use, where a Minister has to have contemplation, am I going to get sued, or is the action going to be blocked through judicial review if I don't have sufficient regard, if there's an arguable case to say, we've done everything that we're required to do under the Telco Act, you're now imposing something that's duplicative. It certainly would be my preference, and I just state that as a fact, because I've said this to the PJCIS, so I'm on the record, that we have a completely harmonised system. Now, that'll be a matter for government. There's a report to respond to that the PJCIS has brought down saying, is it in fact sensible to have part 14? Part 14 over here in splendid isolation, having this interdependency linkage with SOCI at large. I know what we'll be submitting, and obviously it's advice that we'll be providing to this government in the first instance, and they'll make a decision about whether or not an amendment's required. But it certainly creates a feta or a step that has to be gone through that no other sector has to go through.
So just to be clear, is it the advice of the department that the telecommunications sector cannot be included in the risk management program without a change to the law?
As the two acts are currently drafted?
Yes.
What's the answer to that, Mr Hansford? What's your view?
I think in order to look at the existing regulatory system, you couldn't have two duplicative systems on the statute books. And I think that the Minister would have to regard to Part 14 before applying any additional obligations.
Yeah, that doesn't answer my question. Is it necessary to change the SOCI Act to impose a risk management program on the telecommunications sector?
Can I just jump in
Or,
here?
sorry, Minister,
When I was on your side of the table, Senator Patterson, and I asked these types of questions, I was told that it was inappropriate to ask departmental officials to provide advice or provide opinions, and that's the nature of the questions that you're asking. I was told, I spent 6 years being told that.
Minister, I'm not asking the officials for their opinion on whether it's desirable, although
You're asking them for interpretations of legislation.
Minister, please allow me to answer. I asked this question. I have not asked the officials to express an opinion on whether it's desirable, but in fact, Mr Pezzullo has already said that in his view it is desirable. So he has freely advanced his own opinion on a matter of legislation. I'm not even asking him or Mr Hansford to go that far. I'm just asking to know whether or not it's possible for the Minister to issue a regulation for an RMP for the telecommunications sector without changing the Act. I think it is very clear that the Minister can do so as long as they have regard for those relevant facts.
2 points, if I might. I was merely drawing the committee's attention to the fact that I'm on the public record when I appeared before you in another committee of having that view. So if you want to Google my view, it's on Hansard, and that was a...
Mike Pezzullo desirable? Is that what you Googled?
I wouldn't Google that in a... I wouldn't Google that. But the point being, Minister, that I wasn't advancing new advice at this table. I'm saying that in the past, historically, when I've appeared before another committee, I've said, it'd be preferable to do things in a different way. And as to the question, the law as written would require the Minister to have regard to do, in order to do what you've just contended in your question, she'd have to have regard to a number of factors. She could well come to the view that, no, I've had regard, I'm still going to impose an RMP, which is the point, I think, of your question.
Thank you, that is my point. I'm not sure why it took 10 minutes to get to that point, but that is my point.
But I should add...
You could let the
and of course,
Secretary finish the answer.
And then, of course, that would then create the risk of litigation because of the different views that people might have as to the adequacy of her regard. That's my point. That's the feta.
Thank you. I understand your point.
Thank you.
Okay, moving on to the Medibank timeline.
Senator Patterson, can I just interrupt you briefly
You can.
to assist the committee? You've got a little bit more time in this block. We have had some negotiations in that time and have agreed that we won't reach ASIO today, and if we could let those officials and agency know that that is the case.
Thank you, Chair. I'm sure that they'll be watching.
I wanted to do that as early as possible in this session. In saying that, there is still a very strong desire to reach outcome 2. Outcome 1 originally had an hour and a half in the program, and we're getting close to that time period now. So we'll move on. Senator Patterson, you've got another couple of questions, and then we have to hand the call over.
Thanks, Chair. This will be a block of questions about the Medibank timeline.
Come back to a block.
Yeah, if it assists you, it might be easier to do it that way rather than interrupt.
Senator Roberts, you have some questions which we will come to.
Thank you.
I'll assist you in that. I know that Senator Ciccone has some follow-ups from earlier before that I'll let him ask now, and we'll come to Senator Roberts after that.
Okay, thank you very much, Chair. Thank you for that. I know we've just been talking about this particular issue, but can I just get some clarity? Which minister turned on the mandatory reporting obligations for the telecommunications sector?
Well, the relevant minister under the Act would be the Minister for Home Affairs, but Mr Hansford gave the earlier evidence. I'll ask him to return. She is the minister who administers the Act.
Which specifically minister turned it on?
Sorry, can you just repeat the question?
Which minister turned on the mandatory reporting obligations for the telecommunications sector?
Minister Rowland.
Roland.
Minister
Okay.
Roland, on the 5th of July, the Minister signed both a declaration and a determination. The determination in relation to carriage service providers and the declaration in relation to carrier licence conditions under the Telecommunications
Initially, we're
Act.
talking about the Telecommunications Act.
Telecommunications
Right,
Act,
no,
yes.
okay,
All right.
I thought
So,
you were referring to the
is it accurate to say that the telco sector was subject to different reporting obligations than other critical infrastructure sectors under the previous administration?
Well, by virtue of being in different acts, yes.
But the point,
but
I think the point is that Minister Roland was the first minister to turn on these powers in relation to the telecommunications sector.
Yes.
And the
Under the
telecommunications sector was unique in not having those powers turned on under the former government, I think is the point.
I think we should probably take that on notice, and at least refer it to our colleagues, because the Department of Infrastructure, Transport, Communications and other matters administers that legislation in those parts. Is that not right, Mr Hansford?
Correct.
We shouldn't give evidence pertaining to actions of a minister in another portfolio under legislation that another Department of State administers.
But the SOCI obligations weren't switched on
In relation to telecommunications
yes,
or otherwise?
Yes, telecommunications.
Mr Hansford?
Well, the mandatory cyber incident reporting obligation or the register obligation were not, no.
Okay. So
And have not been.
And have not been.
So did the former Minister of Home Affairs turn on any obligations?
Yes, the former Minister for Home Affairs, did a couple of things. First of all, made some definitional narrowing of critical infrastructure assets in March of 22. Also, on the 6th of April, made an application rule, so who the obligation would apply to for the Register of Critical Infrastructure Assets for 13 classes of critical infrastructure assets, and the mandatory cyber incident reporting obligation for 20 classes of critical infrastructure assets, which so made that rule on the 6th of April, which then registered on the 7th of April and came into effect on the 8th of April.
Okay, thank you. Can you also outline for me the steps that have been taken by Minister O'Neill to implement the new obligations in the SOCI?
Certainly. So Minister O'Neill has taken a number of steps to implement the Security of Critical Infrastructure Act as it was reformed twice. I think relevantly, the Minister has made on the 1st of August a decision to consult on the risk management program for the Osborne Naval Shipping Yard, a particular risk management program to support the broader efforts in relation to naval shipbuilding. Consultation occurred between the 5th of August and the 7th of September, and we're in the process now of finalising that risk management program rule, including advice for the Minister at the moment. So she formally consulted on the Osborne Naval Shipyard Risk Management Program. The current Minister also on the 30th of June declared 82 systems of national significance from 38 entities. So she made that decision, and some of the sectors to which those systems of national significance are included in the annual report. And then finally, the Minister for Home Affairs, current Minister, also on the 3rd of October approved the consultation on the risk management program generally to apply to 13 proposed classes of critical infrastructure asset, and we're currently consulting to support the Minister between the 5th of October and the 18th of November. I might add that not only are we formally consulting on the rule and associated explanatory statement, the Minister has also, after those roundtables that she undertook with 5 different groups of industry, a representation of a range of critical infrastructure providers, also asked us to publicly consult on 2 sets of guidance. I think one set is a generic set of questions that we frequently get asked from critical infrastructure, and then a particular set of guidance on protected information. She's also asked us to consult industry on a policy paper about how the AusCheck background checking program might apply to critical infrastructure. And finally, the Minister's also asked us to circulate an annual attestation form to which boards would have to attest should the risk management program be implemented. So 5 sets of principal documents that are being consulted on at the moment.
All right, thank you very much for that Very comprehensive answer. Can I also ask about the systems of national significance? How are critical infrastructure assets identified as such?
Yeah, so in order to be a system of national significance, you first of all have to be a critical infrastructure asset. And then following the passage of the legislation, we've gone through a process of working out what critical infrastructure are so fundamental to the functioning of society, our economy, or our defence or our security, and what interdependencies there are between those assets. So I mentioned before that the Secretary is required to maintain a register of critical infrastructure assets. When we look at how infrastructure assets relate to each other, the aggregation risks, interdependencies, we come up with critical infrastructure assets which have much greater connectivity with others. So we've developed a framework to really work out what are the most critical infrastructure in Australia. And the first tranche that Minister O'Neill signed off on really looked at those key inputs to the functioning of our society, and the annual report outlines that they were effectively in our communication sector, in our financial sector, some major transport-related entities, as well as the energy-related inputs into our society. And so they went through a process of consultation for at least 28 days, and the former minister actually commenced that consultation, but we undertook that throughout April and May. And then Minister O'Neill made the formal declaration of those systems of national significance, taking into account the public interest criteria under Section 52B of the Security of Critical Infrastructure Act.
And what agencies are typically involved in identifying systems of national significance?
So we talk to a lot of people across the Australian government. So when you look at the different sectors of critical infrastructure, it's everyone from industry department to infrastructure department to treasury to some of the major regulators. So we talk broadly across both the Australian government as well as state and territories. We meet fortnightly, for example, with states and territories to talk about critical infrastructure issues, and also do some consultation through the National Cybersecurity Committee. And so state and territory governments, and of course the individual entities themselves are subject to bilateral discussions to form the judgment, or form advice rather, for us to provide to the Minister prior to any declaration. So I think the answer is industry, regulators, both at the Commonwealth and state level, as well as policy and other program-related agencies, both at the state and territory and Commonwealth levels.
And will all the enhanced cyber security obligations be applied?
No, I think that there are 4 enhanced cybersecurity obligations that can be applied. The first one is, I think, foundational, which really asks, can you have an incident response plan to be able to respond to cyber incidences? Our contention is that that's a foundational obligation if you're a system of national significance. Then for the other 3 obligations, they are informed by risk and threat, as well as a national program of activity. So the first one relates to exercises. So we might choose to exercise, exercise certain scenarios, exercises to look for vulnerabilities, so conduct a vulnerability assessment. And then over time, we may well come to the view that providing systemic systems information or the deployment of sensors may well assist the national picture and apply that obligation to help ASD form that national picture in relationship with systems of national significance.
So what's the practical effect of applying these obligations?
Sorry?
That's all right. What's the practical effect of applying these obligations?
Yeah, so the practical effect is the Australian public and the government can have confidence that we've got the incident response plans in place for those most important systems, and that we've got a national program of exercises and looking for vulnerabilities should they emerge, and then finally to build the national picture through the understanding that's provided to ASD.
So, for me, how do we go about reviewing, or how do we review and enhance, I guess, these cyber security obligation settings and making sure that they still remain fit for purpose? Is there a process in place?
Certainly is. So we're in constant contact with systems of national significance, looking at the application of those enhanced cybersecurity obligations. It's a new community, very small community of 82 assets or 38 companies or entities responsible. So we're in collaboration and constant contact with those companies. More generally, the application of a risk management program will lift up the standard for, or set a baseline, lift up some, and some already exceed it for cybersecurity settings more generally in a preventative sense for those classes of critical infrastructure asset who have that obligation apply to them.
Has the department considered if the threshold for a system of national significance is appropriate following the recent cyber attacks that we've, I guess, not just discussed, but other incidents of recent time?
Yes.
Okay.
Senator Cooney, I do need to pass the call over.
Sure,
If you have
that's
one
right.
other
No, I'm happy to
crucial
stop there
question
to
you'd
assist
feel
you,
like.
Chair. More than happy to.
Thank you. Senator Roberts, you have the call.
Thank you, Chair, and thank you for appearing here today. My questions go to the Chinese contact point in Sydney. Is there a Chinese Communist Party supported contact point in Sydney?
I have no idea, and questions of security intelligence, to the extent that your question might have a bearing on security intelligence, is really a matter for the Director General.
So there's no one here who knows about that?
We're not an operational agency that collects that sort of information.
Okay, let's go on to the next topic. Thank you. This is to do with repatriation of Islamic brides and children. Has that been discussed today?
Has it been discussed
Yes.
in this committee? No.
Okay, thank you. What are the costs to Australia of bringing these women and children to Australia?
Well, it presumes that an activity of that nature is on foot. The Prime Minister said earlier today that, as far as he was concerned, this relates to matters that he'll take advice on from security agencies, and that's the practice that I will follow as well. There is nothing that I can usefully lay before this committee at the moment.
Mr Pizzullo, my understanding, maybe I'm wrong, my understanding is that the Australian today reported, or yesterday reported, that they're flying home.
I've seen similar reports. I just have no comment on that.
Okay. Can you tell us what security measures are to be taken to keep Australian community members safe?
Without engaging in the premise of your question that there either is or isn't a repatriation effort on foot, whether it's imminent or occurring or has occurred or will occur, let's settle that aside. The government's made it very clear that the security of the Australian community is its highest priority in this and related fields. So we have the Australian Security Intelligence Organisation, which, as you well know, is a statutory agency responsible for collecting intelligence and providing assessments on security. They work in very close partnership with the Australian Federal Police. The department has a role through the Counter-Terrorism Coordination Centre in ensuring that all the agencies have got a common picture, that legislative, regulatory and other responses are coordinated, and the Counter-Terrorism Coordinator is here present with us if he wishes to add to this, to my question, to my answer rather. And of course, through our processes, be it ASIO-led or AFP-led, or in more typically the case jointly led, state and territory police and other bodies are also seized of the same information. We share that information readily, and our highest priority is to keep the community safe.
Can I just double check, Mr Pizzullo, is outcome 1 the appropriate outcome? For the,
Yes. It would fall under program
other
1.
senators might have questions.
It would fall under program 1.2 and 1.4.
Oh, we'll get to Senator Scarr, but we.
I've got more questions, but they're all short. But if you want to jump in,
could I just briefly add one?
I'm just going to continue with the order
Could I just briefly
of
add one
questioners.
thing, just to back in what Mr Pizzullo said? I can absolutely assure the committee and the Australian public that this government will always put Australia's national security first, and that we will always seek and rely on the advice of national security professionals in making decisions regarding national security.
thank you. Did Mr Kerford want to say something?
No, thank you, Senator.
Okay. Are any of these women currently wives or partners of terrorists?
Well, I'm not sure which women you're referring to. If you're referring
The
to
women,
media
women
reports,
that are
if you're
under
referring,
discussion for coming home.
My apologies. Well, again, for me to engage with the premise of your question, I have to say, yes, this operation's underway and these people are coming home. I'm not going to engage with the premise of your question. If you're referring to a media report, you referred to the Australian. If I heard you correctly,
Correct.
I have no comment on that report.
Okay. Well, these women that are the subject of the conversation, are they refugees?
The subject of which conversation?
The conversation we're having now. Forget about the premise that they're coming home, just the conversation, these women that are under consideration for being brought home.
So that would presume...
Senator Roberts is just returning to the same question. I had a question in relation to the leak that's occurred, and I don't have any question in relation to operational matters. I don't want to trigger any premise. My only line of questioning is relation to the leak.
Senator Roberts, if it assists, the Secretary has said that there is some questions he's not able to answer. Do you have any questions outside of that scope in relation to this matter that you want to put?
So you can't give any operational...
No.
If you can't give any operational, my questions are all operational. Details.
I wouldn't be prepared to either confirm or deny the veracity of media reports. I'm just simply going to be silent on it. I'm not prepared, in the interests of preserving national security, to respond to answer your questions.
Well, as I see it, Chair, these are matters of security for our country, but I can understand where Mr Pizzullo is, so perhaps Senator Scarr can continue.
I was going to hand the call to Senator Patterson next on the matters he had raised earlier.
If Senator Scarr had a follow-up to this matter, I'm
it just
happy.
seems
Sure.
a follow-up, which we
Sure.
can tidy up.
You're
And-
eating into Senator Patterson's
Yeah.
time. But
So Secretary Pizzullo, Senator Roberts has referred to a report in the Australian. So the first one, 3 October 2022, the report entitled Secret ASIO Mission to Save ISIS Families in Syria. I guess after it's in the newspaper, maybe it's no longer secret. Report 4 October 2022 by the same reporter Ellen Winnett, security fears won't stop return of jihadi families. October 5, 2022, same reporter, quote, Islamic State brides will be detained after arrival from Syria. And then just earlier today, same reporter in the Australian, IS families on way home to Australia. I'm not going to put to you any operational questions. I don't want you to accept any premise. My question is, clearly it's absolutely vital for Australia's national security perspective and indeed the safety of people engaged in delicate, especially international security-related work, that the secrecy and confidentiality of their work is protected. Would you agree with that proposition?
Yes.
In those circumstances, has any investigation been commenced in relation to these newspaper reports and where the sources of those reports may have emanated from?
Senator, without the committee drawing an inference, either the positive or the negative as to the veracity of those reports, I am advised that reference has been made to the appropriate investigating authority. As to whether they've commenced an investigation, how they're going about it, that's really a matter for the Australian Federal Police. And I say that simply not to say that any of that reporting is accurate. It could be, frankly, garbage. It could be fully accurate. I'm just simply not going to comment. But when operational matters, be they intelligence collection matters, the deployment of our special forces, the deployment of other sensitive operational activities, there might be elements that are true, there might be elements that are completely misleading. The better course is for the relevant agency or department, or the most convenient one, to make a referral so that the competent investigative authority, the Australian Federal Police, can make an assessment as to whether indeed there has been a disclosure of national security information contrary to the provisions of the Criminal Code. And I think I'm right in saying that such a referral has been made.
That's correct, Secretary.
Thank you.
So, Mr Gifford, I note the Secretary asked you to just confirm that point. Who made the referral?
The referral was made by Department of Prime Minister and Cabinet.
By the Department of Prime Minister and Cabinet. And when was the referral made?
I'd have to take that on notice, Senator.
If you could take that on notice. And when did you become aware of the referral?
Well, again, that goes to the earlier answer I've given, Senator.
Sorry?
I will take that on notice along with the timing of the
You'll
referral.
take that on notice as well. So, Secretary, did you have any role to play, or did the Department of Home Affairs have any role to play, presumably? And I note your comments with respect to the newspaper articles, but I know you take these matters extraordinarily seriously. Did the Department of Home Affairs take any action once they saw these reports appear in the newspapers?
We collectively agreed, and the role that Mr Kefford occupies as CT coordinator allows him to engage in coordination. We collectively agreed that the referral will be best done, given the seriousness, again, no inference to be drawn on factual veracity, but given the seriousness of the potential harm to national security, that the referring agency would be the one that Mr Kefford spoke about. So yes, we were involved in discussions about the referral. There's no point sending in 12 or 13 referrals. Better be done as a job lot.
And was the Minister of Home Affairs involved in relation to those discussions and the urgency to refer the matter?
I'm not sure whether the Minister or staff were involved. It's typically a matter undertaken by departments on behalf of their ministers, but certainly the guidance I've received, the very clear direction from government, from the Prime Minister himself, from the Minister of Home Affairs, is that in such matters, whether or not the report itself is true, in such matters operational secrecy is to be respected and preserved at all times. And if there's a purported breach of that security, then that should be dealt with as a potential crime and therefore to be investigated by the competent authority, which is the Federal Police.
Okay, thank you. Thank you, Chair. I just wanted to deal with that.
I do have a follow-up questions in the interest of dealing with them all at the same time. Not operationally, but there's still, am I right, there still remains a number of women and children who are Australian citizens in Syrian camps?
Yes. To be fully accurate, camps within the geographical territory of Syria.
Okay. And has there been a marked change in the operating environment that would mean Australia should consider reparations?
Chair, I need to be very careful about how I answer this. I'll answer it this way. With ASIO providing as the premier agency in this area, providing security intelligence advice, but other agencies providing input, including other intelligence collection partners and other, indeed, international partners, the conditions on the ground, including the permissiveness or otherwise of our ability to physically access those camps in the autonomous area of northeast Syria, is kept constantly under review.
Okay, and I'm not seeking to draw any conclusions to Senator Scarr's questions in terms of the referral, but can I just understand, has the department briefed the opposition on these ongoing matters?
Yes.
Okay, thank you.
And for the sake of completeness, also the Parliamentary Joint Committee.
Thank you very much. Senator Patterson.
Thank you, Chair. I want to move on to a Medibank timeline, and as we discussed with the Optus one, perhaps the best thing for the department to do is to put their heads together with ASD and come on notice with a comprehensive timeline, and to acquit Senator Watt's concerns, inclusive of both incoming notifications to the government and actions that the government took in response to it, to ensure we've got a complete picture.
I would prefer to do that in a collaborative way with partners, simply because if we, and the conclusion I drew from our earlier exchange is that it's potentially misleading to the committee to say, well, this regulator, and Mr Hansford's a regulator, had this interaction with Optus or the Minister or her staff. Well, that's part of a jigsaw puzzle, and then this area, ASD or one of its subordinate elements did. You would get a fragmented and misleading picture. So my preference, and I take from your comment that you'd prefer us to deal with this, is to take it on notice and to work in a collaborative fashion with our partners.
I would like to do that, although that's not mutually exclusive of me also asking some basic timeline questions here. I'm looking forward to that comprehensive answer in due course, but I'd just like to establish some kind of basic timeline factors here. So when did the government first learn of the Medibank attack?
Well, I'll ask Mr Abalong to join us, but again, and this goes to the different responsibilities of agencies, the first responder in this instance typically, not always, but typically is the Australian Signals Directorate. So the question of when the government became aware is going to have to be checked with other
Thank you.
agencies. So I'm
I
not.
do understand
I'm
that,
not
Mr.
prepared
Pizzolo, and
really to answer on this.
if it turns out that ASD found out earlier or later, I won't hold that against you. I'm just the state of the department's knowledge I'm interested in.
So what, Mr. Ablong, why don't we speak rather than ASD's knowledge or the minister's knowledge or?
Well, hang on. No, I think the minister's knowledge is relevant. The minister sitting next to you is here to represent the minister as well. So let's not carve out the minister.
To the extent that it's within the department's knowledge, and noting that we've taken the general question of chronology on notice, so we can consult with ASD, AFP, and other colleagues. In the broad, when did the department become aware of this issue?
So, Secretary, very similar to what we did with the Optus, the first engagement in terms of the government becoming aware was through Mr Hansford's organisation.
Well, again, let's just be clear. I'm not sure that's the first time the government becomes aware. Let's just limit ourselves to my department, please. Yes. Thank you. Mr Hansford?
I think that's right. We were aware of contacts with other agencies before us. On the 13th of October at 14:18, Medibank wrote to the department outlining that you may be aware that there has been a cyber incident and seeking a meeting. On the 13th of October at same day, 15:47, they've made a mandatory cyber incident report because they're a critical infrastructure asset under Section 12H, subsection E of the Security of Critical Infrastructure Act.
Okay, Mr Ablong, anything to add to that?
Mr Hansford's testimony is what we would have said as well.
Okay. When did the department become aware, or the minister, that a compromised credential was the source of the compromise or the loss of data?
And we'll limit our responses to our state of knowledge, to the state of knowledge of my department, please. Mr Hansford, perhaps first.
I think Mr Ablong.
Mr Ablong
took
or Mr
over
Dowling.
after that.
So the forensics of the incident were first briefed to us on the 19th of October.
So that was when the company publicly said that they thought that the attack was broader than they'd first thought, or that there'd been more data lost. But I understand that they held an investor briefing on the 17th, which was the Monday, at about 9 a.m. in the morning, and that in that investor briefing they disclosed that it was a compromised credential was the source of the loss of data, and that is publicly reported shortly thereafter. So was the department unaware for 2 days that a compromised credential was involved?
No, Senator, that was the first meeting between Home Affairs and Optus at which that information...
Hang on, it's Medibank?
Sorry, Medibank.
It's not about meetings, it's about awareness.
Yes. So the information was available to other agencies of the Commonwealth, but in terms of my set of responsibilities, the first time that was briefed to me by Optus was on the by Medibank was on the 19th.
Yeah, I wasn't asking when it was first briefed. I was asking when you first learned. When did you first know?
So there would have been presumably staff in your in the centre who would have been aware of the investor briefing that the Senator mentioned. Thank you.
So at the same time as the investor briefing. But
right. So you weren't notified prior to the investor briefing?
That's correct, Senator.
Noting that there are other government agencies who may well have been.
Yes, and I will both explore it with ASD when they appear next week, and I'll look forward to the answer on notice. Mr Dowling, you look like you were going to add something there.
No, I was actually just going to comment, as the Minister said, that that sort of operational related information may have been aware to other agencies, but we're addressing our agency.
Yeah. Relying on your expertise about cybersecurity, once it was clear that there was a compromised credential involved, it should have been quite clear that this could be quite a serious incident, shouldn't it?
Well, it's really a matter for assessment by technically proficient and competent agencies who advise us. Our job is really then to coordinate consequence response. But the premise, if you've got a credential compromise, that tends to be indicative of a serious matter. But the advisors to government and the advisors to industry in this respect are the Australian Signals Directorate and a particular centre within ASD. Do you have anything to add, Mr Ablong?
I would just add that while a credential may have been compromised, the access that credential holder has in the system is a fundamental element of whether or not there is an ability of that person to roam broadly across the system or to
Indeed.
be confined to a specific area of the system.
But my understanding from the company, from speaking to the CEO directly personally, is that they knew whose credential was compromised. And if you know whose credential is compromised, you should be able to reverse engineer from that what they had access to, shouldn't you?
Technically, that's true, Senator, but it really does depend upon the way in which the individual company manages its credential system. It would be the case that should be the way it's done, but whether or not the company keeps their credentials in that sort of way, I haven't done the forensics on the way in which Medibank manages its use system. So
Indeed, we wouldn't.
No, exactly right. So I wouldn't be able to comment.
No, I wouldn't ask you to do that. But on the 13th of October, they said, we've had an incident, we're not sure what it is, we don't think we've lost any data. On the 17th, they disclosed, it did involve a compromised credential. Isn't that the point at which you go, uh-oh, this could be serious? There's at least 4 million current customers and potentially many millions of former customers. There's a compromised credential involved. Safe assumption would be to make, this is very serious, isn't it?
Senator, the conversations that we were having with Medibank really was about, you need to tell us more details along the lines of what you said. What access did this person have? What information do you think was extracted in order for us to make a judgment about the harm involved?
When did the Minister first speak to Medibank?
We'll take that on notice as part of the more general...
You're not able to answer that?
No.
When was the first meeting at which you were present, or an official from the department was present and the Minister was speaking to Medibank?
I'd have to check the record, so we'll do that as we sweep through the dates in the context of the question that we've taken on notice.
But what I can tell you, Senator Patterson, and I'm sure the officials can elaborate, is that not only has Medibank worked with ASD, the AFP, Home Affairs, specialist cyber firms throughout this process, but the Minister herself has been directly engaged heavily with the range of Commonwealth agencies that have responsibility here.
Well, I look forward to you substantiating that claim with some information, because based on what's on the public record, all that we know is the incident was publicly announced on the 13th and the Minister didn't make her own...
No, but hang on. That's because
Minister,
this is a live investigation, and
Chair,
it's not
I'd
wise.
seek your assistance here.
It's not wise for ministers of the Crown to go out there holding press conferences every hour in the way that you would seem to wish, updating people about a live investigation. The priority is to protect people in this situation, is to protect people's data. Some of the discussions that occur are necessarily confidential, so I would argue that it's highly inappropriate for a minister to be giving, an hour-by-hour update of her movements and statements and meetings in the way that you seem determined to have her do.
Senator Patterson. Point of order, Chair. I was about to say, in regards to Senator Patterson's point of order, you do have the call, Senator Patterson. If you make an assertion in a question, I'd suggest to you the Minister's open to reject that assertion. But if you want to continue questioning, you do have the call.
Point of order, Chair. I think it is important that Senator Patterson have the ability to complete his question before he is interrupted by the Minister at the table, and I think that will actually assist us in progressing through matters more quickly.
I think it would assist if that courtesy extended both ways across the table. So, Senator Patterson.
Agreed, Chair, and I will seek to uphold that as often as possible, and I'd ask that the Minister do the same. So, to return to my question, all we know from the public record is that the incident was publicly reported and to the department on the 13th, and it was not until the 19th that the Minister made a public statement about it. It may be that you're able to substantiate in your answer to the question on notice that there was a whole hive of activity involving the Minister personally well before then and she was directly engaged. But from what we have on the public record, all we know is what she's publicly said and what you've said here.
Well, and that's because it is inappropriate for a Minister to be out there making public statements about things that she's learning along the way, advice that she's receiving, actions that she's taking, when the entire activity of government, including the Minister, is focused on shutting down data breaches and protecting people. That's the priority.
Well, that is not clear from the evidence we have because you haven't yet substantiated that. I look forward to this answer on notice that will supposedly substantiate that this was the Minister's sole focus.
Well, can I tell you from the outset, it helps to have a Minister for Cyber Security, which is something that your government didn't do, and that enables a minister to get out there and do the very things that she's been doing.
I have heard this claim from the government. It's in fact not true that Dan Tehan was the first ever Minister for Cyber Security. He's appointed by Malcolm Turnbull as Prime Minister, but in any case...
Maybe you can tell me who it was before the election and a cabinet-level minister.
The Minister for Home Affairs was responsible for cyber security.
But not...
Anyway, I don't think that's the main point
I'm unsure
here.
who's asking the questions now. If we could just keep moving, we are very
Thanks,
short
Chair.
of time.
I'm grateful for that. So it wasn't until the 19th of October that the Minister made a public statement. The Minister has said in question time that she has sent in the AFP and the ASD to work with Medibank. On what date did that occur?
Well, again, Mr Pezzullo might think that it's wise to answer that question. I don't know, but we do need to be careful about providing public details about investigations that are underway. But within those parameters, Mr Pezzullo might have something to say.
Well, in fact, I'd be highly reluctant to speak about operationally sensitive matters. We will take it on notice so we can give it careful consideration with our colleagues in the Australian Federal Police. The Australian Signals Directorate will consult with the Minister. I can affirm, to the point about substantiation, and I know this for a fact because the Minister and I have had to reschedule and reprioritise other things that she's otherwise also been engaged on. She has been very heavily engaged, and tracking her engagement merely by mapping her media utterances would be entirely misleading.
Thank you, Secretary. I'm surprised that both of you are reluctant to comment on this issue because in response to a question that the Minister took on notice from me in question time this week, the Minister said, and I quote, on the 19th of October, Medibank notified the Minister for Cyber Security. The very next day, the Minister for Cyber Security initiated a wider coordinated response across government and requested that the AFP and ASD staff be co-located with Medibank's cyber team. So we know that the Minister was notified on the 19th. We know that she asked for them to be co-located on the Thursday, which is the 20th. All I'm asking for is on what day that commenced. And was it on the Thursday? Was it on the Friday? Was it a subsequent day?
And if it's appropriate to go beyond what's already on the public record, we'll deal with that in the material in the question that we've taken on notice.
This is why I asked for officers to become prepared with a detailed timeline of events, so you'll be able to answer questions like this. I have accepted your evidence that you don't have something that you're able to table, but I do not accept that you're unable to answer that question here and now because I asked you to come prepared to do so.
You did, and you asked that my officers come prepared to speak about, quote, the government's response. The government consists of a number of departments, agencies, statutory bodies, regulators. Now that I understand the line of your questioning in detail, we will collaborate with our colleagues. I can't answer on behalf of when the Australian Federal Police were invited by the Minister for Cyber Security to attend to this matter. I'll consult with them.
Well, the Minister can. The Minister is here to represent the Minister.
Well, it goes back to the point that I was making with Senator Scarr before. Just as I'm here representing the Minister for Home Affairs, I can't give you any information about activity that's occurred in relation to the ASD or the range of other agencies that are involved in this process.
You are here representing her in her capacity as the Minister for Cyber Security.
Yep.
And these are questions about what actions she took in her capacity as the Minister for Cyber Security. Are you seriously saying that you cannot answer questions about that?
I don't have a detailed timeline about every phone call she made.
I'm not asking for every phone call. This is actually a very important matter.
I agree.
And it's not just a phone call.
No, I agree it's very important, and that's exactly why the Minister has been working day and night with her agencies to resolve these issues. I'm sorry that not all of them can be put on the public record, but that's because there are active investigations underway.
I don't understand why the time at which you've already referred to in an answer to a question on notice, that the AFP and ASD were deployed would in any way impact in an investigation.
Senator Patterson, I can't add to what I've been saying.
Are you making a public interest immunity claim?
What I'm saying is that the Minister has been actively engaged in this process, and the mere fact that she hasn't been making public statements or putting things on the public record should not be inferred as meaning a lack of engagement. Quite the contrary.
Okay.
Can I ask an
in this
indication
answer
from you, Senator Patterson? how many more blocks of time in outcome 1 do you think you might need?
Chair, mindful of your desire to move to other portfolios, I can truncate my questions. I had about 7 or 8 other matters. I'll try and reduce it to about 3 or 4 and try and be as quick as possible.
I think it would assist the committee if we can deal with outcome 1.
I agree. I'm determined to do that if it's possible.
And Senator Shoebridge has questions, so I can let you finish this block very quickly. These are your last questions. I'll hand over to Senator Shoebridge and then come back to you, but we will need to move on.
Thank you. Minister, in your letter to me answering the questions you took on notice in question time this week, you said that the AFP and ASD staff are co-located with Medibank's cyber team. Where are they co-located?
Well, there really matters for those agencies. I mean, we're not here. The Minister and I cannot possibly represent the Australian Signals Directorate, which is in the Defence portfolio, or the Australian Federal Police, which is in the Attorney General's portfolio. I would respectfully request that those agencies be asked that question.
This was instruction given by the Minister for Cybersecurity to agencies for whom she is responsible, and the Minister who is representing her should be able to answer questions about decisions that the Minister and instructions that the Minister gave.
Again, I'm not willing to say where agencies that are involved in an active investigation are co-located.
Okay.
There may be issues around disclosing that location.
Okay. Do you know that there are issues around disclosure?
I don't know that, but what I do know is that I need to be very careful what information we put on the public record, just as we were in relation to the questions that Senator Roberts asked about these reports about things in Syria.
Let me help you, Minister. Are they physically co-located with the ASD, with Medibank, as your answer implies?
Well, I can't. I've already answered the question, and you've got it in your hands. And there's nothing more I can provide to you other than the information I've already provided.
Well, can I encourage you as Minister to seek clarification on the information you've been provided, because I wouldn't want you to be in a position where you're misleading the Senate. You have said in your answer that AFP and ASD staff are co-located
I have no reason
with
to
Medibank's
believe.
cyber team.
Is that
I have no reason to believe.
Senator Patterson, or are you just dishing out advice
Yes,
it is.
as part of your time?
I have no reason. I have every confidence that the information I've provided to the Senate in the letter that you're reading from is accurate.
I'd encourage you to check that.
I'll take that on board.
Thanks. Well, I was going to hand the call over to Senator Shoebridge, but he is not at the table.
I have plenty more questions, Chair.
I think, Senator Polley, did you have any more questions?
I had some in relation to recent cyber incidents that have demonstrated that cyber security is something we can't take for granted. We know that the government departments are not immune from cyber attacks. So I was wondering in terms of the priorities we have, like in 2017 and again in 2021, ANO reviewed the cyber security strategies and settings of non-corporate Commonwealth identities. Can you give us a brief as to where that's at the moment?
Sorry, Senator, where the remediation in relation to those departments is at? Or?
Yes.
Those Auditor General reports, from memory, cover a number of agencies because they were cross-agency reviews. I'd have to remind myself as to which department and agency was being audited. I think it might have been the Department of Home Affairs in one case. But
Australian Tax, the Attorney General.
I'd really respectfully suggest, not too dissimilarly from what I just said to Senator Patterson, that in relation to what agencies are doing to remediate vulnerabilities and other issues that have been identified by the Auditor General, those questions are properly put to those agencies. If you're asking me to go perhaps at an aggregator level to a more general level, I did say to Senator Shoebridge earlier, there is a government program known as Hardening Government IT, shorthandedly called the Cyber Hubs pilot. And just to very briefly rehearse my earlier evidence, the former government, and now continued in this budget by the Albanese government, has asked departments to pilot frankly, what will be transformative and, I would say, radical new way of doing cybersecurity, whereby you move from a situation where each individual accountable entity or an accountable authority, as the term of art under the Act describes us, the Public Governance and Performance Act 2013 of the Commonwealth Parliament, rather than moving to a circumstance where each accountable authority has to get their own IT vendor, get their own information security vendor within that, have their architecture in terms of where they put their data, how their perimeter is managed, how they patch for vulnerabilities. When the current cyber arrangements were created some 20 odd years ago, when procurement was devolved out to PGPA agencies, the internet wasn't a thing quite in the way that it is today. Attackers had not perfected the art of coming in through the weakest, or through the, I shouldn't say weakest, in through the most easiest vulnerability to penetrate and then hop across networks. Where we've got to now, and governments all around the world are contending with this, you've got to reduce what's called your attack plane. You've got to reduce all the gaps and seams that are in those, in our case, 195 different agencies, and resolve them down to as few surfaces as possible. I should commend, if Minister White allows me to, I should commend the drive that we received under the former government from Minister Robert, who was particularly seized of this, championed and led the Cyber Hubs program, and I'm delighted that just to go back to what I said to Senator Shoebridge, that this current government has said continue with that pilot and come back to us with an evaluation as to how we reduce these multiple entries into government systems down to as few as possible. They'll be called hubs. Whether we end up with 3, 4 or 5 is a number to be determined. It'll be in that range. And then the Australian Signals Directorate will act as a guardian above all of the hubs, because they've got the most potent capabilities, and I need to be very careful about what I say here, but they've got the most potent capabilities to both see the attacker and in certain circumstances to lawfully deal with the attacker in a way that no cybersecurity company can.
Okay. Look, in the fullness of time, I think the Chair's going to take the call from me.
I'm very eager to give Senator Shoebridge the call, because he thank you, Senator Shoebridge.
Yes, we're going to move off the hub guards. And Ms. Pezzullo, I put some questions on notice about a policy that was adopted by the Government of India requiring the provision of passenger name record information for all inbound passengers, including inbound passengers from Australia. And you indicated in answer, well, it was indicated in answers that the department has sent a TPN to the High Commissioner of India seeking information regarding the data risk and security safeguards in relation to the data for foreign nationals, in our case, Australian nationals. Have you had any response yet?
I'm not quite sure why my colleagues are vacating the field at this point, but in terms of the
It's moments like that when you look behind and...
I'm still...
Yeah. I thought we were in politics.
And they're still walking away. In relation to passenger name records, the policy, including reciprocal and other arrangements, really is best dealt with under Outcome 3, simply because it's a border force that manages our engagement with the global PNR system, passenger name record system. In terms of the adequacy, as I understand the question, and I know it's been the subject of some written, I think it's been the subject of a written response to you, about the adequacy of the data security on the other side. In other words, on the Indian side, is that the question that's been asked?
It is. Well, that's where I'm going. So
understood.
Yes,
I'll see if Mr. Dowling can assist me, see if he's familiar with that TPN that's been sent to the Government of India, or Mr. Ablong, and then we'll...
And while they're coming up, I might put the next question.
Thank you.
Thank you. The same data harvesting arrangements have been in place in Europe for a significant amount of time, but they have been substantially reduced in recent years because of decisions of the European Court of Justice, which found them to be excessive and in breach of a whole series of privacy provisions. So I see that you're aware of those.
So I think the question is, we wouldn't obviously want to comment on the policies and procedures of the Government of India per se, but are we familiar with are you familiar, Mr. Ablong, with the sending of a diplomatic representation in relation to data security of PNR?
I am Secretary.
Thank you.
And to answer your...
Why did you walk away?
I need my other folder.
I see, thank you.
And sorry, just Mr. Blong, the information being provided about passengers are email addresses, phone numbers, travel information, date of travel, travel itinerary, payment and billing information, a very large amount of information.
Indeed, which is the standard PNR information that is shared globally by almost all countries in order to allow relatively smoother transit through various countries. We have not yet received a response from the Indian government in regard to the third person note.
Well, the EU has struck down large elements of that data retention arrangement in Europe because it was found to be in breach. Was found to be in breach of a series, the EU Charter on human rights, but specifically as the data privacy.
Senator, the European courts have struck down elements that are related to the length of time that information is kept for.
And the purposes.
And the purposes for which it can be used, correct. But in order to participate in the international global travel system, it is still the case that European countries provide PNR data and are provided PNR data. Australia has an agreement with the EU about PNR data sharing, which we engage in both audits of each other's data retention activities as well as an ongoing conversation about the use for which that data can be put.
Has the Australian government made any objection to the broad use for which India is proposing to use Australians' PNR data, which includes, and I'll quote, sharing travellers' personal information on a case-to-case basis with other law enforcement agencies or government departments of India or any other country?
Senator, I'll need to take that question on notice.
Do you accept that there are cybersecurity risks for Australia if significant amounts of Australian travellers' personal information is shared with any other country, and in this case India, and then open to be shared by them on that basis?
Senator, the information that is provided globally on PNR data sees any traveller required, or the country from which a traveller is travelling to provide data to the country to whom they are arriving, along the lines of what you've set out. That was a measure put in place after the 9/11 events to make it easier for air travel to resume at the levels pre-9/11. The cyber security standards of the countries that hold that data is established through MOUs or treaty-level documents, depending upon the countries involved, with all of the global participants. We have, as I mentioned earlier, an agreement with the European Union that requires both a cybersecurity standard for our holding of that information, but also it deals with the way in which we use that information.
Is there an MOU with India for the holding of Australians' personal data?
So, Senator, that is the subject of the third person note, is to go through the process of establishing the parameters under which they intend to hold and keep that information.
So currently, no.
At this point in time, no, but that's the subject of the negotiations currently underway.
Which commenced with that note after we put the questions on notice?
Those negotiations were underway as part of our sharing of PNR data, but the third person note has looked for additional specificity.
Well, you weren't aware of it until we put the question on notice, according to your answer?
Of the
passenger name record information regulations?
That the Indians...
Correct.
Sorry, I'll go back a bit. So the new regulations that the Indian government has put on PNR data, as opposed to our previous sharing of PNR data with India, was something that you raised in committee and we became aware of at that point.
And then began
a further process.
I think it's good that the MOU negotiations have commenced, don't get me wrong. Do I understand it correctly from the answers that you're not aware which, if any, Australian airlines are providing Australian personal data to the Indian Customs Department in accordance with the regs? You're not aware?
So under our established activities, any Australian airline flying to India would have to provide that data.
All right. And then, are you aware of whether any of those airlines are informing passengers, Australian passengers, that they're providing such a large amount of their personal data to the Indian government?
I can't answer that question on behalf of the airlines. I don't know about their communications with their passengers.
Might be some questions on notice in there, Senator Shoebridge.
Yes, I did have one other matter.
You have very limited time to continue these questions.
I'll endeavour to be extremely quick.
Very quick.
Could I ask you, Mr. Pizzullo, about prescribing right-wing extremist organisations? First of all, I note that there have been 2 right-wing extremist organisations listed in the last 9 months or so. But could I ask you about Proud Boys in particular? Proud Boys has been listed by both Canada and New Zealand as an extremist organisation. We know they're present in Australia. Why have they not been listed?
It's a question of whether thresholds have been met under our laws rather than laws of other countries. Mr Kefford's the CT coordinator and coordinates the process for developing listing recommendations. Mr Kefford, Proud Boys.
Thank you, Secretary Andrew Kefford, Commonwealth Counter-Terrorism Coordinator. Senator, it's not been our practice to discuss in public which entities are or are not being considered at different points for listing. But what I would say is the test involves both the test set out in the Criminal Code involves both the activities of the agencies in advocating or entities in advocating or otherwise promoting terrorism, but then there are also other issues that go to their nexus to Australia, their presence in Australia, the activities and the decisions of like-minded countries forms part of that consideration. And obviously we're aware what our colleagues, including the New Zealanders, have done in this space. But as I say, it's not been our practice consistently to speak until such time as decisions have been made about which entities may or may not be under consideration.
Do you share the concerns of the Director General of ASIO that right-wing ideologically motivated extremism is on the rise? And do you share those concerns?
Well, of course, Senator, we work very closely with our colleagues in ASIO, and the advice from ASIO and indeed other security agencies forms part of the consideration. But yes, of course, there's a concerted effort across the Commonwealth to engage with terrorist entities of whichever particular persuasion, and certainly the online environment is one that is increasingly concerning.
Do you accept there's been a surge of far-right extremist groups? And recent reports, for example, suggest there's at least 9 far-right extremist groups operating just in Victoria. Do you accept that there's been this rise?
Well, Senator, the Director General in his annual report this week has commented on the nature of the broad terrorist threat. And as I said before, we in conjunction with the security agencies and ASIO, continually monitor and consider and regularly discuss the activities of organisations that may be considered for listing. And in the event that there's a view that the agencies reach the legal thresholds, then we prepare material for consideration by the government.
Senator Shoebridge, this is your last question, and then I have to hand the call over.
Is there a, noting that Australia hasn't listed Proud Boys, for example, given their notorious behaviour, is there a problem with the threshold for listing right-wing extremist groups?
I wouldn't characterise it that way, Senator. What I would say is that there's both the legal tests that have to be met under the Act, but also a range of considerations, including particularly the activities of a group, the nature of the group itself and its activities within Australia, and those activities are kept under constant review, and at the point we think we have sufficient material to take a recommendation forward to government, we do that, but that involves coordination and consolidated advice from across the whole of the Commonwealth.
Senator Scarr, if you've suggested you've got a question, if it's got a one-word answer, you could probably ask it. Otherwise, I do need to give the call to Senator Patterson.
I'm happy to share my time.
I would keep it very brief.
I'm not sure if any question's got a one-word answer with these witnesses, and that's no reflection on them. Perhaps it's my questions. I just want to ask a question in relation to the process now with the implementation of the MOG changes. And Mr Kefford, obviously you have a key role in this space now in terms of the process for the listing of terrorist organisations. Who is responsible for what now following the MOG changes? Secretary
Senator,
Pezzullo?
the Commonwealth Counter-Terrorism Coordinator's role has not changed. It's his responsibility, as in fact was threaded through the answer he's just given to Senator Shoebridge, to pull together all of the relevant agencies that have got a role to play, the Australian Federal Police, ASIO as the Security Intelligence Agency, other relevant departments, including the Attorney-General's Department that's responsible for the Criminal Code. Mr Kefford, who can describe how this process works in detail, convenes effectively a standing interdepartmental process. Everyone is given a chance to express a view as to whether they believe the facts are clearly agreed, whether the thresholds have been met. We just had a discussion with Senator Shoebridge about that, and then a consolidated report from all agencies and departments then furnished in legal terms. I think the phrase used in the Criminal Code is that the decisions made by the Minister responsible for the AFP. Is that
The term in the Act is the AFP Minister.
The
and
AFP
under Division 102 is the decision maker.
So it's now the Attorney.
So the AFP Minister is now the Attorney General. It was the Minister for Home Affairs prior to these arrangements. That report is packaged up, sent over to his department, and what they do with it and how they process it and present it to him in an administrative sense is a matter that you may wish to take up with Ms Jones as the Secretary of that department, but I can assure you that...
So, Secretary, just to unpack that, your reference to packing it up and sent over to the Attorney's Department, but presumably, Mr Kefford, earlier on in the process, in terms of your liaison role, you're liaising with the Attorney's Department prior to...
They are part of the process, are they not?
They are part of the coordination arrangements that the Secretary's described, and indeed the legal advice that goes before the AFP Minister comes from the Government Solicitor.
So what role is there now for the Home Affairs Minister in terms of the process? Is there any role for the Home Affairs Minister?
So the process that we followed in relation to the recent listing of IS Somalia, which is the one that's been done under this government, the interdepartmental process that the Secretary's described took place, and then the package of material I provided to the Minister for Home Affairs, recognising her responsibilities for national security, for social cohesion, for counter-terrorism, and the package was then sent from our Minister to the Attorney, who, as we've described, is the AFP Minister, which is the term used in the Act.
So what role does the Home Affairs Minister have? Does the Minister make a recommendation to the Attorney, or do they have to be consulted, or are you just doing that because you think the liaison is appropriate?
Well,
and I'm not saying it's not appropriate.
I'll answer this. Under the Administrative Arrangements Order, it's very clear. We spoke earlier at some length about the prerogative that the Prime Minister has to shape the structure of his government as he sees fit. He's assigned the question of, the AAO speaks of counter-terrorism policy and coordination, as I recall it. It would be passing strange, I would have thought, to follow through on the intent of the AAO, to not give the Minister for Home Affairs, who's got a broader coordinating mandate across all counter-terrorism issues and not confined to the legal requirements that the Criminal Code sets out in terms of how you get to a listing determination. I would assume and anticipate the Attorney-General would value the fact that his colleague, who's actually got the lead responsibility for counter-terrorism policy and coordination, would have a chance to express a view. Now, in terms of whether she'd express a view or whether she'd put a view over the top of the interagency report is a matter for the Minister, and I'm sure as the case requires, she would take whatever decision she makes about that. And then in legal terms, as is often the case, I can instance to you foreign investment review decisions. The Treasurer is the one who makes the decision. I've sat in NSC many times and these matters have been canvassed, and no one is under any illusion that it's the Treasurer's decision. But Treasurers typically, wise, prudent, senior members of government take the view that it'd be good to get a view from all of my colleagues so that if there's any unintended consequences, if there's any matters of which I'm not aware, I can have regard to. And then, of course, as many acts of Parliament contemplate, it's a single individual decision maker who then makes the decision armed with the context and the benefit of all of that collective wisdom, both from agencies and from his fellow minister.
Right. So if I can maybe ask the Minister,
I'm sorry that wasn't one word, but but it's a complex area.
I appreciate it. Minister, are you aware what action the minister took in relation to that registration of the Islamic State organisation in Somalia as a registered terrorist organisation? Did the minister make a recommendation to the attorney? What action
I'm
did
not
the
aware of
minister
that.
take?
I don't know whether Mr Pizzulo might have any information about that.
I think it's fair to say. Would it be fair to say, Mr Kefford, that it was endorsed? I don't want to shape your evidence, but I think the minister's given every opportunity as the CT minister to express a view.
You can take it on notice. I'm just interested in how this process works now that you've got Mr Kefford. You're within the Department of Home Affairs. The attorney leads another department, and the attorney is now the minister with responsibility for the AFP. Therefore, the attorney is the one who makes the decision. So I'm just interested to understand, given the machinery of government changes, we've now bifurcated, or whatever word you want to use, the department. What role does the Minister for Home Affairs have? I know the attorney's role.
Yeah, well,
in practice.
Well, in practice, the way the Secretary has described it is right, Senator, in that the advice that we provided was endorsed and provided to the attorney. But I think the other thing I would say is that a function of my role as CT coordinator does what it says on the box. So in relation to, heaven forbid, an actual terrorist incident, then I am the lead senior official in the Commonwealth's response to that, which involves a direct reporting line to the Prime Minister that's set out in the National Counter-Terrorism Plan. Before, even under the arrangements before the election, under the administrative arrangements, the declaration of a declared area for the purposes of the CT legislation, the process that we followed was exactly the one I've described in terms of the coordination, the CT Coordination Centre pulling together that advice, but in that case, that advice goes to the Foreign Minister. So it is an area of counter-terrorism, reaches across responsibilities of a number of agencies, and this is a established practice. We've adopted it following the admin arrangements to reflect what happened, or to meet the requirements of the Criminal Code, which says those decisions about listings are made by the attorney.
So there has been a change following the machinery of government changes, insofar as the decision maker is now the head of another department, namely the attorney, as opposed to the decision maker under the previous construction of the department being within the department, being the minister for the Department of Home Affairs.
For listings, that's correct. So before this admin change, the Minister for Home Affairs was also the AFP Minister. But similarly, before this admin order change, the process to provide advice consolidated to the Foreign Minister about the creation of a declared area was still with the Foreign Minister. And remains there.
That's a good point.
Okay. All right. Thank you. Thank you, Chair.
What if the Home Affairs Minister doesn't endorse it? Does it not go to the attorney?
Chair, just to flag, I have a question that I ask.
There's no question, Senator, and I don't want to speak on hypotheticals, that in the end it's the deciding minister who'll decide how to resolve issues where other ministers might have a different view. Our job is to ensure that there's ventilation through the process. In my experience, senior ministers value the input of their colleagues. If they have a difference of view, I'm sure that they'd work out a mechanism by which to discuss and resolve that.
Senator Patterson, I sought to give you the call earlier. You have it now.
Thank you, Chair. I appreciate that. Just one final matter for me, although I do flag I'll have further questions under outcome one, and I sadly believe we're going to need a spillover to be able to address those questions. Why was the Minister for Cybersecurity stripped of responsibility for cybercrime on the 13th of October, which of course coincidentally was the date in which the Medibank attack became public knowledge?
I can't accept the characterisation of stripped. If the AAO is clarified to make doubly clear to everyone that the Attorney-General is the Minister for Law Enforcement, then the change is an epithet in the sense that he's also responsible for dealing with all crimes against the criminal code, be they cyber or in relation to offences against persons or otherwise. There's no stripping.
I think most Australians would think that the Cybersecurity Minister should be responsible for cybercrime. They would think it was strange that the Cybersecurity Minister wasn't responsible for cybercrime.
Crimes against the Commonwealth, pursuant to the Crimes Act and the Criminal Code, consequentially upon the machinery of government change that we've been discussing on and off through the afternoon, are matters for the Attorney-General. That's why the AFP reports to the Attorney-General. And I would say the same thing in relation to crimes that are associated with maritime people smuggling. The AFP reports to the Attorney-General, but I see them all the time in the meetings that I chair or am party to in relation to Operation Sovereign Borders.
Sure.
So that integration of effort hasn't been changed.
The time. Was it an oversight from the machinery of government changes on the 1st of June? Did someone forget and then go, oh crap, actually this should have gone to AGs as well?
Well, without responding to the rather pungent phrase in your question, as Minister Watt reminded us, matters of the AAO are really are matters for the Prime Minister personally. They're his discretion as to how he shapes his government. He does take advice. There's a unit within the Prime Minister's...
And did you provide any advice?
No, not on that. As similarly with my previous evidence, no. And there's a unit within the Department of Prime Minister and Cabinet that assists the Prime Minister with machinery matters. So I would...
so your department did not bring to the attention of that relevant part of PM&C the fact that this might have been an oversight and it probably should have happened in June? No one from Home Affairs notified AGs or PM&C about that?
I'm not sure, and I'll take the detail on notice, I'm not sure who drew attention to the staff in PM&C who prepare the AAOs in draft as to whether indeed it's an oversight. I'm not sure. In my view, on reading it's not an oversight because with the transfer that Senator Scarr was talking about that was given effect after the election of law enforcement, laws are enforced in relation to the Criminal Code, whether they are virtual or physical.
But why didn't it happen on 1 June then?
I have no idea, and you'll need to, respectfully, Senator, I'd ask you to raise that, take that up with the Prime Minister and Cabinet. They manage the AAO process.
We can do that, but I will look forward to your answer on notice about whether anyone at Home Affairs notified anyone at AGs or PM&C about the fact that cybercrime remained a responsibility for the Minister of Cybersecurity when it should not have been.
I'll look at the detail about whether any of my officers were involved in those discussions.
Thank you.
Thanks, Senator.
Thank you, Chair.
Thank you.
Thanks. You have no further questions?
We're so close to 5 o'clock, I don't think I should start on another bracket, but I have many further questions under outcome 1.
Well, that concludes today's proceedings. I thank the Minister and the departmental officers for their attendance and Hansard Broadcasting and Secretariat staff. I need to move a motion to accept tabled documents received during the day, if I can get support from that. Thank you, Deputy Chair. Senators are reminded that written questions on notice should be provided to the Secretariat by 5 p.m, Friday the 18th of November 2022. The hearing is now adjourned.